1616 VCL Margaret has no sound.
Correct.
But the video from 6200 Hollywood Boulevard does.
That's correct.
So you overlap the videos from each location trying to show when the shot would have occurred during the 1616 VCL Margaret.
Correct.
Of course, if we agree on this already, if your overlap is off even by a fraction of a second, the shot would not have occurred during the precise moment shown on the overlap 1616 VCL Margaret.
That's correct.
And in order to determine when the overlap of the drawing, in order to determine when to overlap the shot heard on the 6200 Hollywood Boulevard video with the 1616 VCL Mar video, you need to first figure out when that shot took place in relation to the 1616 VCL Mar video.
Yes.
So you use a visual benchmark for both videos, something that you could see in the surveillance videos from 1616 VCL Mar and 6200 Hollywood Boulevard.
Correct.
And that was the floodlight turning on.
Yes.
And you saw the floodlight turning on in camera 2, and just to be clear, camera 2 is file. The file number, I think, based on these filings, was file 18221-716 from 6200 Hollywood Boulevard at 10:17 and 26 seconds.
I believe that's correct.
Now, but even seeing that floodlight in both videos, there would have been only two ways to use that benchmark to determine when to overlap the 1616 VCL Mar video and the 6200 Hollywood Boulevard video at the early moment when the shot would have occurred in the 1616 VCL Mar video, correct?
I'm sorry, sir.
Yeah, I got to do it one again.
I didn't understand.
A lot of words in that question, but I'm going to try.
Yes.
I'm still learning what I was asking. But even seeing that floodlight in both videos, when we just discussed that benchmark, that floodlight going on, right? Okay.
Is that yes?
Yes, I'm sorry.
But even seeing that floodlight in both videos, there would have only been two ways to use that benchmark, the floodlight, to determine when to overlap the 1616 VCL Mar video and the 6200 Hollywood Boulevard videos at the earlier moment when the shot would have occurred on the VCL Mar video.
I'm sorry. I think you lost me, sir.
So the two videos, again, the benchmark for that was floodlight.
Correct. One of them benchmarks, yes.
What did you use to determine when to overlap the 1616 VCL Mar video and the 6200 Hollywood Boulevard video?
Again, it was just the totality of the videos, looking at the sequence of the floodlight, the individuals on the video running from one point of the camera to the other, just kind of looking at it in sequence over and over. Everything seemed to coincide with the sound from the 6200 camera.
Okay. Correct me if I'm wrong, I think there's two methods, and tell me if you use one of these two. One would have been to rewind both videos simultaneously to the exact moment, right? Or, let me rephrase that, to rewind both videos, 6200, 1616, simultaneously the exact amount, 30 seconds, for example, right? Would that be one way?
That would be one way. I mean, anticipating that each individual camera system sometimes has its own time. It doesn't mean they're all automatically set at the first exact second or coincide with each other. But again, roughly looking at the light with the individual persons on those cameras, watching them in sequence, it's the best way I can explain it to you.
Okay. And the other way would have been to determine how much actual time passed on the 6200 Hollywood Boulevard video between the floodlight and the shot heard, and then use that same actual amount of time to rewind the 1616 VCL Mar video, right?
Yes, roughly.
Which of those two methodologies did you use?
I think we explored every option, just to try to gauge the best possible, but I can't tell you which one I believe was more accurate than the other. Again, I just looked at the totality of all these things to see that they coincided.
Well, my question really more is, which one did you use? How did you do it?
I mean, I looked at both, but I think the one that stood out more to me was, I think, the light, the floodlight.
I understand that, but I'm saying you rewind both videos, the 6200 and the 1616, to the exact same amount.
I don't recall whether we were running to the exact second, but to the point where it coincided with the sound. And so, yes, I mean, to answer your question directly, roughly, yes, about the same time.
Oh, there was been once. Okay. I'm going to play you a couple of clips. I'm not sure that we're ready, but when creating the sequence surveillance video, it wasn't an exact science, right?
No.
Okay. Meaning the overlapping was done by hand, right?
Correct.
In fact, I think that 55 seconds into the sequence surveillance video, you could see that little cursor being moved by hand in the upper right corner. Did you see that?
I don't recall that.
All right, we'll show you that.
Sure.
Which exhibit is this?
Is this People's 15 or we're using our own? This is People's 15 already. We'll use this one for this.
Fifteen was thumb drive.
Okay, just switch it then. Use it.
I'm just saying it's 15 then.
That's fine, we downloaded it.
We're using 15 now. Anyway, once we get all this figured out here, at 55 seconds on that video, you're going to see hopefully. See if you can look in the upper right-hand corner, and you can see that little cursor being moved by hand. The upper right hand at 55 seconds.
Okay.
See that? See the cursor?
I do.
Okay. See those balls over there, those little round things? Did you see it moving around?
Yes, sir.
Okay. So that means obviously it's being moved by hand, by someone.
That would give me an indication that it is.
Right. And as you said, you saw the floodlight turn on in camera 2, which again I'll re-identify as file 18221-716 from 6200 Hollywood Boulevard at 10/17/26.
Okay.
And you heard the first shot on camera 2, different file number, which is 182220214, at an earlier moment, which you believe to be 30 seconds earlier based on the timestamps. Correct?
I'm sorry, I'm not sure I understand your question. The two shots in different.
No. The first shot on camera 2, which was filed called 182220214. That's the name of the file number that I have to identify.
Okay.
You heard the first shot on camera 2 at an earlier moment, which you believe to be 30 seconds earlier based on the timestamps, right?
Correct.
So you figured the first shot would have occurred 30 seconds earlier in that same surveillance video in actual time.
Sir, I'm not
Okay.
understanding your question.
Did you, well, you agree that you said you went back 30 seconds, or 30 seconds earlier is when you heard that first shot, right?
Again, in comparison to the videos, as far as what the times they reflect.
Oh,
Yes.
and that's 30 seconds earlier than what the first, what camera 2 showed?
Correct.
All right. And you use that same exact amount of time, 30 seconds, to go back on the 1616 piece of film video.
I believe so.
You'd agree if the floodlight turned on less than 30 seconds in actual time, after the shot was heard on the 6200 Hollywood Boulevard video, that means you went back too far on the piece of film video, right? If the floodlight turned on less than 30 seconds.
Again, sir, this is, I mean, it wasn't an exact science,
Well,
but,
I'm not criticizing.
so I'm not sure about the exact seconds that you're pointing out. So
Well, again, you just
roughly, yes.
right, what I'm saying is you just said you went back 30 seconds early based on the timestamps and what you observed.
Correct, just roughly within that period.
And, right. So my question was, and again, I'm not criticizing your methodology, I'm just asking. If the floodlight turned on less than 30 seconds in actual time after the shot was heard on the 6200 Hollywood Boulevard video, that means that if you went back 30 seconds, that would be a little too far, right?
Could be, yes.
With regard to the 6200 Hollywood Boulevard video, you extracted 3 sets of videos from 3 different cameras maintained by the residents at that location.
Correct, that was what was provided.
And to your understanding, those cameras run in actual time.
Yes, live,
But each camera, I think we've already discussed this last time we were here the other day. In fact, each camera is off from actual time by a different amount, between 2 to 3 minutes.
I'm not sure if it's that camera that was off.
Because it misstates the stipulation.
What's the stipulation?
Okay.
Reread it.
Equals 35, remember?
Go over it with Mr. Steele.
You want to
They want to approach, we do that.
You've heard me clarify something. You're on. All right, this does not need to be on the record. Come on up.
Let's go. Right video. Yeah. Okay, let's just do this. Let's just play these a few videos for you, okay?
Okay.
The first video, and this is again, I want to show you about the timing. Is camera 1, which is file 18220-237. You hear the first shot at 10:15:53. Tell me if you agree with that. Go ahead. Okay.
That's correct.
All right, okay. That's it. So you heard the first shot on that camera at 10:15:53.
Yes, sir.
Okay. Now I'm going to play camera 2, which I'm going to identify again by file number, which is 18220214. And you hear the same first shot just over a minute later on this camera at 10:16:56. Tell me if you agree with that after this. There.
Yes, sir.
Okay. So that was 10:16:56 on that camera, which is over a minute later from the first camera.
Correct.
And on the third camera, which is file 1A221240, you hear, hold on a second, right? You hear that same first shot 4 seconds after that last video at 10:17 on the dot. Tell me if you agree.
Yes, I do.
Okay. So a reason that the times would be off from each other is because at least 2 of the clocks are running faster than the other.
That could be a reason. Yes, independent systems.
And a reason that a timestamp on a camera would be faster than actual time is because the clock for that camera would be running faster than actual time.
Yes, sir. Just like here in the courtroom.
Good example, just like here in the court. With that in mind, let's look at one more. Let's look at video from camera 2, just before the flow light goes off. And now I think the defense is we're going to show, right?
DD.
DD, Your Honor. This is from 6200 Hollywood Boulevard. Again, I read the file number. I'll read it again. It's 18221716. The first, before you play, hold on a second. The first timestamp shown on this camera is 10:17:17.
That's correct.
Okay. And the video itself is at 0 seconds because, hold on a second. I just want to make sure we're in the same video here. We do have, in fact, the same video. Okay. So I think you just agreed the video itself is at 0 seconds because it has not started yet, correct, sir?
That's correct.
10:17 and 17 seconds.
Yes, sir. On the clock, lower clock.
All right, let's play the video until the floodlight is on. 9 seconds later at 10:17:26. Go ahead, please. Okay, you see that?
Yes.
Floodlight on?
Correct.
I'm sorry?
Yes,
Okay. And it says 10:17:26.
it does.
And how many seconds faster than, how many seconds later from 10:17:17 is that?
9 seconds.
9 seconds. Yeah, how many seconds right off the clock?
8.
So that's something's wrong there, right?
Yes, I mean,
Okay.
whether or not it would stop right at 8, 8:29, I don't know how to explain it.
Well, okay. The clock's at, so it's 17 10, 17, 26 seconds, which is 9 seconds after 10, 17, 17 seconds. But the video only ran 8 seconds, you can see that, correct? And the floodlight isn't back on, right?
That's correct.
So this would indicate, at least here, that the video is about 1 second past here.
Could be within 1 second, correct?
Yeah. And given that, it's fair to say that the shot heard on 1616 East Del Mar should have been about a second later than shown in the sequence surveillance video, right?
It's certainly not my area of expertise as far as the way sound travels and light travels. I know they travel at different speeds, but that would be within my expertise. But that's correct.
Okay, that's correct. You put this together, the sequence surveillance video, right?
No.
Who did?
I believe it was somebody in the district attorney's office.
Okay. Off of this stuff now. Just 2 more things, and we're done. Now you can. You earlier testified about the police officers who arrived at the scene on November 6th, 2021. Remember those 7 officers?
Yes, I do.
They were there for approximately 20 minutes, more or less.
I think more or less.
20 minutes, yes. Okay. And one last thing, you submitted, I guess, in January of 2024, evidence to the ballistics lab for testing in this case, right?
Thereabouts, yes.
And the testing was done, oh, I'm sorry, it was done it was submitted in December of 2023, right?
I believe that's correct.
I could just refresh.
I believe when the return came back, it was a different date than when it was submitted.
You're right. Just take a look, make sure. Same dates.
Yes, sir.
So that report was, I guess, finalized in January 8th, 2024.
That's correct.
And that was given back to you, this report?
Yes, it was submitted to myself and one of my partners.
But yet, that report was not given to the district attorney until about 2 weeks ago, for the first time, correct?
Yes, that's my understanding.
Over a year since the report was given back to you or one of your partners.
Correct, that's my understanding, yes, sir. I believe it had been given, but I could be in error. Correct.
Well, obviously, the district attorney represented that they got it for the first time 2 weeks ago.
Correct.
The DA, was the DA even informed of its existence, do you know?
I'm sorry, what point?
Yeah, at this point, it's going to be a 3-2 court step.
That's it. Okay, thank you for your time.
Sir, motion strike whatever answer was given. I don't know, was there an answer?
I don't think you gave an answer.
The question is stricken, and if there was an answer, that's stricken as well.
So
Mr.
the last question, correct?
The last question? Yes.
Thank you.
Mr. Zolman, do you have anything?
I do, Your Honor.
Okay, go ahead.
Detective, when you were testifying, I believe that was on Tuesday,
Yes, sir.
you were asked questions about the latent fingerprint examination of the prior cartridge cases in this case. Do you remember that?
Yes.
And as a detective, you said you have almost 30 years of experience as a police officer, correct?
Just passed my 29th anniversary. Yes.
Okay. If I round you up to 1 year, we call it just approximately 30 years.
I appreciate it.
Fair? Okay. Do you have an understanding of what could potentially impact whether or not you would find a fingerprint on any kind of object?
Yes.
What are some of the factors that you're aware of?
Time in which it was processed, the exposure to the elements, rain, water, foot traffic, cars, depending on where it's at, wind, other weather events, I mean, anything, other people going through the area or touching vehicles. I mean, it just depends on where the item is going to be processed with conditions it's found in and how long it's exposed to those conditions.
What about temperature? Is that one of the things that would be potentially affected?
Yes.
Objection to leading.
Would exposure of a fingerprint to something of high temperature potentially impact whether or not it's able to be located later?
I think so.
You also said that you've had extensive experience firing firearms, throughout your law enforcement career, correct?
Yes.
When a gun discharges a fired cartridge casing, when it first comes out of the gun, is it hot?
Yes, on a semiautomatic specifically, when it ejects the cartridges, just from personal experience, I've had them land on me. When we go to the police academy to shoot a qualified, we're on a line. So oftentimes the casings are ejected as the next person next to you is firing. So I've many times felt that the casing landed in my neck or in my collar area. They're hot.
In your nearly 30 years of experience, and 29 years of experience as a police officer, can you personally recall any cases of yours where fingerprints were developed from a fired cartridge case?
None that I can think of.
And you said you've worked on homicide cases, correct?
Yes, sir.
A fair number of those involve firearms.
A good majority, yes.
Can you give the jury any idea of how many cases you think you've handled over your career?
I mean, between homicide cases or cases involving firearms, as the lead investigator or assisting in investigations, probably to date, I would say probably in excess of 2,000 cases that I've assisted or led.
You were asked similar questions about DNA evidence potentially on the fired cartridge case, correct?
Yes.
And based on your background and experience, do you have any idea of things that could impact whether or not DNA is present on an item?
I mean, along the same lines as fingerprints, exposure to the elements, contamination, anything from human contamination, vehicle, wherever it's exposed to, weather.
Could temperature also potentially impact it as well?
Yes.
In your almost 30 years experience as a police officer, can you personally recall any cases where DNA was developed on a fired cartridge case in later cases?
Not that I can think of.
After the cartridge cases are booked, in your experience as a police officer, can they be made available to the defense if the defense wants to conduct their own independent testing?
Yes.
In this case, could the defense have done their own DNA testing?
Yes.
On cross-examination, you were specifically asked if you observed any video of Mr. Ephron returning to the crime scene the night of this incident. Was there any video in this case that you ever had possession of that was captured after 11:20 p.m., capturing specifically that intersection of Vista Del Mar and Selma?
No.
I want you to assume, for purposes of a hypothetical, that victim in a case returns to a crime scene at 11:45 p.m. Would the video that you recovered that only goes to 11:20, would that video have shown that person's presence at the scene?
No, no.
You were also asked about Mr. Ephron's girlfriend returning to the scene. Assume the same hypothetical that she came back with that individual at 11:20. Would the video that you collected in this case, would it even show her?
At 11:20,
I'm sorry, if she returned with Mr. Ephron at 11:45, the video that only goes up to 11:20 show her.
no.
Okay.
Objection, Your Honor. This is that kind of evidence. It would just mean that they didn't have
Overruled.
the video.
No speaking objections. Overruled.
Okay. On cross-examination.
No, stop. No editorializing by anybody. Ask another question, Mr. President.
Just one moment, Your Honor, trying to organize this. In cross-examination, Mr. Tacopina asked you questions about your prior testimony at the preliminary hearing, and specifically read you a passage regarding whether or not you asked Mr. Ephron if he had firearms back in November of 2021. Do you recall that?
Yes.
Okay. In your testimony prior to that, were you asked,
Page 9.
page 269,
Which
on
volume?
5,
Which volume?
volume 2, Your Honor.
2?
2, yes.
Which? Repeat the page, please.
269. I'm going to first go with 5 to 11, Your Honor.
Can you read the question back?
On cross-examination, Mr. Tacopina asked you questions about your prior testimony at the preliminary hearing and specifically read you a passage regarding whether or not you asked Mr. Ephron if he had firearms back in November of 2021. Do you recall that? Answer, yes. Question, in your testimony prior to that, were you asked? And do you have a page number?
All right. What was the next question you were going to ask?
As you read the question he was asked at line 5, you go through his answer.
That's not a prior inconsistent statement from what he said. Your question was, did he ask Ephron? That's not what this question asked.
Now, I wasn't offering as a prior inconsistent statement.
Why don't you just ask the same question that you asked the preliminary hearing?
Did you ever look to see what firearms were registered to Mr. Ephron
Yes.
at the time of the incident in November of 2021?
Yes.
And what did you discover when you searched for any guns that would be registered to him at that time?
We didn't find any firearms registered to Mr. Ephron.
Okay. Okay. In your nearly 30 years of experience in law enforcement, have you ever conducted an interview with a significant witness in a case and either not recorded your interview or not taken notes and not written a report?
No, not that I can recall ever doing that.
As an investigator, can you tell the jury why you either record your interviews or take notes and then write a report immediately following your interviews?
I like to record because it's 100% accurate. The reports are done generally for our purposes as a summary, kind of as a refresher, to identify key points that were made during the interview. But again, my preference has always been to record because that's always 100% accurate.
Would you ever interview a witness and not record your interview, or not write a report or not take any notes of that interview in your experience as an investigator?
Objection or irrelevance, whether you would or would not.
Make an offer of proof.
Well, but the first question is significant witness, now you're asking any witness.
Okay, I
So,
can,
any witness, that question's irrelevant. The answer would be irrelevant.
sure. Imagine a scenario where you interviewed somebody months prior. Hypothetically, you did not record this interview, you did not write a report, and you did not take any notes. Then months later, you go back and try to summarize what that witness told you. Is that something that and that witness is a significant witness in your case that you're investigating, is that something that a trained police officer such as yourself would ever do?
Objection, Your Honor, cultural speculation.
No.
Why not?
I mean, it's just not accurate. Again, my preference would be to record it, just so it's 100% accurate to go off that for any kind of summary.
Okay, in addition to going off of the summary, if you record your interviews in a case, are those also given to the district attorney?
Yes.
Would those also be given to the defense?
Yes, and no.
Would anyone involved in the case then have the opportunity to hear verbatim what questions you asked and what the answers were that were given?
Correct.
Likewise, if you record your interviews, you said after you conduct an interview that you will summarize your interview in a police report, correct?
Yes. Typically in a police report or as part of the case, yes.
In this case specifically, did you speak to Mr. Ephron the day that you were assigned to this case?
Yes, on the November 9th of 2021, yes.
And did you record your interview with him in any way?
Yes, that was recorded, but it included myself, Detective Camacho, Detective Menifee.
Understood, but when you say it was recorded, was it an audio recording?
That was an audio recording because it was a telephonic interview.
And did the audio recording capture your voice and his voice?
It did.
Okay. When you later went back and, or not you, or when your partner, I believe you said, went back and summarized that interview, summarized it into a report, correct?
Correct.
And I believe that you testified that there were a few sentences in the report that had some inaccuracies, correct?
That is correct.
But that was the inaccuracies in the report, not, those were not things that Mr. Ephron specifically said in the report. Were those inaccuracies in the report, or were those things that Mr. Ephron said to you in the report?
There were inaccuracies in the report. Summary.
Okay. I believe you were specifically asked about whether after the shooting, Mr. Ephron contacted an attorney before he returned to the scene to recover the gun casings located at Selma and Vista Del Mar. Do you recall that?
Yes.
And did Mr. Ephron ever make that statement to you that he did things in that order?
That is not my recollection.
If Mr. Ephron testified that he first collected the cartridge cases and then he contacted an attorney, did he ever tell you anything directly contradictory to that?
I'm sorry, I don't understand.
Yeah.
that
Did
question.
he, if Mr. Ephron testified that he first went to the scene and collected the cartridge cases and he contacted an attorney at some point after that, did he ever say anything to you that was different from that order?
No.
I believe you were also asked about the line in a report in which it was written that Mr. Ephron said that Hills had a knife. Do you recall that?
Yes, I do.
Did Mr. Ephron ever make that statement to you?
No.
Was that just an inaccuracy in the summary of the report?
That's correct. It was an inaccuracy.
When you were also asked if you, that essentially you knew that there was that inaccuracy in the report prior to your testimony today, correct?
Correct.
And you were asked if you ever went back to correct that police report, correct?
Correct.
Did you testify under oath at a prior hearing in November 2023 at the preliminary hearing to that inaccuracy?
Yes, I do.
So did you tell the court, the DA, and the defense that that line in your report that Hills had a knife was not correct?
That's correct.
Has Mr. Ephron ever identified anybody else other than Mr. Phillips, who we've been calling ASAP 12B, as the person with the knife outside of the parking lot?
No.
On cross-examination, a little bit on Tuesday and into today, I believe mostly on Tuesday, you were asked about whether you reviewed individual videos, and based upon those individual videos, you could tell certain characteristics about the gun. Do you recall that?
Yes.
When you review evidence to determine something like whether a gun is operable, if you have multiple videos, do you view those videos individually to make that determination, or do you view them collectively to make that determination?
Collectively, obviously, look at them individually, look at them as a whole, and obviously try to put them in sequence with events collectively.
Okay. And I believe you said when you reviewed the video from the parking structure, that individual video, you couldn't say it was an operable gun, correct?
Correct.
But when you review the video collectively, is it your belief that the gun that we see in the defendant's hand was operable?
Objection to leading.
It is.
When you viewed the videos collectively, what was your opinion regarding whether the gun was operational?
That it was an operational firearm.
How did you come to that determination?
I mean, in the totality of the circumstances, the first view of the weapon, followed by the second view, the reaction to the incident as the four individuals in the distance in the camera were scrambling, as you can see that something's going on, in conjunction with the sounds of the shots heard from the other camera, and then the fluidity of everybody running through the cameras over to El Centro. That along the lines with the information provided by Mr. Ephron, that was my opinion that it was an operable firearm and shots had been fired.
Okay. When you reviewed the sequenced surveillance video, were you reviewing whether or not they were sequenced? What were you using to determine whether they were sequenced accurately?
The totality, just the movements of the individuals in the cameras, again, along with pieces of lights, but a lot of it has to do just with the sequence of events, walking around from one side to the next, and just kind of following the individuals in the video, and obviously in conjunction with the sound. So it sounds more biblical than it is, but it's just kind of collectively putting it all together and watching it.
Okay, from what you were just describing, it sounded like you were using audio and visual cues in the videos, correct?
Yes.
Did you specifically use the timestamps in order to determine if they were sequenced correctly?
No, not exactly. Obviously, I understand from collecting a lot of videos, in a lot of cases that individual surveillance cameras systems are all different, and they all can be off by seconds, hours, depending on how they're maintained and kept and updated. So again, a lot of it has to do with just kind of finding certain markers within whatever crime or whatever we're looking for at the time to try to kind of establish what happened. When you're dealing with more than one camera that captures different points of view from different areas.
Okay, when you collect the video in your cases and you're checking the timestamps for accuracy, are you checking it down to the fraction of a second?
I mean, it's captured, and we take that into account and try to determine how far off it may have been. Again, the other factors include that we can't control the maintenance of it, it's been updated when it's in service.
But to the fraction of a second, that's what you're checking, or are you checking minutes, hours, things like that?
Generally checking minutes, hours, and events captured that coincide with other markers that we do have, whether it's from another camera or a witness or something else that kind of puts us in that right time frame that we're looking for.
As to the videos from the residents on Del Mar, the one that had the audio, counsel kept using the word rewind. Were those physical tapes that you or your partners collected, or was that digital video?
the camera from 6200, the residential is all digital.
Were any of the surveillance cameras in this case captured on manual analog tape, or were they all digital recording?
Now they all have been computer digital.
Okay. At the beginning of his questions of you, Mr. Tacopina asked you about whether or not you had spoken to 12. Do you recall that?
Yes.
Do you know for a fact that 12E, to this day, still refuses to be interviewed by law enforcement?
Objection, that assumes a fact, not supposed to be.
No, no speaking objections. It's the objection sustained. Ask another question.
To this day, have you been able to interview 12E?
No.
Have you ever been present when 12E was asked if he would agree to an interview?
Yes.
And what was his answer when asked if he would agree to an interview by law enforcement?
No.
Similarly, you were asked about whether or not you'd talked to Mr. Levin. Did you have any indication that before January 20th of 2025, the day before jury selection, that Mr. Levin had any role in this case?
No, not any direct role, no.
Once you were made aware of that he could possibly have anything to say, did you take any efforts to try to interview him or talk to him?
Yes.
Were you successful in those efforts?
No.
Have you been present when Mr. Levin was also present and asked if he would specifically agree to be interviewed by law enforcement?
Yes.
And what was his answer to that question?
No.
As to both 12E and Mr. Levin, did those questions as to whether or not they would agree to an interview with law enforcement, did those occur in this courtroom?
Yes.
Did you or your partners attempt to speak to Mr. Mayers to defend?
Yes.
And were you or your partners successful in that effort?
No.
All right, Your Honor, I don't have anything.
Tacopina?
Yes, just briefly, Mark. Because we're almost done. You asked a bunch of questions by Mr. Sloan just now about a host of inaccuracies on fairly significant issues in
Your Honor,
your reports.
the question is argumentative in itself. It's statement of access, not an evidence.
Okay. I agree.
Just a minute. Just a minute.
Mark?
I don't believe that the question is argumentative.
It assumes that's not an evidence as well, Your Honor. And the question you read back,
Read the question back.
Detective, we're almost done. You were asked a bunch of questions by Mr. Preslovic just now about a host of inaccuracies on fairly significant issues in your reports.
Let's vague.
Okay. You asked questions about, let's generalize it first, inaccuracies in police reports, right?
Correct.
Okay. One of those, for example, were who had the knife, right?
Yes.
That's a significant issue, isn't it?
Yes, in the report, yes.
One was whether Mr. Ephron was instructed by his attorney to go back to the scene and pick up the shell casings or not. That's a significant issue, isn't it?
Correct.
Okay. And those two issues in the reports were inaccurate, correct, according to you.
Yes.
And those could have been corrected at some point, right?
Yes, they could.
They never were they?
I mean, as far as generating a new report, other than what's been explained in court, no.
Right. So the reports today are still inaccurate on those issues.
Correct.
You were asked about one other thing. Let's start with this. 12. You were asked if you would agree interview, 12 would agree to be interviewed by you, and you said, he said, no, he wouldn't. Are you referring to, correct, sir?
Yes,
Are you referring to 2 weeks ago in court here?
yes,
Is that the first time you tried to interview him?
yes,
So, in January of 2025 is the first time you tried to interview 12B about an incident that occurred in November 6th of 2021, correct?
correct. Me personally, yes,
How about anyone else from your police department?
yes. No, that would
No.
be the first one, correct.
Now, you were then asked questions about whether the firearm was operational. Remember those questions just now?
Yes, sir.
You testified already on cross-examination that the video from the garage, you can't indicate if that's an operational firearm or not, correct?
Correct.
You testified on Tuesday that the video from 1616 Visa Del Mar, that from that video you said, that video alone, there's no evidence of a shooting, correct?
That video alone, no.
Correct. But then you said the totality of the circumstances lead you to believe that the firearm was operational, remember just now?
Yes, sir.
Okay. And the totality of the circumstances is Relli's testimony.
The physical evidence, the video, collectively, yes.
Well, the video, you just said both videos don't add to the fact that it's operational or not.
Collectively, it's as a whole, not the two that you just cited, but in the entirety of all the videos involved, yes.
Well, which video shows you the firearm was operational? Which video?
Sir, as you put them together with the sound, with the sequence of events, along with the physical evidence and the statement from Mr. Ephron, that is just my opinion, that it is operational, and that's why I believe it.
Well, take out Mr. Ephron for 1 second, because he's the one who recovered shell casings, right?
Yes,
And he's the one who gives you the narrative on that video that you can't tell what happened, the 1616.
correct. I mean, as he provides a narrative of the sequence of events, the initial encounter of the gun that was displayed to him, what he believed to be a gun.
All right.
Whether it's operational or not at that point, I can't tell you. But the sequence of event as they evolved to Selma and Vista Del Mar, the cameras there, the incident that took place as far as what I can describe as a scramble during some, obviously, the events that occurred there, what Mr. Ephron described as being shot at was consistent in conjunction with the audio from the cameras. Again, this is just what I'm looking at when I'm trying to rationalize and give my opinion as to why I believe it is the gun that was fired.
I'm sorry, you're done?
Yes, sir.
Take Mr. Relli and Mr. Ephron out of the equation for a second.
Okay.
Take him out of the equation. You don't have Mr. Ephron. And therefore, his shell cases that he remembered, which we talked about the issues with that on Tuesday. Without Mr. Ephron and his narrative or version of events, with those two videos that you said independently, you cannot tell if it's an operable firearm. In the second video, you said you can't see it. There is a firearm.
It's an improper hypothetical which relies on evidence.
The answer would be when more examination. Objections sustained.
You want to use asked his opinion to respond?
No,
Okay, okay.
taking something out of the equation then makes the hypothetical irrelevant. So ask another question.
Is your conclusion based on the fact that Relli's narrative is truthful?
It is consistent up to the point that what he describes occurred based on what I've been able to see in connection with the physical evidence that has been provided.
So let me break it down this way. Video 1 alone, you don't know if the gun is operable.
Correct.
Video 2, that's 1616 pieces of more, or so what? You don't even know if there's a gun based on the video.
Specifically, just looking at that, not looking at anything else, no.
You then hear sounds that appear to be a gunshot, right?
Correct.
Aside from the gun, what else could make those sounds? Not with the gun, I should say.
The sound that I heard off that camera, I mean, I mean, a firearm, some kind of replica firearm potentially, but to state the sound of the firearm, then again, my belief it was a firearm.
Right. Thank you.
Ms. Mazonas, anything?
Would you agree that you don't need Mr. Ephron's truthful testimony in order to determine that a shooting occurred at that location?
Check out.
That, the question was
It's
asked.
a different question. He's asking a different question.
Can I get a question in your hand, please?
Yeah, go ahead.
Would you agree you don't need Mr. Ephron's truthful testimony in order to determine that a shooting occurred at that location?
That's so taking him out of the equation. That's number one. Number two, it's leading. It's leading us to me.
Yeah, the court's ruling, we're getting more speaking objections.
I'm stating my words.
So to not move around other speech.
Read the question again.
Would you agree you don't need Mr. Ephron's truthful testimony in order to determine that a shooting occurred at that location?
It would be a proper question if the question ended with occurred. But when you say at that location, then I believe that calls for speculation.
Would you agree that you don't need Mr. Ephron's truthful testimony to establish a shooting occurred?
Yes.
I don't have any answer.
I do now. So, without Mr. Ephron's truthful testimony, what leads you to believe a shooting without Mr. Ephron's truthful testimony? So I guess he's now out of the equation. What would lead you to believe a shooting occurred?
Again, just looking at the video, the first incident where guns displayed, he obviously follows through with a scramble, as you can best describe.
That's not.
Yes, sir.
You need to answer questions, ask questions.
You asked a question, let's finish.
Okay, so.
So again, it just comes down to, sir, is looking at everything in combination, even without Mr. Ephron's statement. If I were an investigating officer just responding to investigate a shooting scene where maybe there was some evidence found and establishing what had occurred without a potential witness, would be to obviously look at the same video, listen to the same sound of gunfire. Again, it's just factors that would be known at the time. But it would still lead me to believe that there had been some actual shooting short of a recording witness being present. I would still believe that.
Okay. So you first cited the fact that the gun was displayed. That was the first thing you just cited, right?
Correct.
Which you already told the jury. The gun that was displayed, the only time you could see a gun in any video was the parking garage gun.
Correct.
You already told the jury, by that video, you can't tell the top of it, right?
Correct, because it was not fired at that point.
Well, you also said the sound could also have been made by a non-operable firearm. You just said that before.
Again, it's in the realm of possibilities.
Okay.
From what I've heard, again, based on the sound, again, this is just my opinion, my expertise, and my experience. I believe it to be a firearm.
You also heard, you were here when the police officer's body cam from the scene was played, right?
Yes, sir.
And you heard the police officer say there's no evidence of a shooting here. You heard that, right?
Yes, sir.
Okay.
No, Your Honor.
All right, thank you, Detective Flores. You can step down. Next witness.
My next witness is Mr. Ryan, Your Honor.
The last witness.
It is.
I'm giving you very start towards that 3 hours. We are certainly going to be in court in the jury. We're sort of starting at 1:30 instead of the.
No, sorry.
I'm just letting the court know.
No, 15 minutes left. Let's use it.
Trying to make a lunch line out here.
Just raise your right hand for us, please. Thank you. You solemnly state that the testimony you may give is cause nothing before this court. Should be the truth, the whole truth, and nothing but the truth so help God.
I do.
Would you please take a seat on the witness stand there?
Thank you.
Please state and spell your name for the record.
My name is Fadil Birayma. First name Fadil. Last name Birayamah.
Thank you.
Sir, would you tell the jury who you work for?
Yes, we're the Los Angeles Police Department Forensic Science Division.
And how long have you worked for LAPD?
Just shy of 20 years.
Are you a police officer?
No.
Where do you work within LAPD?
So I'm a civilian employee. I'm a criminalist employed at the Forensic Science Division, essentially the crime lab.
Is the laboratory that you work in an accredited lab?
It is.
And what's your job title at the laboratory?
I'm a criminalist 3.
How long specifically have you been a criminalist for?
For 19 years, almost 20.
The entire time that you worked?
Yes.
What unit are you currently assigned to within the lab?
Within the lab, I've actually just recently been assigned to the toxicology unit. It's a very recent assignment. I've been in firearms for about the 20 years prior to that.
Okay. You say very recent. When was that transfer made?
January 13th.
Of this year?
Yes.
Okay. Your entire time before that, you said you worked in the firearm analysis unit?
Correct.
Okay. Can you give the jury just a broad idea of what your job duties entail when you worked in the firearm analysis unit?
So a criminalist in the firearms unit, we are primarily trained to perform work within the laboratory. That's where we spend most of our time. We perform the analysis of firearms and firearm-related evidence. This is the type of analysis that's commonly referred to as ballistic comparison. We call it firearm identification. In addition to this, we respond to the field in order to process crime scenes, particularly shooting scenes and officer-involved shootings are our main field obligations. We generate reports regarding these analyses and testify about them in court.
When you're specifically analyzing firearms and firearm-related components, can you give the jury an idea of what some of those items are that you're looking at?
Yes, so we are trained in the operation and structure of a wide range of different firearms. A firearm for us is a device that propels a projectile by means of combustion. So this wouldn't really include airsoft guns, things of that nature. But firearms, which actually fire live cartridges or ammunition, during the discharge process, they will actually cause marks to be impressed onto those ammunition components. So this is a large part of our responsibilities, is to perform the microscopic comparison of fired ammunition components. These could be bullets or cartridge cases, with the aim of determining what types of firearms they might be compatible with, or actually continuing to determine whether 2 items have been fired in the same firearm or were eliminated as having been fired in the same firearm.
Can you tell the jury about your educational background, any training or experience that you have that qualifies you to perform those functions that you just described in the lab, comparing firearms and firearm-related components?
Yes, well, entry-level criminalists have a natural chemistry, natural science background. I have a degree in biochemistry. This prepares you for most of the work in the crime lab, but to perform the analyses in the firearm analysis unit, we complete another lengthy training program. This is the firearm examiner training program. It has a duration of about 2.5 years. It includes lecture, literature review, and live fire exercises. By these means, we learn about the structure and function of ammunition. We learned to operate a wide range of different firearms. And we actually spent about an 18-month period training on microscopes in order to perform the comparison of discharge fire components. I completed that training program in 2009. I spent the following decade as a full-time firearm examiner. Each year of that period, I was tested by an outside firm in order to maintain my qualification. I am also certified by the Association of Firearm and Toolmark Examiners. This is the premier professional organization in my field, certified in the area of firearm examination and identification. In the course of my work there, I've performed the examination of more than 3,600 items of evidence, logged more than 600 hours in the processing of crime scenes, and about 6 years ago I advanced to the position of Criminals 3. So in addition to the duties I've described, I also do training of other firearm examiners. I work on special projects and research for the firearm analysis.
Do you continue to attend professional organization meetings to maintain your proficiency in firearm analysis?
Yes, during that period, we, under our accreditation requirements, it's encouraged for us to have continuing education. So I've completed, I believe, about 575 hours of additional coursework outside of the actual department. This includes workshops and training from some of the leading professionals in my industry, as well as certain agencies such as the California Criminalistics Institute, which is operated by the California Department of Justice.
You mentioned that you were tested by an outside vendor, outside of LAD, right?
Yes.
Are those commonly called proficiency tests?
Yes.
And are they required to maintain your accreditation?
Yes, the lab is accredited, and requirements for that, you must participate in proficiency testing by approved vendors outside of our actual agency.
And are those tests graded? Those proficiency tests?
Yes, they're evaluated.
And have you successfully completed them?
Yes.
Approximately how many times do you think you've testified in court about firearm and toolmark identification?
I'd say over 60 times. I testified around 75 times in total, but that includes testifying about field work as well.
Okay. In a general sense, what was let's start with, you were assigned as a criminalist in this case, correct?
Yes.
And what was the task that you were assigned to complete specifically related to this case?
I was tasked with the analysis of two ammunition components. These are cartridge cases, discharged cartridge cases, for a type of examination that we call type and caliber determination.
Your Honor, I'm going to move into a different area. Do you want me to start with that?
Well,
Or?
it's close enough. We'll break that.
Sure. We put it on time for a second, before you go through it, come back.
Okay.
But now we're going to move on to the case of, that case. They think the case of A$AP Rocky, Michael, and you would think that, let's see, we have a dismissal, directed verdict in Georgia. We have a not guilty here in Massachusetts. And now we're back to A$AP Rocky, where Joe Tacopina tomorrow will continue his cross-examination of the case agent, who seems to have made their case for them. Let me just remind you where we are before we bring Neil Rockin back in. Rockin' Neil, who co-hosted Rockin' Coast. You were Rockin' when he coasted the other night. And he was talking the shell casings, right? We've got the shell casings.
Shells or anybody else. And again, don't look at the internet or any print media. No electronic media. Please continue to keep an open mind about this case. We'll see you at 1:35.
Okay. They're going to lunch in the case. The A$AP Rocky, I should say. I mean, they went a little faster than I thought. Took me a second because I was all wired up when they were going to take a break about 15 minutes ago. And then the judge said, we have 15 minutes to go. Why are we breaking early? Let's use the time. So thanks all for being on with us. This is my area now. But before we get to who's on the stand right now, and Ms. Shorty, are you still here? I mean, because I really want to thank you for those memberships you gave us earlier today. And we love our OC friends, as you know. We absolutely love it. Hopefully I shared it on X that, yes, you gifted 5 memberships, shared it on X earlier that would be on. Waiting for Michael Bryant. We'll see if he's going to come on. I don't know. Last time I saw him, he was felling a tree. All right. But yeah, the right now we do have on the stand the firearms examiner. Let's see what's happening here for a second as they go to lunch.
And the questions involve video during my full counsel's the question involved whether or not there was video.
Sound is pretty bad, I know.
Was available that would have shown the witness and his girlfriend had that given the time that was involved. Right. The court indicated that they showed up after the video stopped. Right. Mr. Siegel said the court sustained objection, but I believe I heard Mr. Siegel say that doesn't mean they didn't have the video. Now, if listen, right? Yeah, that's not what I said. Okay, so I'll just ask again, because of my 4 hearings, I'm not the best reporter of this, but I just want to ask if the court reporter can check if that line is in there, because if the jury heard that, if I heard it right, and if the jury heard it, that's
Repeat what you think you heard.
I thought I heard him say, in reference, that doesn't mean they didn't have the video. Meaning, in essence, that
I should have known. Maybe I don't even care at this point. What is going on here? I thought we were going to take a lunch early, and I see Mr. Lewin's making objections again. Let's see. Let's listen a little more before I speak. Hi, everybody.
So we had to bring it up after the jury was gone. So I would just ask the question.
So I can understand. The question was, would something, if the video stopped at 11:20, would something that occurred at 11:45 appear on the video that stopped 25 minutes early?
It was during one of those couple of questions involving Mr. Clement. He asked about the victim. He also asked about his girlfriend. I believe it was the question about the girlfriend in the video. And
all right, can you look for that? Was that the question? That wasn't the objection. So can you just look for those words? Thank you. All right. See everybody.
Even the judge gets it. If the video stops at 11:20, something happened at 11:45. It's not going to be on the video. So let me just recap what happened at the end. We came back. Joe Tacopina continued his cross of the case agent, right? As we saw from the other day. Now, then there was a redirect by the prosecution, and the redirect was trying to say, and here's the whole scope of the redirect. Even if he didn't have Mr. Relli, now, even if he didn't have the victim, right? But we have the victim, would you find that there's enough evidence to show a shooting occurred? And what you couldn't move this agent off was, yes, I find that even though in video 1 there's no indication of a shooting, in video 2 there's no indication of shooting, but I am a trained cop and I hear shots. Okay, I hear shots fired in another video, and because of that, because I hear the shots. Given the fact that he came and he reported it. Oh, wait, I'm not supposed to take Mr. Relli. But because I heard the shots, I can say there was a shooting. Now, did Joe Tacopina get himself into a little pickle there? Maybe. But the other way he's going to explain it is, you see, these people, the LAPD and then the DA, they don't care who Relli is. They don't care what evidence came before this jury. They don't care what evidence came before them before they went to a grand jury about the bag for $30 million. They don't care, because they are going to say, no matter what, know how bad it is, we believe there was a shooting. We believe in the shooting, even if you take out Relli. Well, let me ask you all, can you take out Relli? Can you really take out Relli, who says that the tape of him asking for the $30 million because he needed a lawyer to get a bag or else it'd be extortion? Can you really take that out of here? Yeah, I mean, really? I mean, it's like why we've been having a trial if we're going to say, well, the LAPD gets on, and we know they've had some issues in the past, and they say we believe there's a shooting, and therefore there is. So I know I saw some questions going on here. Well, let me just have some comments. Tandra Cook, I just don't find any validity in this case. What was the prosecution's smoking gun? I guess the smoking gun would be the last witness who would say, and I don't think it was smoking. I'm not even sure you call it a gun, was that, yeah, I find there's evidence of a shooting here. Even though there's no cartridges, even though there's nothing that indicate from their 7 police officers on the scene that a shooting ever occurred, even though the cop on the scene from LAPD said a shooting, he didn't see any evidence that a shooting occurred, even though Relli didn't return cartridges until he'd gone to New York and New Jersey to fire at a gun range, that he didn't see anything. And now what they're going to do, and I'll tell you what they're going to do right now. They're going to say, remember that report that wasn't turned over until like, what 5 days ago or whatever it was, 25 days ago, but certainly 5 hours before the trial started. They're going to say, well, these cartridges shown that they could be fired by a Glock, and they could be compared to the cartridges found in a magazine case at ASAP Rocky's house. Well, would you all Google how many Glocks there are out there for me? How in the whole world? Just Google it. Then Google in the United States. So maybe when we come back tonight and talk about this case, we could talk about what this witness was going to say. So what? First of all, the idea and I told you it wasn't ballistics. This guy even said, well, it's called ballistics, but it's not. It's firearms comparison. It's actually tool mark identification comparison. All right. By the way, Quan Shaw says, doesn't a prop gun being fired sound like a gun being fired? Yeah, that too. That could be it. I mean, they really, they can't. They couldn't take a Glock to the scene and shoot it and actually have it in the same circumstances that night was. So they can't do any type of sound comparison with these stupid sound machines sometimes they use, right? They can't do that. And as Neil Rockin, and it's Neil Rockine, but I call him Neil Rockin. I've renamed him, given him a new, I guess a handle would be Rockin' Neil, I guess I should call him. Said everybody and their brother would be out there with a something that can find metal detectors, like a metal, right? And no one found anything. No one turned anything into the police, not one thing. And then the witness that they said was that Relli said had witnessed it and supposedly had a weapon. He wasn't even asked to be interviewed until 2 weeks before this trial. And of course, he said no. Why? Because no lawyer in the world was going to allow him to be interviewed. Even if he wanted to be interviewed, no lawyer in the world was going to allow him to be interviewed. Why? First of all, you wouldn't trust the police. We saw what happened in YSL, right? We saw it. You all watched it with us. So do you really think you're going to trust them? So Vayu. I'm sorry, I am not going to even try to pronounce your last name. I think it's Rihanna. But Relli had a story together. He lied so much, even without knowing he was being taped. He needed to tell his story. Yes, absolutely. I mean, he had a story put together because he knew he wanted to get a lawyer and asked for the 30 million. And what was important, remember, Relli said on the stand, well, I called my lawyer, and my lawyer said to go back and look for the cartridges. But between the time that there were the sounds that were emitted, that there was a 911 call, and the time supposedly Relli went back, which turns out he's not in the video, according to police, going back, guess what? There were no calls to his lawyer. And he said what he did then is the next, I think he couldn't keep his story straight. He called his lawyer on the next day, right? And then the lawyer, he said that lawyer told him to go back. But he supposedly to him, he'd already been back. So it just doesn't make any sense. So what this guy is going to say, so let's talk about firearms identification, firearms comparison. If you Google the Aaron Hernandez case in YouTube, there are, I think, 2 days of me, or maybe at least one day of me cross-examining Detective Sergeant Tyrone Camper. In that case, he was from the tool mark identification of the crime lab there, about all the problems. It starts with this little book here. Forensic Science in the United States, A Path Forward. And there is on page 151 and 152 of the tool mark and firearms identification are simply, they weren't, shall we say, meant for prime time right now. That the analysis is really comparative by somebody looking at a microscope and saying, well, these things match. And if I have time, I'll try to pull out the 2 exhibits I used in the Hernandez case and show you there what the officer said matched. And your idea and my idea and maybe officer's idea of a match when there is a case going on, maybe 2 or 3 separate things, because you have to have a measurement certainty, right, on terms of markings. And usually you fire the gun you have, right? You fire the gun you have, and you compare the cartridges that come out of there, the bullets that come out of there, with the bullets or the cartridges you've collected at the scene, depending on what type of gun it is, whether it's a revolver or whether it's an automatic and all. And then you look at those cartridge comparisons, right? And whether it's from ejection, whether it's from going down the barrel of a gun, depending on what you're comparing. And then you measure those, you look at them in a comparative microscope, and you say, oh, they kind of look alike, right? Now, if you found the gun, that you have a gun, and you have a gun that was, you could say, well, yeah, this is pretty good. But they don't even have that. All they're going to do is say, this could be fired from the Glock magazine cartridge that we found in ASAP Rocky's house. They don't even have that. But even when you have that, you have something called a measurement uncertainty, all right? And it's required to have this measurement uncertainty to get certified. And you heard that he talked about accreditation of the lab and accreditation of the individuals. I would like to see his CV that he filed for the accreditation of himself, okay? Because normally we'll have a lot of things in it that you'll see I do with Tyrone Camper about how this is not primetime science yet. All right. And this is even less science when you don't have the gun and you don't have the cartridges filed from the gun. And all you have is what someone says are the cartridge casings from a gun that was fired, right? So there's furrows, there's all sorts of things. And I think I gave you the list the other day. I don't want to bore you because we're not a forensic course. I think I gave you the list the other day. Now I see Michael Bryant is joining me in this conversation. There you go.
Could I have the forensics course, please? Because
I'm going to give you the forensics course
have
back,
my notepad ready to go here.
So the totality of the circumstances, they would not give it up. All right. He was there, and he was there to rehabilitate the case on redirect, that no matter what, they believed, even without Relli, that shots had been fired. Okay. They believed it. And I can see that, as I said, Michael, I don't know if you were listening, I said, well, you can say either Joe got himself into a pickle because that's what they believe, or they're not going to believe anything else, anything, no matter what.
How bad does Relli have to have been that you have a cop come on who's already testified in a way that at best is a break even, to get him to say, let's pretend Relli wasn't even here. Let's pretend he never testified. Let's pretend that this jury didn't hear him lie after lie after lie. Let's just set that aside. You think a shooting took place? A shooting? when
firing of a gun. He didn't say the firing.
Well, shooting of a gun, firing
the
of a
shooting
gun.
of a gun. Right, right.
So when do we start getting charged with? I know. Should the charge be some sort of discharging a firearm in city limits? Is that what this is about now? I don't know.
Oh, no, Todd
It's
just
just
I
sad.
asked him to look. I'm actually going to take off my final for you. I can't because my microphone's attached to it. We had a snowstorm here in New York, by the way. So this is
I
why
sent
I'm
you my
off.
little video, but I guess you didn't have a chance to look at it because
I didn't have a chance.
I was
didn't
out
have a chance.
plowing.
I will. You were plowing.
I was out plowing.
Yeah, it's been pretty wild here in New York City.
It's kind of.
But Tandra Cook said Glock more than 50 times more than 20 million have been sold here. Is that here in the United States? Within what period of time? The cops all use Glocks, by the way.
That might just be in LA County.
Oh, in LA County, right?
I'm only being slightly facetious.
Yeah. So I've been blathering about not blathering, but really about how ridiculous it is. No matter what, they're gonna believe him. And then when you know what got me too, Michael, when Joe went up and they said, "Well, can we take Relli out of the equation?" And there was an objection by Lewin. Objection, improper hypothetical. You can't take Relli out of the equation. Then their side got back up and said, taking Relli out of the equation was there a shooting? And Joe got up and said, okay.
It's just so desperate. And this all leads us to that moment we expect to be coming when the prosecution rests and Joey T stands up, says, yes, a matter of law and motion, Your Honor. And then, of course, the jury will be excused. And then the fireworks will begin. And he'll make his motion for directed verdict and he'll argue it. And he's got so much to work with. It's going to be quite fun to watch.
Yeah, I think it's going to be fun to watch. And the judge can come down and say, well, we had the testimony, Detective Flores, who said at the end that he believed there was a shooting, a weapon, I guess, because he didn't say of Relli, right? He never said a shooting of Relli, right? Shooting of a weapon, and that's enough to go to a jury. I mean, the standard is so ridiculous.
Yes, and we know that, and we anticipate that. But I don't know how much worse it can possibly get for the judge to totally ignore the fact that there is no case here. There is no case. Maybe there is a gun that was shot at some point at some time, but there's no evidence of that unless it was a prop gun or some gun without a projectile.
Right.
Because there's been no evidence of any projectile or evidence of any projectile damage that you're probably going to get if you shoot a weapon. And these guys, this is LAPD. They have been involved in a number of shooting investigations, one or two, right? And they know what to find, what to look for, what the indicia of a gunshot into a building, into the ground. Even when you shoot a gun in the air, that projectile does not go up in orbit with an Elon satellite. It comes down. In fact, there's stories, I'm sure you've heard them, where somebody has died from a projectile that was fired in the air, and on the return, boop.
And then there's a manslaughter case, or there's a murder case because you were intending to shoot something else.
Like New Year's, you'll hear that New Year's Eve, people are out just firing off
all the
guns.
time in the country. Not in New York, but in the country, right?
My point is, the projectile comes down, and there's no evidence.
I mean, it doesn't go poof. It doesn't disappear. Go poof.
And it doesn't just join, a Skylab up there and float around with all the other space junk. No. So I just can't wait to hear these arguments. And of course, Lewin is going to be very entertaining as he tries to refute the motion for directed verdict. I just can't wait to hear it.
Well, he kept getting up and telling Paulie P what question to ask in the redirect. And that was,
that's what most second chair do, right? Most second chair attorneys tell the lead attorney how to handle it.
All the time. That's almost so embarrassing. So Miss Shorty's here. She stopped by to say, yes, she gifted 5 memberships to us this morning.
Oh, that was so nice.
Yeah.
I'm still going to try and figure out what time it is there. I think it's like 7 a.m.
Is it 7 a.m.? I thought you were going
to. 7, maybe 8 a.m. I don't know for sure. I thought it was 14, 15, 16 hours, something like that.
Yeah.
We had so many comments on the stuff we posted. When we do a live, we then repost it for later in the day or early the next day.
Right. And I didn't get a chance to go to them because I actually have other work sometimes I had to do. But
I understand. I understand. And well, if I hadn't been the one who cut them and put them back up, I might not have remembered what we were doing either. But the comments, I'm going to fish for a few while we're talking, just because I think there were some great.
So you got it. 7:17 a.m. Friday.
Ah,
yes.
There you
got
go.
it, Michael.
I knew it was close.
You got it. Thank you. You were really on early then today with us. Thank you very much. And we've been thanking you very much. We've been trying to get. We're going to try to do a show with Miss Shorty, as you know. Try to get a time that maybe this is the kind of time that works. Something at 7. I don't know, 7 in the morning.
Yeah, early evening for us.
Maybe noon for her, and then it goes. What would be the time there? It'd be like another 5 hours. It'd be noon for her. We'll figure it out. And, Marissa's going to try to figure it out with the Shorty, so we can try to do a joint show together. Yes,
that'd be fun.
Yeah. And just so you know, tonight, by the way, at 7 p.m. our time, not only we're going to continue this, but we do have our dear friend Doug Weinstein is going to be with us, from YSL, Yak Gotti fame. Hopefully Yak will be out of jail one of these days. He did get a not guilty, and he'll briefly address the Jackie Johnson case yesterday. We talked about, because at least he's in Georgia, he knows Georgia law, and then we had some fun stuff that was happening. We'll have to post it for you later on. You know what? Fonnie Willis is having a party. Did you know that, Michael?
Oh, I did not get my invite. It must have been delayed in the snow or something.
Yeah, she's having a party.
What's the purpose?
Well, because she's now the inaugural gala of the district attorney, Fonnie Willis, because she won re-election on February 13th, 2025. Now, you can go, by the way, even if you don't have an invitation, if you want to donate $25,000,
let me
you
check
can do that.
You
can go VIP tickets to a little $750. We'll try to show it to you afterwards, and maybe I'll post it on my Twitter account. Yeah, you're welcome to go, but if you want to be a Supreme Justice, you have to give $25,000 to be a sponsor of Fonnie Willis's inaugural. I'm sure we'll see if Doug is going to go. We're going to ask Doug tonight.
I'm sure Doug will be there. Max will be there. Brian Steele.
Well, plug that into your asset for tonight, Michael, because that's something that I'm sure they're all going to want to see.
Oh yeah. It's like one of those fancy invites, right? I think I've seen the invite. I just didn't get one. So
yeah, well, we forwarded it to you. Our producers got it for us so that we can use it tonight. And have you all see it. Okay, so what else did you hear? Because I was like, gosh almighty, what are they going to do to rehab him? And that's the only thing they could do to rehab him is, what do you think? What do you think?
I just feel like they're playing out the string, like even they, meaning the prosecution, doesn't have any dreams that this is going to bear fruit, but they're just, they're zealously advocating. I think they obviously should never have begun their advocation for this prosecution, but now that they're in, I think they're just trying to avoid a directed verdict. I think for the prosecution, a hung jury would be a victory. Normally, a hung jury is a loss for the prosecution, but I think for them in this case, it would be a victory. So I think they got this ballistics guy out there he's not ballistics. What did he call himself?
Well, he said he was a firearms comparator, tool mark, commonly known as ballistics, which is what I've been telling you all. That the ballistics is the science of the projectile,
the trajectories
and all that kind of stuff.
Those cool reconstructions we see where they shine a light through something and they show where the path would be. Or back in the day, they would use the rods, right?
Right.
That makes perfect sense. Yeah. Can't do that when you don't have any bullets flying around. All you have are two sounds. You have two sounds.
Yeah, but so if the question was, okay, for all of you, if you take Relli out of the equation, okay, without Relli being there, do you believe, officer, that there was a shooting? Without saying, do you believe, officer, I'm going to get technical here, there was a shooting of Relli by A$AP Rocky. Does that do enough to get them past that directed verdict? I mean, I'd even go there.
Okay, let's say that question is asked. I'd object for lack of foundation, calls for speculation. Because what does he have? What would he have to lay a foundation for that?
He was asked that.
And wasn't it objected to?
Yeah, but it went when Joe asked it. It was objected to. Prosecution came back and asked it. It wasn't. The judge let it go on, And I think Joe wanted it to happen because then he can go back and say, but without Relli, right? What do you mean without Relli? But the question wasn't, and I'm particularizing, the question wasn't, sir, with taking Relli out or without Relli, do you believe there was a shooting of Relli by A$AP Rocky? I mean, to me, that has to be the question, not do you believe there was a shooting?
Yeah, and that gets back to what my original point, which is let's erase Relli from the jury's memory, because that's what you'd have to do for that hypothetical. We don't care what he said, but was there, in fact, based on other evidence in your investigation, a shooting by Rocky of Relli? Can anybody give that opinion credibly?
And they get supported because they try to interview the guy with the knife 2 weeks ago, and he wouldn't give an interview. So because he wouldn't give an interview that supported what they said, that supports that there was a shooting. Am I in Alice in Wonderland?
We're through the looking glass, people, as Costner said in the Kennedy film. Also, I heard bits and pieces of some correction of a report on I think it was redirect of Torres asking about a report that he had made suggesting that somebody had a knife and it had been attributed to the wrong person.
Right.
What was the deal there?
And he said, yes, it was a mistake. Yes, it was a mistake. Yes, it was never corrected. Yes, it was a mistake. And then Joe, that's where Joe got into, well, did you ever try to interview X? No, we didn't try to interview X. Did any from your office try to? No, we didn't. Well, yes, we did. But when was that? It turns out that it was 2 weeks ago. And the prosecution let that, by the way, the prosecution didn't get out that it was 2 weeks ago. They said, yes, we did try to interview it. And he said no. So the implication was he was not cooperating with the police. That's why the police couldn't do their job. But it turns out he was not cooperating with the police 2 weeks ago because they never went all these years to try to interview him. And
was
you know,
the,
as I know, the guy supposedly holding the knife. You and I know that what lawyer is going to let him interview with the police now?
Well, of course. Well, and you know that they asked right at the start of trial, anybody, want to talk? In fact, it included Relli and Justin, who didn't show up in this case, the business partner.
Right.
They were in court to be asked by the judge, hey, anybody here willing to talk? No, we're not.
No.
So yeah, not a surprise.
Because they have something called a Fifth Amendment right. And what is that?
I've heard of that. You can't incriminate yourself. But we also have perjury laws that didn't stop Relli from ramrodding his testimony through. Who's it? Tondra Cook. Yeah, North Carolina, you're firing those pistols in the air. Watch out where those projectiles come down. It happens.
Yeah, we hear them in the Catskills on New Year's Eve or any celebratory 4th of July and all, and I always say, keep make sure the dog is in the house because you don't know what happens with the projectiles because everyone's firing them in the air because we're living in the country where everyone has guns and that's what you do. Well, not me.
You just do that. Yeah.
Not me. I just don't do that. But I prefer to be shopping, as you all know.
Okay, so
yeah. Oh,
so
thank you for calling me glamorous. I actually have my workout clothes on.
Look at this. Even when she's working out, she's glammed.
Thank you.
So what's going to happen now? We're going to have the balance of this guy, whatever he's called.
Yeah.
And then that should be it.
I think that should be it, right? That's going to be it. And then the question is there going to be enough time to do? I have a feeling that this guy's going to take all afternoon after lunch because I know I would. I took almost 2 days or about 5 hours, better part of 2 days with Detective Camper if you do it right. But maybe not. Maybe Joe's going to figure he's on a roll and won't. And then the motions would be tomorrow. And then the defense case, if there is a defense case, would start next week. That's what I feel. I don't even know if you need to put a defense case on.
Yeah, I'm not sure he needs to either. But it depends maybe on how this expert plays out and how the cross-examination of this expert goes.
Right.
And I have to believe there's not a lot to work with in this expert's opinion. It's not like he's going to have 5 or 6 opinions that involve a lot of testing and a lot of analysis. I mean, it's a very finite bit of facts and a lot of missing facts. I can't imagine the cross after he rips them on the key components is going to take all that long. I'm sure, when you were involved with that ballistics case or that expert, it was a much bigger.
Yes, yeah,
case.
I'll try to get the link for the cross, or I'm sure Missy or Dizzy can find it. It was actually Law and Crime. It was the first case that they televised, but they didn't have anybody commenting or anything on it.
Okay, so
And
it's
her
back
name
to
was,
that all things come back full circle.
it's
Yeah.
the most amazing thing. Yeah. First time they televised, and yeah, well, I won't go there. You know where I wanted to go, but I won't go there.
Okay. So what's going to be the
That's a
directed
good
verdict
point.
argument?
Wait, that's going to be a good point.
Even
Law and
shots were
Heard,
fired, they can't prove it was
Law and Heard,
Rocky.
PHL, right?
And how
You
badly
can't
they
prove it.
messed up.
Don't checking the. That's a really good point, right?
Yeah, that's exactly right. I mean, okay, I'll give you that. Shots were fired. Okay,
Yeah.
now where are we?
Oh well, look at this control. I didn't know that him having a prop gun makes sense against Wally because he's passive aggressive. Sonny Liston scared Muhammad Ali also in a casino. I didn't know that. I have to go back and look at that. That's why historical content is so important a lot. And then also you're on this case. I know I can appreciate the conversation with Wally. 5 shots, the conversation with the police, 3 or 4 shots, and only 2 cartridge casings. You know.
That's one of the few things I gave Relli a break on, just because of the nature of what's happening, and it's you're all discombobulated, and somebody is in theory shooting at you. Okay, maybe it was 4, maybe it was 5. Oh, it was only 2. Yeah, that I don't fault him too much.
You know what happens though whenever they say Wally? I think of the movie Wally with the robot. I keep saying Wally. Wally.
I think of Wally World. So we're both in the cinema there.
Well, that's because when you're listening to this case, it's so ridiculous in terms of meeting the burden. A serious case like this should have been seriously, but there's really, I mean, I don't know how if the judge has the kind of sneakers that the judge in the Alec Baldwin case had, this judge should dismiss this case on a directed verdict. But it's
they had the shoe testimony, right? They had some shoe testimony.
Shoe testimony.
Yeah, didn't they have some shoe testimony in this case, or no?
About what?
I thought they had some shoe testimony, not testimony from shoes.
Oh,
but some evidence of potential shoes at the scene. I thought I saw something on that.
I don't remember it. I must have been. Well, look. If somebody mentioned shoes, I just go down and look at mine and I go, I'm kind of not interested in the shoes at this scene. Now, if you were talking about the shoes that's out of the Louboutin store, I'd be doing that. I would notice that the new I guess it's the new AG of the United States, Pam Bondi. She was in the same special I was in when we did. I was in the Casey Anthony special on the other side, and she was wearing red-soled shoes, Louboutins at that point. I think she even wore them. I think she even wore them this time. I'm not sure.
Well,
but
Relli could afford those. No.
Relli
was hoping to afford them.
Relli was hoping to afford those shoes. Relli was broke. Relli was hoping to have a lifestyle in front of the Rolls or the Mercedes? I guess it was a Mercedes.
Oh yeah, was it Maserati? Was there a Maserati?
There may have been a Maserati. I know one was a Mercedes too, and the private jet. I didn't get the name of what type of private jet it was. It was just a private jet. He was hoping to have that because you
gotta have dreams. We have a question here. I know it's not a question. Thanks for gifting the 5 Just to Serve memberships. You guys already talked about this while I was gone?
Yes. Yeah, Miss Shorty did.
Yeah,
she did. Yeah.
Then,
she did.
Then
right off the bat.
Again.
And they've been good. To really thank you very much. I mean, we'll thank all of you very much. And, just great and last night, a lot of you were on talking. We were on and we had 3 different topics last night. We were doing Jackie Johnson. We were doing the Penny McGee case, which was also a not guilty case out of Judge Bev's courtroom. Can we talk about that for a little bit? Do you guys mind? You guys don't mind if we talk just a few minutes?
Shift to Karen Reed a little bit.
Yeah, Karen Reed. Karen Reed was in court this morning. We remember they were supposed to be in court either Thursday or Friday, or Thursday and Friday, or they picked a date. Well, they picked Thursday today, and you knew it was kind of important, even though it was supposed to be a motion just for. And you and I had this discussion earlier by text. It was supposed to be a motion just for her recouping her $12,000 in costs. As soon as I saw that Alan Jackson was there, I think I texted you, oh, that's not just this going on here. And so what happened, Michael?
Well, it really was technically just the motion for the $12,000 and change that the defense wanted back from the state because, the Commonwealth hasn't spent enough money on this case. So they wanted their 12 grand back because they said it was only necessary to hire this expert, fly them out to Massachusetts to look at the magic DVR that sometimes does have video on it of the Sally Port and those areas, and sometimes doesn't. Depends on the time of day and who's finding it. So they wanted this expert to come out and look themselves. And Jackson's point was that, if they hadn't screwed us over, that wouldn't have been necessary. It was something they caused. That was the technical part of the motion. But he spun this, and it really kind of genius the way he did it, because if nothing else, he's foreshadowing for the court what's coming in the motion to dismiss. He talked about all of these various Brady violations, in his opinion, Brady violations about the things related to these videos that have not been turned over, not been preserved, right?
Right.
Even though a formal notice was made twice to preserve this material. And there's kind of an unspoken duty to do that anyway.
Right.
Asking for it formally is just on top of that. And the Commonwealth failed over 3+ years to turn over this material.
Before we get back to that with 3+ years, Ms. Shorty has a question. The question, why, I know she's working, why has this case taken 4 years to go to trial? Is it simply court backlog or, well, let's start with one. It's LA. Everything takes longer. Number two, we did have a pandemic in the kind of, sort of at the end of it. Number three, it does involve, they had another celebrity case going on, Durst, and then they were catching up on the pandemic. So I think that's really what was mounted. And also, it's LA. Everything takes longer. It just takes forever. But
yeah, getting out that's what we call it in California. When you get a courtroom, we call it getting out, because you can have a call to go to court and not get out. And that's especially true in the civil world, because civil world is second to the criminal cases. Criminal cases, constitutional right, speedy trial, and all of that. So, if you're in the civil world there, very few trials get out. But it also, the backlog affects the criminal cases too. And it's also, I think, part of it, the internal issues that might have been going on with Gascon on his way out and doing all kinds of, he was struggling in the last year of his term. And I think it probably just got back burner treatment too.
Yeah. Yeah. Well, maybe because of Relli. I don't know. Maybe I would like to know. I tell you what, when this finishes, I would like to know, was there an internal investigation? Did they have a ethics investigation, or somebody come in to separately evaluate the ethics of going forward on Relli's testimony with his statement on the tape? To that he says is AI, right? That he wanted the bag, the 30 million. And I'm going to go back to it again, because I assume Joe's going to go back to it again, because I would. He needed to get a lawyer to get that bag, because or else it's called extortion. Okay. And I'd like to know if were there internal investigations, were there internal discussions, are there internal memos? I think if there are, I think those are Brady, Michael.
I think you're right, but I'll bet you there aren't, because they were so lax in, we talked about this last night, Relli was clearly never prepped for this trial. And if he was never prepped, if they never spoke to him to the degree, and it doesn't sound like it would have taken much. I could talk to this guy for 15 minutes and tell this is a shaky witness. I don't think any of that was ever done. They had the report, they had this grainy video, a couple of casings. And, let's go forward with it. It's a big, celebrity defendant. Let's do it. So I agree. If they had done that kind of investigation, there would be some evidence of it. I'd just be shocked if they did anything, because he was so bad and so unprepared on the stand.
Well, let me ask you this then. Let me go one step forward. They made a determination. Let's assume, I'm going to hypothetically, okay? Let's assume they were discussing it, but made a determination not to talk to Relli, because if they found out anything different, they'd have to turn it over, or if they put him on the stand knowing there was something different, it'd be suborning perjury. Take that as a next hypothetical.
Yeah, I think objection, incomplete hypothetical. No, I think that that is almost as bad, really, as knowing somebody is going to lie, that you're almost tacitly thinking this person is not truthful. So I don't even want to ask them questions to confirm whether or not they are truthful. I think there's an obligation to not put a witness up there with even the thought that witness might be a liar or not be completely truthful about the facts of a case, especially when it's the witness. right? This is not some peripheral witness, not some precipient. I was walking down the street and I heard a couple of shots fired. I looked, I didn't see anybody. Fine. This is the witness. This is the case. So,
and I don't know, do you remember whether or not, and maybe our viewers remember, I thought the prosecution not promised, but said that there were other people that witnessed this that were going to testify, and that the girlfriend was with Relli when he picked up the cartridges, and she was going to testify. I thought they said that everybody at that location, or at least one or two of them, were going to testify, including the girlfriend. I think they promised that an opening.
at this time in a trial, well, usually I wait a little longer because usually I expect a defense case. I'm not sure there will be one here. But I go back and I listen to the openings to see what they promised and to see, okay, what can I nail them on? If I'm opposing whoever that is,
Right.
what can you heard the prosecution promise you that there'd be witnesses telling you that night they accompanied Relli back to the scene. Where is that video? Where is that proof? Where's that witness? So this is a good time if there's going to be a directed verdict that has a whiff of being granted. Now's a good time to look back at the promises made by the prosecution.
Maybe we should do that over the weekend and see what the prosecution promised. I don't think it was that long of an opening.
It wasn't. Neither one was all that long. Yeah.
Now, Been There says, and Relli said the gun was pulled out by Rocky for self-defense on the phone call with Wally. Absolutely true. It said there, he pulled the gun out, pulled it out for self-defense. So now you have, let me ask you this one. So if he pulls out, whether it's a prop gun or a real gun, once Relli says there was self-defense, and you see Joe kind of went there, I think, in one of the crosses, because when he had Relli, he said, did you grab who by the lapels, right? Didn't you grab him and push him into the back,
pushing,
right?
Who's pulling,
Who's pushing, who pulling? He now has given ASAP Rocky a self-defense argument without ASAP Rocky testifying. Isn't that true?
That's a good observation. I don't know if I would make a point of that in closing because I'm not sure it's all that obvious to the jury. But in reality, if there was ever a chance Rocky was going to take the stand, and we knew that was slim to none, now that just reinforces that decision. Sit down, Rock. Just watch this unfold, because it's not a true self-defense case. It's just not.
Yeah. Well, Tandra Cook said it appeared to me that Relli was the aggressive one and continued by running after them. Thoughts, Michael?
Yeah, well, remember there was that contradiction in the preliminary hearing testimony, and there were lots of them. November 2023, the prelim took place. A lot of these same witnesses testified. There's a big old transcript. We heard most of it. It was like Masterpiece Theater with Joey T reporting all of these. Well, what about, let's go to this page and this line. In the preliminary hearing, he was asked, as he was in trial here, he was asked, well, were you afraid of Rocky? When you followed him, because there was a big dispute about, did I run after him? Did I skip? Did I so they agreed that he followed. You agree, Mr. Relli, you followed him, Mr. Ephron. In the trial, he said, yes, I was angry. I was afraid of him. I was afraid. And in the preliminary hearing, he said, no, I wasn't. So it may seem like a simple contradiction, but logic tells you if somebody is threatening your life, you don't chase after them. I don't know. Just logic.
I just kind of run away. I mean, I wouldn't chase after them unless I had some kind of big old tank that I could ram into them. I don't know about that. But Lily says that's why they wanted him to take a plea, because the case was weak. And it was a very light plea, if I recall. Do you remember what it was?
It was 180 days, as I recall. 180 days and then 5 years probation, something like that. And up front, a lot of people were like, boy, that's a sweet deal. Why he doesn't take it. And we were thinking there's got to be more to this. There's just got to be more to it. You're not just going to be so so self-righteous that I'm going to beat this rap. You could take that position to your detriment, and then you wish you took the plea. Sarah Boone comes to mind as somebody who could have taken 15 years, and instead she's doing life. But I don't see that here. But we knew something. Well, now we know the Relli factor. The Relli factor is blowing up this case, and the prosecution would have considered it a win if they could have sold Rocky on that plea deal.
And that's what happened in YSL, right? After 2 years of trial, you come in and the judge is going to grant a mistrial. So you offer these plea deals that people get out of jail right there. No matter what you plead to anything to get out of jail.
Yeah.
It's to me, that's like blackmail and extortion. It's like legal
There's no
blackmail and
doubt.
extortion.
There's no doubt.
Yeah. So we kind of saw that. And then Fonnie Willis wins and she gets to claim victory, which we've seen the office claiming. She's gotten convictions from, all the YSL gang, and she's got people to admit it's a YSL gang. So, all the bad stuff goes, like washed under the carpet, it seems to me, when you do that. And all the bad stuff would have gone washed under the carpet. Now, what do you think about A$AP Rocky's demeanor in the courtroom, Michael?
I think it's been very good. He's calm. I see him contributing, to the team as much as we see him sitting there, but he's not, demonstrative. I think I once or twice may have seen a slight head shake, SMH, the kids say, shaking my head. But no, I think he's been great. What do you think?
No, I thought so too. I thought he's very calm. He doesn't, he's appropriate. I think he's incredibly appropriate. The jury did not see the moment that was reported that we didn't see either, because the cameras were off, where apparently Joe Tacopina and John Lewin got into it when Lewin told Tacopina that the prop gun defense was bullshit of some sort.
And the jury was gone, though, right? The jury was out. The
jury was gone, right?
Okay.
And apparently, then there was, you should go on. Then Joe said something back, and then Lewin said something back. Take more steroids, and Tacopina said something back about go vacation at Robert Durst's wife's house again, because apparently he did with his daughter, and apparently. It was reported that actually that A$AP Rocky stood in a stand suit, stood in between them and kind of separated them. Now the jury didn't see it,
right,
but I think for people that were in the gallery, they saw it. So unless you're a moron or you're on the payroll, or you want to go, you don't want to go, you don't want to support any kind of rap figure because your gig is not supporting rap figures, and becoming famous, not supporting rap figures, going against rap culture. That had to be a pretty good moment for A$AP Rocky.
Yeah, you would think. I mean, like a regular dude, just trying to prevent two maybe angry men from who knows? It might have been interesting to see what happened if he didn't step in between those two. I'll take Joe Tacopina.
I think Joe Tacopina boxes. I think I've
so?
seen on one of his social medias, Instagram or whatever, that he actually boxes. I mean, I think he was a boxer. You guys who are watching this, can you guys Google that to see whether Joe Tacopina boxes or
when we get your buddy on here, we'll ask.
Yeah,
him.
we're increasing everyone's coming on now that we're talking here for questions. So anyone else have questions of us? We love to answer our own questions, but we prefer to answer your questions. Okay.
I have a question for Joe when he comes on. How much you bench? Oh.
How much do you
How
bench?
much you bench? Yeah.
Oh, Lord and Amber, you've been lurking, not to us, and doom scrolling. Okay, well, now we called you out because we want you to have a. So here we go. Joe has a fine physique. I mean, we should actually screenshot this. Matter of fact, I think I will screenshot this so when he comes on, because I know we're never going to find it afterwards. What we're looking for.
That is true.
And I will send this to our producers to hold on. Tandra Cook says, "I'll take Joe for 200." All right.
Exactly.
I mean, I really. This goes because of the question you asked about whether or not if you. This is the question you asked, right? Here you go. Now we know what's going to get people involved here. Okay. There we go. Get people involved here. Michael Missy wants to know, do you even lift?
Me?
He says, yeah, you said you would ask Joe how much does he bench press?
How much he benches? Yeah, that's just kind of a guy question. Just a guy question.
The guy would. This is great, isn't it? Hey, Michael Bryant, my partner, do you even lift?
I see. It's called do you even lift? Oh, ouch, ouch. Let me. Ow, that hurt.
I can do 100 modified push-ups.
What is that? Is that a girl's push-up we used to call them, where you're on your knees?
Yeah, you're on your knees. It's a girl's push-up.
Well, that's a lot.
Girl's push-up, but I can do 100 of those. Yeah, when I was really out of shape, I decided I'm going to start with one. I was like, because I said I used to do these when I had a trader, right? And then day 2, I did 2, and then day 3, I did 3.
And you got up to 100 doing that?
And I got up to 100. Now I decided to
Wow.
like stay right there.
That's a good
You know,
number.
that's 100's a good number. You know,
Yeah, that's a good number.
it's a good number. I think there's a disparity with evidence. Alec Baldwin case was dismissed. YSL case continued. The case despite evidence being withheld, and now Rocky. The bullets being collected by a witness, right? The cartridges being collected by a witness. It goes to show you that the criminal justice system, although I have to say, we did have what? We had a not guilty in Penny McGee, right?
Right.
What else did we have this week?
Well, you have the
But
directed
verdict in
Jackie Johnson.
Right? We did have with YSL, we did have the complete not guilty that our friend Doug Weinstein got. So we're seeing some, I don't know.
Yeah, I don't have, the numbers, a broader number base. Maybe it's because these are the cases that have gotten a little more attention and it skews the stats. I don't know, but it is disturbing, to see all of these cases, Ty Tucker.
Oh, yeah. Not guilty with the kid and his mom. Add to that.
Not guilty on that kid with the one that just happened. Yeah. That one was a little more surprising to me. And I hadn't followed it in all that much detail, but it was a gruesome case. And I think the acquittal was a bit of a surprise.
Yeah, well, because he killed his father like 2 years ago, right? And it was never charged because it was determined to be self-defense. And now he killed his mom supposedly in a suicide by son, and found not guilty. I mean, I just I didn't follow the case. I don't know if all of you did, but my point is that we're seeing, I think, a kickback, right? And I don't mean a monetary kickback, a kickback on
pendulum swinging. Is that what you're saying?
Yeah. I hate to avoid. Whenever I think of pendulum, I think of the pendulum. So with the Edgar Allan Poe. So right, I know.
Story and
so every time you say that,
but that's that's society that happens. So I don't know if it's hey, let's jump on the bandwagon of more defense-oriented decisions, or if it's just these particular cases are not good. And I like it because the system seems to work, right?
Yeah.
It's not perfect, but it's an adversarial system. And you put these two sides in the arena with the best weapons they've got, they go at it, and may the better man or woman win,
Yeah, Missy points out that the jury didn't know about the dad's death.
I would think that would be a motion in limine. Yeah,
a motion in limine. So it was Colin Griffith, Missy points out, was the kid not guilty of killing his mom. I think he's supposed to go. I think he's supposed to go live with his grandmom. So we'll see.
Watch out, Grandma. Careful.
Yeah. So but the point is that we're seeing that shift here. We're seeing that maybe all of a sudden the police aren't being as believed as much as we as defense attorneys have said for the last number of years. And we get pilloried. We get pilloried in courtroom. Oh, they always have to be guilty, And I think certain people and certain commentators and certain networks gear to that, because I think the audience has been in the past that you had to say everyone was guilty to get watchers. I think now the audience is changing. I think people know the system. They see it being abused. They see things going wrong. They see things not being turned over. And, I assume that the cameras in the courtroom are helping this.
I would hope so. Yeah. And people don't necessarily root for the cops, or they want a fair, just system.
Right.
They want to see it fairly play out. If that's good for the defendant, great. If it's bad for the defendant, that's the way it goes. They want it to be fair. And what we've seen is unfairness generally on the side of the prosecution. And, there's no better example than, of course, OJ, but that was years and years and years ago. And so,
let me bring what I did last week. No, last week when I was on the panel with the Chief Judge of New York and the former Attorney General and the head of the Legal Aid Society, when we were prepping before we went on, I said, hey all, the elephant in the back room of all our conversations here about how people are looking at the courts and what juries are going to think, and I'm going to bring it to the room, is President Trump. I think there is a viewpoint out there, and I hate to bring politics into it, but I think we have to, if we're going to be honest here, that now it was always the one side saying the courtroom was unfair, right? But now we're having people who are voting and who are citizens and who are supporting of a winning presidential candidate saying that the courtroom was unfair. And I think finally, you're maybe no matter what side you're on, whether you're Democrat, Republican, Independent, you're an alien. Maybe we'll have a discussion about how the courtroom situation has to be fair.
Yeah, that's what the goal is, and we've seen it shift, and maybe you're right. Maybe it's I think sea change is the phrase that I've heard a few times. The sea
That's really
change.
good. That's really good.
So I don't know. I don't know if it's that dramatic or not. We'll see.
Well, what do you all think? I mean, I brought the Trump word into it, and you're all from all over. What do you all think? Do you think that those prosecutions and what's happened since have had some effect about how people in the courtroom view the police? Or do you remember it always would be, well, you needed somebody who was minority because they had a different, like in OJ, right? They had a different experience with the police and not trusting them. But now I think there's a lot of people who may not trust them. You don't have to be, and if you're doing a jury selection, and by the way, I can't call him now because he is on this team. My jury consultant, my trial expert, Richard Gabriel, who I was on the panel with, it was actually his Truth and Justice report. Before there was a gag order, I had asked him, because they hadn't even picked the jury yet. Will you come on our show to discuss trial selection in this day and age? And what better time to ask him than whether this case finishes? And he at that point said to me, without a gag order, look, I can't come on this week. I'm really busy, and next week is really wrapped up. But I'll come on the week after, which would be next week.
Yeah.
So
he may be done with that particular job at that.
Yeah, if he's done, he's promised us, and boy, we'll advertise that if that happens, so you can get your questions into him, because I really want him to address that elephant in the room about presidential politics and politics.
It'd be good to get Michelle on too, if we had those two big brains that could. Michelle,
Dr. Michelle Ward is his partner, right?
Yeah.
Yeah.
Richard
Gabriel, right?
We should do a tag team then. I'll work on Michelle, you work on him.
Well, I've already got a commitment, so it's just a question of when that gag order. As soon as that gag order gets lifted, you and I are on the phone, baby.
It's gonna, obviously at the end of the trial, you can't really. Well, I guess in theory it could be continued through sentencing if there's a conviction.
Right.
But I wouldn't expect that to happen.
Yeah,
I wouldn't expect a conviction to happen either. Here's another element that I think leads people to be maybe more concerned about the process. If you go on any social media, how many times do you see a video of cops on a normal traffic stop exceeding their authority, demanding you identify yourself, even though you're not being suspected of a crime? They're just fishing for whatever reason.
Right.
Maybe some shop merchant called and said, hey, there's a guy wandering around the sidewalk. He's videotaping out on the sidewalk. And they come and they investigate, and they basically pretend you have zero rights and try to get you to, tell them who you are, what you're doing there when you're on public property or you're doing nothing illegal. And I think people see that stuff and it just bugs them because that's on such a low grassroots level. You don't have to be in court charged with murder. That's just, hey man, I'm just trying to get through the day.
Right.
And I've got authorities challenging me and saying I don't have the rights I know I have.
Right.
So,
And Tate points out, which is what we talk about, that certain communities, have not been treated fairly by the police, and it's true. It's absolutely true. Hopefully, we'll eventually get there. Although I don't know. I mean, I thought it'd be in my lifetime, but I'm not sure it's going to be in my lifetime. I think we've got a few hundred years to go. When is Doug coming on? Doug is coming on tonight at 7 p.m. Yeah, we'll probably monitor the courtroom about 6:45 to see if they break. If we can get on to answer some of your questions before Doug gets on. Doug's going to talk about the Georgia case, and we're going to pick his brain a little bit about obviously this case, because he is now a criminal defense lawyer extraordinaire, right?
Oh, and I talked to him the other day, this is breaking news. Wait, do I have? I can't find my breaking news down here. He's opening his own firm.
Woo, Dougie! Yeah, we're gonna.
There we go.
There it is.
Breaking news. Yeah, he's opening his own firm, so that's very exciting, and I'm sure that all the notoriety from YSL kind of led to that. So we'll learn about his new deal. I think he's going to be working not with, but in the same building as Bruce Cutler. that
No,
right?
no,
No.
no.
The other Bruce. Bruce Harvey? No.
Harvey, yeah,
Bruce
yeah.
Harvey. Yeah.
Yeah,
Okay.
no, not going here. Louise didn't like to not critique cops. You've been protected your lifetime. They're not better than anyone else. I have a lot of clients in my lifetime who are cops, right? And some of them have actually sued their departments for not
No-
doing the right thing.
No doubt.
So, they're, we've all seen, and I think that's the whole point. You can't blind your eye to when they do something wrong. You can't blind you, and you can praise them when they do something great. And yes, I'm not one of the get rid of the cops movement. No, I think that certain departments may need reform, but I'm not one of getting rid of the cops movement. I think they have.
Nope. Defund the police. No, that didn't work out so well.
No.
That didn't
But
work
you
out.
know what? I think training is important because I do cases in civil rights, and I think training is very important. And when anyone does anything wrong, whether it be a lawyer, a doctor, a police officer, there should be, if it's criminal, it's one thing. If it needs training, it's another. I mean, you can't improve unless you address the shortcomings. And
Yeah, and I think no matter what the group, doctors, lawyers, Indian chiefs, oh, you can't say that now anymore. There's going to be bad apples in there. That's just human nature. So I'm not going to be naive enough to think that every cop's good, every attorney's good, every doctor's good. That's too naive.
Right. But here, you can believe very easily that the cops want to say they did a good job. And no matter what comes out in this trial, they're not going to say that this case was improperly brought. Why? Well, let's face it. If it gets dismissed on directed verdict, there could be lawsuits against the individual cop. Did you do this? Did you do that? I mean, we've talked about it here. I mean, I would have if there were a civil case, and the civil attorneys are very responsible, Ben Chu and Camille Vasquez, I'd have ethics counsel reviewing those tapes before I would bring this case. Now, one thing we didn't talk about, and we should talk about tonight and more, there's a defamation case that was filed by Relli through his attorneys, Ben Chu and Camille Vasquez, for defamation against Relli, for Joe Tacopina is the defendant. So there's a subplot also going here, right? I mean, and that's what's happening, by the way, in all these cases. If I file like a sexual assault case against somebody for my client, and I say that they're guilty of sexual assault, and you see it in the egregiously in the Blake Lively case that's going on right now, right? The attorneys end up getting sued. So you can't say anything. You can't say my client was sexually assaulted out there in the open, because then you get sued for defaming the person that your client says sexually assaulted them. All right. And that's the same thing that's happening in any case.
Yeah, this is the answer to that lawsuit. You can see, the named defendants right there.
There it is.
Fine, Joe Tacopina.
Tacopina and his law firm, right?
Yeah, and his firm, and then of course, and Rocky. So
and they try to get you out of the case too. Not only do they try to get money, but they try to get you out of the case of representing the person, because then is there a conflict?
There's a conflict, yeah.
So you need ethics counsel from the insurance carrier to say it's okay for you to go forward to represent, and it creates all sorts of issues. And it's really, that's what's happening now. That's the way of the world, and there has to be some kind of slap law. We used to call them slap suits.
Yeah, slap suits. Yeah.
And that people would sue people to get them not to sue other people. There have to be some kind of protections on this.
That is some complicated area of law, I'll tell you that. The slap laws. On your comment about the cops, I think, and I'd be curious to see what folks think, I don't fault the cops at all in this case. I think they evaluated what they found, what they didn't find, and it just went into a category that did not require much more work. They weren't finding what they needed to find to pursue it further. So I got no problem with the police. They made a little mistake in their police report, came clean on that. But, was that a big deal, or was that just kind of immaterial and minor? I got no problem with the cops in this case. I don't know what people think. What do you think?
Well, I have a problem with them at the trial, just not saying, hey, you take Relli out, you put Relli in.
Yeah, I'm talking about the investigation.
I mean,
yeah, I'm talking about the investigation.
Yeah, they did. They went to 7 people to the scene, right? They said 7 people to the scene, and they didn't find anything. I really have a problem with going forward afterwards, because somebody had to make a charging decision, right? Sure. There's where the problem lies, in the charging decision, knowing that you've got the Relli tapes out there. Now, I don't know when those came to the forefront, But that's a real problem. Hi, Moon Goddess. Moon Goddess was actually on the
She
air
was
with us
on.
last night.
Yes, she
You
was.
were, and she was great. If
Yep.
you didn't see her, go back and watch our tape from last night. She was the star of the show on the Penny McGee case. As you know, she brought that case to us to look at. And when she said, you have to listen to the medical examiner there. Her testimony was outrageous, and quite frankly, it was. And you know, it was like, you know, if I said boo to you, Michael Bryant, and you
Again,
had a
with the
heart
boo.
condition, with the boo, okay. And I said boo to you, and if I shoved you because you were pulling my hair, which you can't because you're in Connecticut and I'm here, but if we were together, you know, and you were sitting next to me, and you died from your heart condition, which I don't know if you have, but if you, let's assume you did,
I'm good.
hypothetically
Good.
here, right? Okay, I could get charged with murder, and she was like not deviating from it; she was strident in her opinion.
Yeah,
You know,
very
you had-
defensive.
so
Yeah.
so I said to, and you're all going to get the lowdown on this. I said to my husband last night, he said, well, you're a boxer in the ring. No boxer who hits somebody in the ring is going to get charged with homicide, even if it's a death at the hands. No, they're just not going to do it just because you're in the ring. Or I came up with something even further and said, what if you were having a consensual relationship with somebody and they died in the middle of the consensual relationship because of a heart condition?
You're talking about
That's
sex?
I was trying to avoid that word.
I mean, come on.
I'm Catholic, okay?
Oy, oy, oy.
Okay.
Yeah.
All right. Consensual, but they have a
And
heart
the same
condition
thing
and
is
they
true of the
die.
boxing. And you know, there's case law that supports that. If you consensual to a boxing, a mutual combatant,
Right.
yeah, whatever happens,
Right.
happens. Remember Duck Koo Kim? You remember Duck Koo Kim?
No. Did he
Yeah,
die?
Korean boxer died in the ring.
Oh wow, I didn't remember
Yeah,
that. Okay.
not that long ago, and it
But
happens.
they won't call, and they're not going to call somebody whose partner has a heart attack in the middle of a
During
consensual sexual
that thing.
That's I you know why, because I was thinking about this is how my mind works. Goldie Hawn had a movie that she was in the army, and then she joined the army because she was
Yeah.
having sex with her partner, and
What was it called?
and it was I can't remember what it was called,
I
and
can
he
picture
died.
it.
I can picture it too. And she joined the army, and she didn't think the army was the same thing that she thought it was, because where's the condominiums in Hawaii? Where's the
Private
post?
Benjamin.
Private Benjamin. There you
Yes,
go.
thank you. Did I
Goldie
win? Do I
Hawn.
win? I got it first. Did I
Yeah,
win?
you win. And I'm thinking to myself, imagine if they had like a little glitch in that movie where in between, before she joined the military, she got charged with homicide because she was in the room when somebody died, and it was a physical act that she knew somebody had a heart condition.
This is a perfect example of the distinction between medical homicide, legal homicide. In the ring, in the bedroom, you do have the death of another person at the hands of a death of a person at the hands of another, right? That,
Right.
arguably. So the medical examiner could call that homicide. Boxing ring, clearly one man or woman died at the hands of another. That's a homicide medically, but there's a defense to it, so it's not a homicide legally.
Yeah. So anyhow, so thank you, Moon Goddess. Relli ruined his own career and future, in my opinion. I agree with you. Just like you said last night when the gentleman who died, and he said that he died from his own anger. That was the standout line of the night last night about the Penny McGee case. So that's what caused his heart attack. And you're right here. He owned his own career and his future. And the jury, we'll see if the jury feels that way. I know I think you and I are beginning to feel that way, Michael Bryant.
Yeah, I think that would be legitimate, but we're not in the box.
Well, yeah, this is true. Who is the box?
We were asking Offie about the other day. Offie Patterson has been in the courtroom, and it's funny. She said, I think there were 4 women. Is that right, or was it 4 men? I know it was very lopsided, and she didn't really have any real specifics on racial breakdown. But men to women, it was definitely lopsided. How do you feel about that? And does it even matter in a case like this?
Well, they had the jury consultants, the trial consultants. They probably likely mock tried the case or had focus groups. It's pretty evenly split, if I recall. It was 7-5, right? So I'm not sure.
No, it was like 4-8.
Oh, 4-8?
That's
Okay.
all that Offie could remember. She didn't have it much further than that, but it was 4-8 one way or the other.
Kel says they're all white.
Okay.
I think it's kind of important, actually. I don't have a problem with the jurors all being white. I really don't. I think that even though there was an issue that Joe raised initially, that there were no black jurors on the case, I think that this is a case that should transcend racial divide here. I mean, is Relli a liar? Is he a liar? He's not a liar because he's black. He's not a liar because he's white. He's just a liar if you think he is a liar. And he admitted he lied, so he's a liar. Okay, So I mean,
There was talk of having an appeal on that issue, early on, because they had there's 6% of the population, no, 9% of the population in LA County is African American, and they had only 6 out of the 100 and some prospective jurors in the pool were African American, and then none got on the jury.
Well, that baffles me. That baffles me how that happened.
Here's how I think it happened. Here's my guess. First of all, I still, as I said from the very beginning, I want to know who didn't show up. I can't believe they got 100% attendance. They send out, let's say, 200 jury summonses, right?
But 7 women, 5 men. I was right. I was right, by the way.
Oh, well, then Afi was wrong. Okay. So 200 people show up because they sent out 200 notices? I don't think so. So I would like to know, of those who didn't show up, what was that racial breakdown? Because that could affect the overall percentages. And then of those that did show up, remember, how you do it in California, they randomly pick, 12 people, and then they don't replace those 12 people until they've removed somebody. And as I've talked about before, the 6-pack, where we would do 18 people, and the same process takes place. Well, if you only have 6 out of 110 that are African American, you could easily go through the selection process and never even get an African American in the box to question. They'd never make it that far.
How do you only have 6 out of the downtown LA jury pool? That was the whole thing in OJ. Remember, the office wanted to bring it in Santa Monica, like where the civil trial was, and the DA at the time said, "No, I want to show we're fair. We're going to bring it in downtown LA where we can get a racially mixed jury pool so that the verdict will be accepted." And now, when I tried Spectre, we had everybody. We had Asians, we had white, we had black, everyone. Now, I mean, how do you in downtown LA?
Well, that's just it. It's not downtown LA is not the pool. It's not downtown LA. It's LA County, and that percentage is based on LA County. So LA County is massive. So yeah, if you just went street to street downtown, maybe you'd find a higher percentage of African Americans, but that's not the pool.
Okay, so take 2 is an interesting, having them explain the slang, the culture, what get in the street means. I think everybody was having a little problem, remember?
There's a lot of language I didn't understand.
Yeah, it's well, we're white, in case you haven't noticed. Okay, and we're not of Gen Z. I mean, Bob Bianchi had a great story a couple of weeks ago when he was on, and somebody told him that he had unspoken Riz. Remember, unspoken Riz, right? And then Bob Bianchi came out as he's in his EMT.
There it is, unspoken Riz.
Unspoken Riz, there it goes. Came out in the EMT uniform, and he asked the Gen Z person, "Is that good?" "Yeah, it's charisma, bro. It's unspoken. It's charisma without you saying anything. It's Riz."
I think the unspoken part is very, very cool. That part, because that means you exude it, right?
Right. You exude it, right? Absolutely. So, and there was something else that went on recently. So there was some other statement that we knew what it was, and somebody else didn't know what it was. But you hang around with people. Well, that's why it's important of hanging around with everybody. Young, old, different cultures, because there are words that people use. I mean, I remember growing up in my generation with my Italian immigrant parents. They use words that other people did not use. No one would know what they are unless you come from an Italian immigrant family at the time. So I kind of put them out of my head right now. Not my parents, the words.
The words. So we dabbled into the Karen Read for a moment. You want to touch on that, or just save that for tonight?
Yeah, no, let's touch about it some more. Yeah, let's touch about it because they're still out. And anyone have any questions on Karen Read, put them in there, because we will do some more tonight. Obviously, a little bit more.
We decided not to go up this time because even though there could have been something of consequence, and the argument was of consequence, the underlying motion was not so of consequence, the expense motion. But mark March 4th on your calendar, because that is when the motion to dismiss is going to be heard. And what kind of motion to dismiss is it going to be, according to Alan Jackson? Full-throated.
I was like that. I thought about a hummingbird, a full-throated
hummingbird.
He said that 100 times, I think.
It's going to be a full-throated motion. So
a full-throated motion. And then she gave the DA's office like 3 days to answer.
Well, they were negotiating, because here was the original order, right? And then I've made notes on it based on the changes she decided today. They're also having a hearing on the 18th. about voir dire, just perspective questions, format. So that was going to be a day that was originally going to be for the filing of the motion to dismiss. That's been pushed because Alan Jackson cried, and he did it because he had just got dumped. How much did he get? What new discovery did he get from the prosecution?
A lot, voluminous. The word was voluminous. They
You got
didn't
a
say how much,
voluminous
but
amount.
Last night, you got a
Yeah,
that they
you
had
got
to
a
do it by
full-throated amount
a
of
voluminous amount
discovery.
last night that they had to do by link. Okay, and the defense was great. They didn't. Well, we'll be ready. We'll go through it. We'll be ready.
Yeah, it was 12 different files of stuff. So, who knows? File is now they're all digital. A file could be a file. It could be a file. So anyway, that date was pushed, but she said, well, you already have the 18th available because that's what we originally were going to. So that's the voir dire issue. The 21st is the new motion to dismiss deadline. It was going to be that, like I said, it was the 18th. Oh, you know what? I think she pushed it a second time. Remember, because Alan Jackson said, "Can I get to March 1st or something?" Because we want the weekend.
He wanted the weekend. She said no because I need weekends too.
Yeah. So it might have been. Let me check my calendar. It might have been pushed to the 24th, which would 24th gives them the weekend. So it is now the 24th, and
she didn't. They didn't get the weekend. They didn't get the weekend. She wouldn't give it the weekend.
Oh, she wouldn't give that one. I think they have it on. I'm going to check, but I think I have it on the 24th. But
I thought it was the 22nd, and then the prosecution.
Well, it wasn't going to be 21st. 22nd is a Saturday, and then
I think it still stayed the 21st, and then she did the prosecution because she said she needed the weekend, 4 days or something like that, or they got 4 days, and then she wanted the weekend. She wouldn't give the prosecution, so she said she needed her week, and she needed her weekends, right, to look at the stuff.
So March 4th is whenever those.
And she has a hearing too. She has another hearing in there. She gave them
a hearing on the 6th for all reciprocal discovery. That's not a hearing. That's just a discovery.
Then she had a hearing on expert voir dire, I think, too, right?
That's why I said voir dire. That's on the 18th.
Voir dire. That's on voir dire, right?
That's voir dire.
Why would you have expert voir dire? What's different from voir dire?
I don't think it was expert. I just thought it was just thoughts on the voir dire process.
On voir dire. Okay.
How they were
got
going to handle it.
Well,
we know that's coming up. That'll be April 1st. The first day of trial is. People think it's opening statements. It's not.
Oasis Cat thought she gave them one more day to get their
one more day. So that would be the 19th.
19th is a
No, I'm sorry. That would be the 22nd. Is that right? The new date?
Yeah. Is that
Saturday?
Saturday?
That's a Saturday. It can't be.
Yeah.
Can't be Saturday. Okay. Well, it's been pushed, and it's either the 21st or the 24th, and
somewhere's around there. Yep.
And then the Commonwealth has a few days, but the key is March 4th. That's the
and Jackson said, and we can argue it, and we'll be ready for trial. So no one's expecting it to be granted, even though it's full-throated. I don't think, because they said,
of course,
I don't know. Yeah,
of course. But then you've got just one more grounds for appeal, and just playing the game. But I think it's going to, just as today's argument did, it really lays the groundwork in front of the court and the public for all of the evil deeds by the prosecution in trying to hide the ball from the defense. And, just ask the Baldwin folks how that played out for them. Morrissey, the DA in the Baldwin case, when they decided certain bullets would be relabeled as another file and not given to the defense. Oopsie. Dismissed with prejudice.
Muga doesn't think it's going to go to trial. Making accounts is why didn't she seem to make any decisions from the bench? She did make the not guilty yesterday from the bench. Penny McGee. That's the one thing.
Yep.
That's the one thing she did. But that, my view of bench trials when defendants agree to them is usually because there's already been an in-chambers conference where there's like, you're not taking the jury to begin with, right? So you have to know how the judge feels about your case. There's a lot that we don't know when we see a case go to a bench trial on that, but I don't know. You think, well, yeah, Alan Jackson's not going to say, he's going to say full throated, but there could be a lot of stuff in there. I mean, I can't imagine how you can have all these motions to preserve. And then it turns out that, and I'm going to go back to a comparison between here and ASAP Rocky here. Brennan took this case as special prosecutor. He doesn't need it for his reputation. He's got a good reputation as defense attorney. But now he's finding out all of this stuff that happened. If this were me, I'd be like, I'm out of here.
Yeah, that certainly he would have I could see him having the right to do that, but he's sucking it up. And I agree. I don't think he's doing it for the money. And we know the $75,000 that he's getting through June, sounds like a lot of money, but it's not. not for the kind of work and hours that he's putting in. I do believe he's a stand-up guy when it comes to, hey, I inherited this crap. Whatever happened before me, I take responsibility. I'm now the guy. I respect that. And he said that in court today.
Yeah,
So,
well, he did say that, but he was confronted with a whole bunch of bad
sure.
stuff.
Now,
shall we say.
what he knew before he took the job and what he didn't know would be very interesting to find out. Because if he had done a little of his own due diligence, maybe he would have asked, a handful of questions like, anything we haven't turned over to the defense yet?
Right.
Oh,
and then by the way, there's a detective's file, because when you go ask for discovery, what do you ask for? What's in the police files, right? But detective, and I always try to do this, a side file that a detective keeps, and they may have a download, and then where did that go? Then there may be an iCloud account, but no one knew who owned the iCloud account. Was that a formal account by the police? Was that some other side
personal
account? Personal account that somebody has other stuff in and other things. I mean, and then they went to, we'll talk about it tonight, but they went to a sidebar. She asked about the federal investigation. So we're going to talk about tonight because you have the clip ready for that later on. When we talk
it's a clip of nothing, but it just does set up this conversation they had. It was a 14-minute conversation sidebar about what do we now know. That was really the crux of it. Are we going to get into this? She's asking, and this is the ARCA, material, which is the federal investigation into whether or not there was, I guess, contact between the car and John O'Keefe. That, in a nutshell, that's what it was about. And so she wanted to know from the attorneys, well, where are we on this? And let's talk about it off the record. That's about as far as it went. And then for 14 minutes, they're talking at the bench about whatever it is they know about those reports. And clearly whatever she's learned is going to color her decision on what is and isn't going to be allowed in trial number 2.
Yeah, with the beep, beep, beep that we kept hearing instead of the white noise.
What is that? I thought it was my pacemaker.
Yeah, I know this. There's no such thing as professional iCloud accounts. So that's why no one seemed to know. Even Brennan didn't say, he didn't know what iCloud account it was.
That person was identified in the affidavit by Brennan, because the court confirmed, did this person you identified in the affidavit, they're the one who uploaded it into their iCloud account, which is now where they'll go to get it.
Fun to see. So TB, It's a Beautiful Life. A lot of people get confused about reasonable doubt. Can you explain how reasonable applies in the Rocky case, even though people get stuck on the he had a gun fact in the case?
Interesting.
Go ahead, Michael.
Well, he had a gun, maybe one element of the ultimate crime. Obviously, you can't shoot at somebody unless you have a gun to do that. So that's fine. That's an element. But the reasonable doubt, I think the question is, what is reasonable doubt? And if we compare it, sometimes I used to have some sticks that I used to use where I would have clear and convincing evidence stick. I would have beyond a reasonable doubt stick. I would have a preponderance of the evidence stick, right? And so if preponderance of the evidence is 51%, right?
No.
You don't like that?
50.1. A grain of sand.
Yeah, a grain of sand. Interesting. So, in other words, more likely than not, right?
Right.
It's just enough to tip you over. So that if that standard is that, then and clear and convincing is the highest, right?
Right.
Then beyond a reasonable doubt is just below that. It just means, can you push every reasonable doubt out of your mind, other than the story being told by the prosecution or whatever the story is that's being told. It's very close to certainty, right? That's how I try to describe it.
But the question is, can you find beyond the reasonable doubt? That right?
Well, the question seems to be, well, just because he has a gun, assuming that's legitimate,
right?
Doesn't get
he has
you
a gun. Doesn't get you the elements of the crime.
He might be convicted of a gun charge, as in, if it's not his weapon or it's illegal, but that's not shooting.
They can't even prove that.
That's not assault and battery.
That's right. They can't prove it. So
so the question becomes elements of the crime. You can't prove one element beyond a reasonable doubt and get you to the finish line.
Yeah, has to be all the elements of the crime. And we were young prosecutors. We were told, bring the book, The Wall Down with you. Open it to the page where the crime is charged in the indictment.
There you go.
The charge, and you have all the elements, and make sure you ask the questions And did he have a gun? And did he shoot the gun? And was there a projectile in the gun? There was a, you know, so that you got all the elements in. They told us when we first started out. So,
I
Moon
always
Goddess.
described, well, criminal law is one of the first classes that anybody has. It's a first-year law school class. The
Right.
reason is because it's easier for people to grasp, because it's like a cookbook. You know, let me tear out the page for battery. Oh, here's my cookbook. And here's the elements, the ingredients that I need to make that recipe.
Case. Right.
Yeah.
You're absolutely right. Right. Moon Goddess, again, the Commonwealth did not preserve the original video audio. That's a problem. Yeah, I think all this is a problem.
Yes.
Because let me tell you, you have a duty. We talk about a right to preserve, or a motion to preserve, which I file all the time. Usually when I get into civil cases, I go in under New Jersey law, even though they don't have a case. Let's say it's a shooting case, not a criminal case. But a lot of times you don't even have a defendant at that point. You can't file a motion to preserve on day one because you're not a defendant. You get no standing. But there's a duty to preserve things that are exculpatory, no matter whether there's a motion to filed or not. So that's a really interesting thing. It doesn't, a motion to preserve only applies to things that are not exculpatory to begin with, that you want preserved.
Yeah, and as the cops are doing their investigation, they know what is or isn't likely to be exculpatory. They don't get to decide whether it is or isn't, but they know whether it's going to be an issue, and they would be required to preserve it.
Right. Candy Temple.
Alan made a great. I'm sorry. Go ahead.
What type of Brady violation? Okay, Candy Temple. What type of Brady violation sanctions are available to Bev other than dismissal? Well, she could put monetary sanctions. I mean, dismissal's the biggest one, obviously. Like involvement's the key. That's the one everyone wants. She could put monetary sanctions on the office, right? Yeah. She could put monetary sanctions. I don't think she could do it on individual officers, but certainly on the office, on the Commonwealth, big monetary sanctions on the Commonwealth and all. But that's really the problem. She could eliminate some of the evidence. Some of the evidence can't come in.
Issue preclusion. You've got claim preclusion, and that could manifest itself as evidentiary exclusion. That's not coming in because it's connected to this, and this. Yeah, she has a lot of weapons.
Yeah, she does. So, but
I was going to say,
obviously, you want the big one.
You want the big tamale.
You want the big one. You want the big.
Alan Jackson made a great comment, because remember the Higgins video that surfaced out of somewhere recently?
Yeah, everything surfacing out of somewhere.
Yeah. So how does that even exist if, in fact, the 30-day timer had lapsed on this DVR?
Yeah, it's in the iCloud account.
Gobbles everything up after 30 days and starts recording over it, which is not unusual, and it isn't captured somewhere else. How does the Higgins video survive that and come to light after a period of time? It makes you think it is somewhere else, and they have been picking and choosing what they hand out.
That's what Alan Jackson did. That's what he argued.
Great argument.
Clip. It was a very good argument, because he said, I'm getting all these little things. Where'd they come from? They're on the original. They weren't there. They were gone. Oasis Cat, does it bother anyone else that Bev handwrites her decisions all over the filings? Does she follow up with typewritten rulings? Sorry if the word that you didn't word it wrong. It annoys me so much my brain can't think. And most times when you're at court, by the way, you get handwritten decisions on a type, because you submit the order and then the judge handwrites on the order. The judge doesn't make up the whole order.
That's a good point.
But they usually write the rulings on.
This is just kind of a housekeeping thing that people may not realize. When the court orders, well, guess where that order comes from generally? The attorney that wins. The attorney, both sides may craft an order, tailored to what they want, and then the court will take the one that closely matches the decision, but it's not always perfect, and that's where the handwritten notes come in.
Right.
There was that one that Bev just did recently it just confused me. It basically contradicted what she had said. Like the order was denied, but then she handwrote in something that made it sound like it was granted. And that was very confusing. I wish they had kind of rewritten that instead of had her.
Yeah. Dizzy. Thank you, Jen. Could she say that the Sally Port video isn't admissible? She could, but the problem with that is that Alan Jackson now wants that in, because it showed
so
that
damaging.
They actually
Damaging.
They gave it to him. They had inverted it as to the right and the left, and somebody had to formally do that inversion, and that came out at trial, and somebody must have picked it up and noticed it, because I don't think I get the
how stupid could they be?
Yeah,
you see the video and the numbers, the date stamp and everything is inverted. How could you look at that and go, yeah, that's right? I don't understand.
You know, and before that, I thought the witness would testify. The heavy set guy who was on the stand, I thought, well, he's a pretty good witness. And then it turns out they brought him in there because he was introducing this inverted video as if the lawyers are stupid. But, you know, sometimes you don't see things too until, you know, the end too. I don't know if they saw it.
I guess.
You know, but inverted video. Okay.
Well, I mean, the other interpretation is that they saw it, they knew it, thought they could get away with it.
Yeah, just you know, it's just I don't know, and that leads for the issue of is she guilty or not guilty, because all this other stuff is crazy, right? Just crazy, and it's unfair. It's unfair. Even the supposedly admissions. If somebody admits to a crime, usually we're fighting an admission in a police report because it said, you know, I did it or something like that, or they made an admission, they confess, and we say, no, you didn't. No, you just made that up. Here, they don't have any admissions in any police reports, and now they're saying, oh, but we didn't put that in there. We didn't put that in there because we were being fair to her. What?
Yeah, I mean, you know, the whole I did it without, you know, perspective and context. I think one of two things could have happened. Well, one of three things. She really thinks she did hit John O'Keefe. That's possible. She was questioning it. I hit him. Or in the emotion of the moment, she just assumed she hit him. Those are the only three possibilities for her saying, I hit him.
Right.
That's
Which doesn't mean she's guilty. Doesn't mean she's guilty.
No. You got to have something to corroborate the other one of those three meanings.
Now, I don't understand how they get around, and apparently, I don't know if there's new expert reports from the Commonwealth. We don't know what they are because they weren't listed in court, but I don't understand, and maybe this is why the federal thing is so important. The federal people, and including the state medical examiner, which of course now we've seen the one from that testified in McGee, said that there was no evidence that a car hit O'Keefe. So if a car didn't hit O'Keefe, how could she have killed him by hitting him with her SUV?
Yeah, I mean that's
riddle me that, Michael Bryant.
That's game over. That's game
then why
over.
isn't it game over already? Why isn't it dismissed?
Why did you have an expert and you have cops with their various pieces of plastic they found at the scene and in his sweater that they say suggests she did hit him? You know, that's the $64,000 question.
So I'm going to bring that full circle to you because we're going to be going back from lunch soon, back to ASAP Rocky, where the police officer, the case agent who Joe had pretty much converted to his side the other day, then today gets on the stand trying to rehabilitate and redirect and redirect that even if you didn't have Relli, there's enough, and we don't have any shell cases on the scene. And my officers said there were no shell cases on the scene. I hear in that video a gunshot. And I can hear a gunshot. That's a gunshot. And to me, that's enough to prove the case. So how do you compare the two?
Yeah. And the only other thing he has is there is a gun that you see in the video, right? In the waistband.
Right.
And so you have some of those elements. Well, great. Okay. But let's assume he's 100% right. Let's assume a shot was fired somewhere, somehow. Maybe a blank, maybe a projectile. So what? I mean, it just doesn't get you beyond a reasonable doubt as to an assault and battery. Remember, an assault is an attempted battery. It's causing the apprehension of a battery. The battery takes place when the knuckles, if they are actually hit.
When the assault ends and the battery begins.
Exactly. Right? If he had no injury that he blames on the firing of the weapon, then you still have an assault, but you don't have the battery because you didn't have the harmful touching.
So I bring it now back to Karen Reed. How did we get past any motion if the statement or the prosecutor's experts, the state expert, the federal expert, that they couldn't, and they didn't call them, right? Couldn't determine that he was killed by an SUV.
You mean they have evidence that he was hit?
No, they have no evidence that he was. They don't have, according to the experts, they don't have any evidence that he was hit and caused his death. That's what was the first trial, right?
No, they just have forensic evidence that could lead you to believe he was hit.
But no expert testimony that says it was hit. So here you got the reverse. You're going to have an expert who's going to say, "Well, I believe that the gunshots show that this happened as Relli said it would happen, even if we don't have Relli, and even if Relli's a liar." It's kind of the reverse.
Yeah, that's kind of twisted.
Yeah, well, the whole case is twisted. Both cases are twisted, right? Both cases are twisted. We still, I mean, I want the jurors. When we go to Karen Reed, I want you to go up there. Here's Michael's assignment. I want you to go up there and find the jurors, Michael Bryant, from the first trial.
Go track them down.
Don't
Oh,
you think that
from the first
that
trial.
they're using? Don't you think that defense, and I don't know who the jury consultant is, but don't you think they're using some of those jurors to consult with them?
I would think
Just
if
to-
they're willing, if they could find them and they're willing, sure. Why wouldn't you? You know, there is that kind of weird thing hanging out there that that matzo ball appeal that does involve affidavits from what? How many
wait,
they
the matzo ball
the big
appeal?
matzo ball hanging out there?
Okay.
You know, yeah. What they have 5 jurors that you know anonymously said that they had ruled a certain way. So I would imagine those 5 you would not target or get their participation in, and probably shouldn't, because that might kind of muddy the waters on the appeal. But you still, there might be 7 out there that would be willing to chime in. I don't know. On second thought, I'm thinking if that issue is still kind of out there, then maybe you don't want to touch any of those jurors at this point until the appellate court decides.
Did you see that case that came down the other day? I think I sent it to you in our chat. We're chatting at the Massachusetts top court. Came down with a case that said the judge, in determining whether or not there had been misconduct or something, the jurors didn't go back and do a proper investigation by interviewing the jurors.
I did not see that.
Okay,
Was there a timing element? Yeah, was there a timing element in that? Like how long?
I don't remember. I'm going to go back and look at it before tonight. We'll try to find it and have the name of the case. It's somewhere. Dizzy, Missy. It's in our chat. It's the case that's in our chat somewhere. Well, among the 100,000 other things.
Yes, it's hard to find stuff in there at times. Just scrolling, 15, 20, 30
There should be
entries.
a search function in WhatsApp. All right. Is there?
I guess there's not.
I don't know. Is there? Is it in
know.
Facebook? Is there a search function? There should be a search function. They should do something good. Oh my goodness gracious! So,
I forgot this. Mention this. Let me mention this. I forgot all about it because we had so much going on. But remember Robert Birch? Remember Robert Birch, the attorney for Gretchen Voss?
Yes.
The writer for Boston Magazine. He
Yes.
was victorious in getting those notes protected.
Fabulous.
I'm going to talk to him tomorrow, and we'll have that tomorrow night. So.
Oh, that's going to be great too. Yeah, because he really got a reversal for opinion.
Too. He seems like he hesitated so long. I could have driven a truck through the silence when I asked him if he would talk to me, and it was just like looking off into the distance, like he's cranking through the pluses and the minuses. And then he said he would, and then once I broke him down on the street there, calling him up after the fact was fine. But I do want to ask him too about some stuff he may not want to get into, which is the stuff we've been talking about from yesterday and what we think's happening in the motion to dismiss. Might be just curious to get his take. He may excuse himself from that discussion because he was very focused on the First Amendment issues and the Reporter Shield-esque issues. So
yeah, and he did a beautiful job.
It's amazing. He when you get a judge,
right.
any judge, to reverse him or herself, that's a huge victory.
Yeah, you wonder. I assume judges, and I used to see it when I collected from my judge, would go back and get the opinions of other judges when they've done something. I wonder whether or not the Judge Canoni got the opinions of other judges, other people she's with, about whether or not she should do this, because she didn't rely on a shield law. She really relied on a common law.
It's a balancing they use there. Yeah.
They use a balancing. And
so what they decided was those notes, and these were, again, just the handwritten notes of the third interview that was done between Gretchen Voss and Karen Reed, not the article that was done, not the notes specific to those articles. Just she met her for a third time at her home and just took some notes. The court decided that the chilling effect on a journalist who has to cough up those notes outside of any sort of source question, because obviously we know the source, that it didn't outweigh the prosecution was not able to outweigh that chilling effect and get the notes. So
that's really
and she looked at him. She looked at him in camera, so.
She knows what they say.
It wasn't in a vacuum that she was ruling. She looked at him and said, "Yeah, it just it doesn't help First Amendment rights of journalists."
So, Michael, does she have to keep those under seal, or do they get destroyed now that she's ruled that
I would think they're either returned, which is they do quite often. They just return them. It's that way they're out of the court's possession and they're done with them, or they would destroy them. But I'm assuming they were copies, so they probably just destroy them.
Really interesting. Let's see, Pokemon 0730. We're not going to talk about the Ellen Greenberg case. We're not up on that yet. So we'll do that some other show if that's okay with you. Judy Jameson, yes, he did do this himself, trying to place the blame on Rocky. That really tried to do this himself. on his knuckles. Well, I've never seen, you mentioned yesterday, I've never seen a grazed one to kind of like, just like hit. And your knuckles, remember, your knuckles are kind of, you know,
They're
they
not
don't,
even,
they're
yeah.
not even. It's kind of, the bullet had to
But
kind
you
of
know,
like,
I defer to physics on that. I mean, you know, how does a president to be turn his head and get his ear just nicked by a bullet? I mean, there's so many moving parts,
variables, right?
you
So many
know.
variables, right? Right.
So
There's
yeah,
so many variables. So yeah. So we have that all going on. So we have tonight. We have Doug on. We'll talk about the Georgia case, Karen Reed, and of course this case, which we assume is going to end today. The last testimony. I don't know if the directed verdicts motions will start today or tomorrow. I think if this case goes, I assume the cross examination are going to take the whole afternoon. We'll see directed verdict motions tomorrow. That's what I'm assuming. You know, I go, oh, those ashy knuckles kissed the pavement. LOL. You
What?
know, LTO. Says
Those
just coming through my
action.
you know.
Yeah.
And Phoebe
Many.
Purvis, yes, we're already late starting from lunch again. The judge really likes these extended breaks. California. That's why
Hey,
cases
you
take
know,
so
we're low
long.
key. We
You
don't
know,
need to rush around. What's the hurry?
yeah,
And they may be
attorneys
having
will-
conversations, you know, and
Yeah.
these moments before the jury comes back or before they report in the morning are the perfect opportunity to judge just one thing. Just a little housekeeping thing. What about
Yeah.
this piece of evidence and this and this? Or the judge might be saying, Mr. Tacopina, how long do you expect your cross-examination to be?
Right,
So
right,
he can kind of
exactly.
factor in, okay, do we have time for any post-trial or
Motions,
post-prosecution
right,
resting
right.
motions or not?
We don't know if the defense is going to have witnesses, by the way. That's something happens
That's right.
after a directed verdict. Although the defense doesn't have to say anything about whether they do have witnesses until after the directed verdict.
And
Nothing-
technically, they had one. Remember,
They already had one.
Wally was
Wally.
called out of order, so they
Right,
have had
yeah.
one.
They have had one, and whether or not they're going to have anybody else, we simply don't know. We don't have witness lists. We don't have access to witness lists, and the judge hasn't let anything out of the bag. And I'm sure, you know, whether or not he even lets the prosecution. Sometimes in California, you don't even have to tell the person who your witness is until like 7 o'clock the night before you're putting the witness on the stand. And sometimes not even then. You know, you carry. It depends on what the judge has ruled in this and whether he's you know, require them to tell their witnesses 24 hours in advance who's going on the next day or not.
Yeah.
But the defense does not have to let them know whether or not they're going to have a next witness or whether they are putting a case on. So we'll see.
Why
You know?
is that? Because a trial is a living, breathing thing. That's why. You
This
just
is
never know. So
This is true. And you may have a witness that you thought you were going to have on, and then you say, you know, I'm looking at that jury. We're winning. They've had enough. Let's not get them mad at us. You know?
or you may have a witness that was supposedly the girlfriend of the chief witness, and she has a colorful history, I guess, and she's disappeared. So you never know.
Or she's decided you know, it was one thing when he said she's there and she's over there. She's just out of view of the thing. And she's like,
She's right there. By that, I mean, over there.
Yeah.
She was right there.
And her lawyer is saying, you're not going on and saying that. You're not, you know, you're not going on and saying that. You're taking the Fifth Amendment. You have no, you know, duty to testify here because, you know, if you testify, you know, you could be charged with perjury. And why would you want to help either side in this case at this point?
Nope. Not something you want to get involved with if you can avoid it.
The $30 million knuckles. I like that. I like that characterization. $30 million knuckles. Yeah. Cash.
Well,
remember the second one with the cash.
That's 10 million per knuckle, because only the three knuckles were
oh, that's
scraped.
right. That's
Not
right.
not the fourth one.
I wouldn't want to know why he'd come with 40 million or 50 million. I wonder if there was like a news article that said whether or not at some point whether or not ASAP Rocky was worth 30 million or something like that.
I don't know. Yeah, it might be a percentage deal, because I don't think even Relli's dumb enough to think I'll get everything he has, but he might think I'll get a percentage. That's a percentage.
Well, except that Neil Rockin' Neil, as I'm calling him Neil Rockin'. I've changed. I've dropped in the D from his name. Made a good point. That's the thing that Relli said at one point. He said when there was a pause in the action, I didn't think it was going to be like, you know.
I remember that. Like, somebody told me that I'd be putting up with all of this. Maybe I would have, you know, thought.
Maybe I just asked for $1 million and got on my way. You know,
you know, and that could have happened, and that actually could have happened.
That could have happened, yeah.
Yep, in his words, I just want this to be over.
Yeah, right.
Oh man,
We're still monitoring the judge.
Are we?
They're not back yet. They're still not back yet from lunch. Huff, huff,
Boy.
huff, huff. All right. But if you don't have any more questions, we have 98 of you on. Stay on. We'll just run the card here. Let's see. Okay, I do. Jenny, I don't know if anyone heard of it's with Ian Kellen, right? I don't think it was Runkle. I think it was Rumpel of the Bailey, right? If you recall, he is against tool mark analysis. Yes, it's junk silence. Yes, he is very smart. It was very funny. It was a very funny, and I'll tell you how I know it, and you'll know this. She who must be obeyed. Remember that? That was his wife. That's what he always called his wife. She who must be
obeyed.
Oh, must be
I
obeyed.
see a note here from Dizzy, which confirms some of the timing we've been talking about here. The 21st is the new deadline. Originally, it was the 11th, but I know he begged for more, and that part was denied. So I have it right on the 28th for the response by the prosecution. So again, all of that on March 4th. That's when the fireworks will be launched in the full-throated defense motion.
Okay, so I think we'll get off. We'll let the card play until they come back and stream. That will give you a chance of all to use the restroom and all.
I got to go do some more snow. I got to get some more snow.
You can do some more, and then we'll be back on at 7 tonight.
And then Missy,
right?
I'm going to go lift some weights. All right, so I can do that and then do some snow. Then we can come back on later. Okay, that's it for me. I'm.
All right. See you all later. Bye. Relli never going back to the scene, right? To supposedly
Not
get
seen on the
child
video.
casing.
Yes,
Not seen on the video. The officers didn't think he was on the video. Then they thought, well, if that he could have been on the video, it was only 2 minutes, but that really wasn't him. And now we have the fact that they know that he was shooting a Glock in both New York and New Jersey. And we've heard all of that. So the case agent is like, to me, when I was listening to the case agent, I was like, where are we going here? Including the search, 25 people to search A$AP Rocky's house to find guns that he legally owned and guns that were owned by other people,
Right.
which means that even if there is a magazine for a Glock there, it could have been owned by somebody else, not just him. But anyhow,
Could have been. First, before we move on, thanks to Here Comes Drama, gifting the Justice Served membership. We appreciate that. And before we move on, one question we didn't quite get to that I want to do before we get into the Rocky stuff.
Okay.
You can't die from someone yelling at you. I'd be dead most of my life, allegedly. Maybe. I think probably says what we all believe, right? Anyway, so that was sorry, a little side trip.
No,
Let's get back to Rocky.
No, that was great. I mean, I'm going to keep saying boo every time somebody comes around the corner. And God forbid it's in Massachusetts, because if they die, I guess I'm going to be charged with manslaughter, and I'll have to call you guys. Yeah. So let's get back to Rocky. Let's bring Neil on.
There he is. I found him. Hey, Neil. How you doing?
Hey.
Hey, you got more dressed up for when Linda's here. What's the deal? What's up with that?
Still no Chanel and
well, no, that's
I know. I made the comment the other day that I had big shoes to fill. In the meantime, I recognize I probably have much bigger feet than Linda, but I'm sure that my shoes are not nearly as nice.
No,
Well, yeah. But Michael's now wearing red shirts. Pretty soon we'll see Michael in red Louboutins for men.
I don't know. I don't know about that. I don't know about
He's
that.
trying to match the chair. Red, red and red. Right.
Yes, exactly. Yes.
All right. So, Neil, we have a
Yes.
question, and you guys are going to talk more about this than I will. Why won't the judge issue, or will the judge issue, a directed verdict on this case? I mean, that's certainly a way to save the prosecution if you think that this case is marred, especially when the guy wants $30 million. But, to get that bag of $30 million, you got to have a lawyer, because or else they call it extortion. So I just go back to that. It's whoa. That's all I can say.
You know what's interesting? So what's really interesting is that the most significant evidence in the case came from John Lewin's cross-examination of Wally, who was essentially testifying about audio tape that he made with Relli that Relli said wasn't him and was AI. So John Lewin did, look, we all, John is a bulldog. He's certainly an aggressive prosecutor. But he went after Wally. And in some ways, if you were just reading the black and white of it, it could be considered at times that it was compelling at times. The challenge is the jury reacting to it? And does the jury care? Because does the jury care? And again, I'm not saying whether Lewin, that he did a bad job cross-examining Wally, but he's cross-examining a witness who was called to literally say, I didn't manufacture and fabricate these videos, these audio recordings. So he spent a half an hour, maybe longer, an hour or 2 hours, whatever it was, cross-examining Wally, drilling in that Relli said this, Relli said that, Relli said this. But Relli himself, who's the state's witness, said, that was AI, it wasn't me.
All right, we're back on the record. We're outside the jury. Right before we broke, we asked the court reporter to find out whether Siegel, objection, Your Honor, it assumes a fact not in evidence. Overruled. Mr. Siegel then said it would just mean that they didn't have a video. I then said, overruled, no speaking objection, overruled. And then you said, Your Honor, can the jury? And I said, no editorializing by anybody. Ask another question, Mr. Procedural.
Your Honor, that was a comment that conveyed to the jury that there was potentially video that they didn't have. It's not just a speaking objection. Courts basically sustain the objection, and what it is.
No, I said overruled.
Whether it's...
All right, so what is it that you want? You are focusing on minutia.
Judge, what I want is I want the unethical conduct to stop.
Stop. Both of you knock it off.
Talking about from day one, Judge. I mean, that's...
Knock it off. Enough. Stop, Mr. Lewin.
What are we going to do, Judge?
The objection was overruled. You're focusing on minutia.
You mean a speaking objection where you're working out something for the jury?
What do you want me to do? Tell me what you want me to do.
Judge, you've instructed repeatedly that there's a difference between a speaking objection when you're trying to even communicate a legal reason. That's not even a legal reason. That's basically shouting out a fact to the jury. It is, Your Honor, we've had in this case time after time after time, and what happens is, unfortunately, the conduct doesn't result in any inconsequence. So, Your Honor, again, what I asked at the time was, I just wanted the court to, when the comment was made, I wanted the court to say to the jury, that comment should not be made and you're disregarded.
No, I'm not going to do that. I'm not going to do it.
All right.
Both sides have been making speaking objections.
Judge, we have not one time in this case, both sides at points have made speaking objections where they've tried to clarify a point of law or say, here's why the question. We have not one time made a comment like that regarding evidence. And we're not in a vacuum, as the court is aware from conversations that have been had. I'm not making this point in a vacuum. The court knows exactly what I'm talking about, and so does the defense. And there's a point where we just had it. It's not right.
The jury's going to be told that a question by an attorney is not relevant. It only applies meaning to the answer. There was no answer to the question. This is minutia. This doesn't amount to anything. I don't want to take any more time about this. The jury is waiting outside. The jury can come in. I need response. No response is necessary.
Yeah, no.
Yeah, well, they said
All right, we are back on the record. All parties, jurors, and counsel are present. Mr. Rihanna is on stand, and
Thank you. So when we broke, right before we broke for lunch, you told the jurors about your background and education and training in this area. And I believe we left off, you mentioned that in this case specifically, you were asked to conduct what's called a type and caliber analysis of 2 fired cartridge cases that you looked at in the lab. Is that an accurate summary?
Yes.
Okay. In order to illustrate some of the topics that you're going to be discussing today, did you create a PowerPoint presentation that addresses the type of exam that you did and illustrates the various terms that are going to come up throughout this examination?
I did.
Okay. Now, I'd asked to mark my next exhibit, EBD 43, with Mr. Brima's PowerPoint presentation. Can you see it on the screen?
This
let me turn on your little screen. Let me make it easier. So you don't have to constantly turn around. Good.
Yes.
All right. Is this the presentation that you created for this case?
It is.
We go forward to slide number 2. Can you tell the jurors what we see on this slide?
Sure. Well, in the course of this examination, there's a few different areas of basics that will, I think, help the jury understand the fundamentals of what we're talking about, and then actually the conclusions at the end of the examination. These topics are separated on this slide. They include firearm identification, cartridge components, pistol discharge, type and caliber determination, evidence features, ghost guns, and my ultimate findings.
Okay. We go forward to start with the first topic on your list, which was firearm identification. If you would tell the jurors what generally firearm identification is.
Yes, so within forensic science, there is a large discipline called tool mark identification. So this is simply the practice of looking at marks that are caused when a harder object impacts a softer object. Sometimes those marks can actually give us information about the objects involved. Firearm identification, what most people would call ballistic comparison, is really a subset of tool mark comparison, in which that tool is actually a firearm.
You talked about different types of tool marks. Can you discuss that just a little bit more for the jury? What it is that you're looking at when you do a tool mark identification examination?
Yes. Well, the tool is simply the harder of the two objects in forcible contact. The reason we use that word is because this is often performed using hand tools like chisels or bolt cutters. If they're used in many different types of incidents, property crimes and such, they can leave marks on items that they've come into contact with. Those types of marks vary. There's 2 different general types. The first is an impression. An impression is straightforward contact between the harder and softer object under pressure. The striation includes that contact, but it also includes lateral motion. So essentially, an impression is a dent, and a striation is a microscopic scrape mark.
Okay. Can you talk to the jurors how this relates specifically to firearms?
Yes. Well, the discharge of a gun releases immense pressures. It does so quickly that we often don't think about it. The pressure you use to actually inflate a tire is maybe on the order of 35 pounds per square inch. A 9mm Luger cartridge, when it discharges, releases pressures around 35,000 pounds per square inch, or PSI. These are just immense pressures, and they slam ammunition components into the gun. And that's the forcible contact that we're talking about during a firearm identification tool mark generation.
You talked about term in my head. Fire ammunition components. Would a cartridge case be, or a cartridge be one of those ammunition components?
Yes, a cartridge case is part of a live round of ammunition or a cartridge. That's one of the types of components that we examine.
Okay. If you would, I want to talk in more detail about the cartridge specifically and its components. Go on to the next slide. Would you explain to the jury the cartridge?
Yes. So a lot of times people will say to fire a gun, you've loaded with bullets. That's not exactly true. What you need is a round of ammunition, also known as a cartridge. The top left image there, you see an actual photograph of a few cartridges. And in the larger portion of this diagram, there's a simplistic diagram of one round of ammunition. It has a few different parts. The first part is that cartridge case. It's a brass cup that essentially holds all the other components together. Jammed into the mouth of that cartridge case is the bullet. This is the actual projectile that's going to travel from the gun towards the target. Within the cartridge, you'll see some grayish material. This is the propellant or gunpowder. And at the very rear of the cartridge is the primer. This is a small metal cup. It contains some shock-sensitive explosive. When this primer is struck by a portion of the gun, called the firing pin, it explodes, causes the powder to burn very rapidly. At this point, the cartridge sort of functions like a champagne bottle being popped. The bullet is going to leave the cartridge like the cork from a champagne bottle. The cartridge case, that brass cup, is going to remain in the firearm at least for a period of time.
Okay. Moving on to the next slide. Can you explain to the jurors the different parts that we see here in slide number 10?
Yes, slide 11.
Sorry, my apologies.
No problem. It essentially is just showing you another depiction of what we just spoke about. So here we have two live cartridges on the outside of this photograph. Each of those is ready to actually be loaded and fired. Just inward from those, you'll see two cartridges of the same types, which I've actually pulled apart. So here you can see at the bottom, there is the cartridge case, that gold-colored round item with the writing on it that's facing us. The primer is in the center of that. The grayish black powder material there is the propellant. That's actually going to give the discharge its pressure. And at the very top of the center of the photo are two different bullets. These are typically going to be copper wrapped around a heavy lead core, and that's the projectile that travels through the barrel towards the target.
Okay. Now let me understand the components of the cartridge. I want you to explain to the jurors the discharge process, if you would. Let me get to the next slide. Can you describe for the jurors what we see here?
Right, so here we have a simplified diagram of a cartridge that's positioned within a semi-automatic pistol so that it can be fired. The cartridge is located in essentially a tube called the barrel. It holds that cartridge and it will guide the barrel bullet as it exits the gun towards the target. This cartridge is in the unfired state and it's ready to discharge.
And you said this illustration specifically is of a semi-automatic handgun, correct?
Correct.
All right, I'm going to click it, and it will show us sort of the actions or what's happening within the gun at the time the trigger is pulled and the cartridge is locked, correct?
Correct.
Okay. Can you describe for the jurors what the action was or what we saw in the motion on that animation?
Yes, so the first cartridge has discharged. The propellant burned and the bullet went down the barrel towards the right side of the image. At that same time, that pressure is actually going to be harnessed by the mechanism within the gun. It will cause the top of the gun, it's called the slide, to recoil, to move to the rear. This is going to use some of that energy from the first cartridge that's fired in order to prepare the gun to be fired again by a second pull of the trigger.
Okay. Would you describe the kind of bluish tinted area that we see in the handle of the gun there?
Yes, so that's depicting what's called a magazine. This component will actually be inserted inside the grip of this type of firearm. Magazine holds rounds of ammunition, stores them within the gun until they're ready to be fired. Essentially, it works like a Pez dispenser, if you're familiar with that, without the plastic head. So it's a box, it's got a string in the bottom, and it pushes the cartridges towards the top. When the first cartridge fires, the top of that gun reciprocates, you saw it move. This allows the gun to first remove the extended cartridge case from the chamber where a live cartridge needs to be positioned to fire a second time. It reloads that chamber with the top cartridge that's in the magazine, and it also resets the internal mechanism of that gun. When we say that a gun is semi-automatic, that specifically means that every time you pull the trigger, one cartridge is fired. It's going to function like a Windex bottle. I can hold the trigger all day, no more ammunition is going to be expended. So that is semi-automatic, as opposed to full automatic would function like an aerosol can. I hold the trigger and it will continue firing until the source of ammunition is depleted.
When you talked about the expended cartridge, that's the piece of the cartridge case that's left in the gun after the bullet comes out for what would be essentially a fraction of a second, correct?
Yes, that's the cartridge case. That's the brass cup. It's depicted in gold color on these particular diagrams. And that is the part that will be expended and ejected from the chamber.
How does that happen? How does it eject out of the gun?
Again, this is one of the functions that the mechanism is doing when it harnesses that energy. After discharge, there's a small hook in the gun called an extractor. It's going to pull that cartridge case out of the chamber rearward from the barrel. It's going to hit another implement called the ejector. At that point, it's going to be flipped out of the gun. It essentially will appear like if you flipped a quarter as hard as you could towards your right shoulder. So that extended cartridge case will be cleared from the gun and remain in the vicinity typically.
And is that action that you just described consistent among all semi-automatic firearms?
Yes, to fire a semi-automatic gun, such as depicted here, more than once, you will have to clear the chamber of that expended cartridge case. It's a necessity to fire multiple.
We've covered this a couple of times, so if you would just briefly talk about what the distinction between that action would be versus a revolver.
So a revolver uses a different mechanism. You may have seen these in Western type movies. Rather than having a magazine and a single chamber, there's a part called a cylinder. This is a cylindrical component that can be loaded with a number of cartridges. That component will then be rotated, bringing each cartridge in line with the barrel one by one, so that each can be fired. After that cartridge is fired, the cartridge case in a revolver will remain in the chamber of that cylinder until it is manually extracted and ejected from the gun.
Okay. We move on to the barrel of the gun. When you talk about what happens in the barrel when the gun is discharged.
Right, so this is the portion of the gun that's most interesting to a firearm examiner during discharge. So I just enlarged that to the barrel. The rear part, you can see it's specifically made to accept that cartridge. That's the chamber. The entire device runs off of pressure. So the rear of that barrel has to be closed off. This will be accomplished by a surface that's called the breech face. It's illustrated here in that bluish green color. In the center of that breech face, there is a hole or a channel that allows the firing pin to protrude and strike the cartridge and initiate the discharge.
Now, specifically with the examination you did in this case, would you agree that a lot of the information that you were looking at comes from that area around where the breech face, the aperture, and the firing pin are?
Yes, a great deal of the information for cartridge cases in general, and in this examination in particular, will come from that portion of the firearm.
Because it's important to this examination, would you just highlight with the pointer exactly where those three different features are? The breech face, the aperture, and the firing pin?
Sure. So the breech face is going to be the forward surface of this blue block that's simplified for the purposes of the diagram. You'll see this channel that's meant to depict an opening in this solid breech face. The very opening forward portion of that channel is called the firing pin aperture. It's just the name we use for that hole, the opening. And depicted in orange, this simple cylindrical implement is the firing pin that will be propelled forward, strike the primer, and initiate discharge.
You said in your examination in this case, you looked at two of those fired cartridge cases, those brass cups, as you talked about, correct?
Correct.
You did not specifically evaluate any actual guns in your examination in this case, correct?
Correct.
So how is it that you were able to see any of the information that would come from the gun, meaning the breech face, the firing pin, or the aperture, if you didn't have a gun and all you had was that brass piece that was ejected from the gun?
Right, so again, this is an effect of those immense pressures and forces that are involved in discharge. Someone about my size stepped on a soda can. I'm exerting, I believe it's about 5 pounds per square inch. You can imagine that surface of the street could then cause dents into that soda can. Here we're talking about pressures in the order of 35,000 pounds per square inch. These are acting on surfaces of the cartridge case, which are not much harder or much different than you might find in the soda can. This allows just huge amounts of information to be imprinted into the material of the cartridge case, allowing type and caliber determinations to occur, giving it a job.
Okay. Look forward to the actual discharge process. Can you describe what we see on slide 19?
Sure, so it is depicted that firing pin coming forward, slamming into the primer, initiating discharge. Once that bullet has moved to the end of the tip of my finger, it is moving at the speed of a commercial jet, and it's rotating now at maybe 60,000 to 80,000 rotations per minute. So a great deal of energy has been released. The bullet's on its way out of the gun through the barrel, and pressure is slamming that cartridge case into the surfaces of the gun. This allows that firing pin to leave an impression. The firing pin aperture itself can be impressed into that primer with such a force that we can see the actual imprint, and also breech face markings. The small imperfections of that breech face can actually be impressed into the surface of the cartridge case, just as you would impress a fingerprint into a lump of clay.
Okay. This is an illustration that you have on in slide 19, correct?
Yes.
Did you put actual examples of these different components, the breech face, the apertures, in your presentation?
There are, yes, some exemplars. There's only one, I believe, that's related to this case. These images, such as the firearm you're seeing, are unrelated examples.
Okay. What specifically are you showing here in slide number 21?
So what you just saw was a gun that's slowly been disassembled to show you the internal parts that are going to be in contact with the cartridge during discharge. We're looking on the left side of the image. We're looking rearward at that breech face. This is the surface that will close off the back door of that barrel, the tube behind that live cartridge. The area, main area, is tinted blue there. That is the breech face surface. You look towards the center, you'll see a dotted line. I just added that dotted line around that opening. That opening is the actual firing pin aperture. And within the opening, you'll see an orangish, sort of elongated implement. That's the firing pin. On the right side of that diagram, you'll see an illustration of the types of marks that we'll talk about. The blue area, that circular area, is the primer. It's a soft metal where that explosion happens on the other side of it. Marks from the breech face can come over. You'll see that dotted line outlining the firing pin aperture, and an actual impression into the material from the firing pin striking and causing discharge.
Okay, you said the illustration or the animation of the gun slowly being taken apart. I'm going to just go back so we can follow what you were showing. It goes by a little quickly, so I'll play it again.
Sure, so the top is a slide and barrel. Now I've taken the slide and the barrel apart. Here we're looking at the slide, which has that breech face surface within it.
Okay. I'm going to go on to slide number 22. Would you describe what you're illustrating here?
So a typical firearm identification task will often include what we call an actual microscopic comparison. I'll use an instrument to look at the tool marks on two items such as cartridge cases with the aim of trying to determine if they are fired by the same particular source. You could come to an opinion that they were fired by the same gun, or an opinion that they were not fired by the same gun, meaning they've been eliminated. That information is typically most useful when there is a gun in evidence. So here we just sort of depicted that there's a firearm. Test fires from that firearm can be compared to the two evidence cartridge cases connected with the dotted lines down there. The cartridge cases depicted in different colors are sort of just indicating that sometimes the features of those actual marks will be sort of an apples and oranges situation. And we can tell, even without looking at the microscopic markings, that they were fired from different guns.
You said what's displayed up here would be an identification that you could make if you had a gun to actually compare the fired cartridge cases to, correct?
That's when it's most useful? Yes.
If you hypothetically had received a gun in this case to compare to the two fired cartridge cases, could you determine scientifically if that particular gun that was provided to you was the one that fired these cartridge cases?
I could perform a side-by-side microscopic comparison on a comparison microscope. If the marks are of sufficient quality, it may allow me to come to the opinion that, yes, the reason for the agreement of those marks is I'm of the opinion that they were fired in the same gun. Conversely, it could lead us to the opinion that they were not fired in the same gun.
That was my next question, was if you were provided, hypothetically, if you were provided a gun to compare to two fired cartridge cases, you could also definitively say, looking at these individual marks, that that gun was not used to fire those cartridge cases. Is that what you're saying? Is that correct?
Yes. There's identification, same gun. elimination, they were not fired in the same gun. If there's any deficiencies with the items, we can just say inconclusive, meaning I can't give you any definitive.
Okay, and that's if you have a gun. But if you don't have a gun, what are you looking at? In a case like this, or what you would call a no gun?
Right, so you can perform that comparison with two cartridge cases collected in the same area. But again, it does not tend to give you much additional information. What we will tend to do, if you just had two items collected at a crime scene, for instance, is perform what's called a type and caliber determination. So here we would be trying to characterize or describe types of guns which we know to produce marks, such as those that we see on the evidence.
Okay. Which gets into the analysis that you did the type and caliber, analysis, correct?
Correct.
Okay. Let's talk about let's talk about caliber first, or how you do these types of analysis.
Right, so this is basically reiterating what I just discussed. So type and caliber, we're leaning towards trying to determine two different groups of information. First, the caliber, the specific type of ammunition, the size of ammunition that the unknown gun is intended to fire. And then we will actually look at the marks on the exhibit to see if we can begin to list some brands of firearms which we know to produce similar marks.
Okay, when you're looking at fired cartridge cases, is it difficult to determine what the caliber is?
Cartridge cases, it is not so difficult. They have a portion on the rear of the cartridge case surrounding that primer that typically has what we call a head stamp, meaning that the manufacturer has stamped in usually some identifying information about who made the cartridge, and also the caliber of firearm is intended to be used with.
Okay. Moving on, can you describe the illustration you have here in slide 27?
Right, so this is just to get a sense of that type and caliber examination. Imagine that you have a clean kitchen floor and 30 seconds later you have a muddy footprint right in the middle of it. Something we're just instinctively going to do is look at the basic size of that footprint. At this point, we're probably going to narrow it down to some of your family members as opposed to others. You could look closer into that footprint, and if you see a particular design that is typical of a particular brand of shoe, this can further narrow sort of your list of suspects in your household. Type and caliber determination is essentially you're just doing that same process, but we're doing it using ammunition components, which is a little bit of a different exercise.
Okay. Just following your illustration of the muddy shoe print, are you saying that if you were to look at a muddy shoe print on the floor and see that it was a smaller size, you may eliminate that, oh, it was an adult that contributed to this footprint because it's too small to be an adult shoe, something like that?
Correct.
All right. And then if you have multiple children in your household, are you saying you could look at the pattern of the muddy footprint and say if my son wears Converse but my daughter wears Reeboks, that you could eliminate one just based on the pattern that you see in the mud?
Right, and you're using patterns that are common to other Converse shoes out there. You aren't linking it to one particular shoe, but you're able to sort out this list of limited suspects.
So if you have 3 kids and 2 of them were Converse and one of them wore Reeboks, you could eliminate the Reebok, but you wouldn't be able to distinguish between the 2 Converse. Is that kind of what you're saying?
Right. You've narrowed it to 2 potential culprits and eliminated one.
Okay. Let's go on to talking about caliber with cartridges.
Okay, so caliber is another term that people pick up from movies and TV, but it has a specific meaning. So if you were to pick up a flashlight in one aisle of a store and a battery in another aisle, you're going to select the proper compatible items based on that size system. For instance, you're going to pick a AA battery. It allows you to match up the right battery with the right flashlight. Caliber is a similar system for ammunition. It's a matchmaking system that allows us to put the right ammunition into the right type of firearm. So saying a gun is of a particular caliber is like saying a battery is of a AA size.
Okay. Going on, are there common calibers that you see in your laboratory?
Yes, there are hundreds in existence, but most of the work that we actually see day to day will come from a relatively small grouping, maybe 20 to 24 different calibers that are commonly encountered in a crime lab.
Okay. Talk about caliber, and talk about type. What do you mean when you say type in a type and caliber analysis?
Right, so it's kind of a vague term, but what we mean by type is that even when we're looking at these marks, even very simple implements like that firing pin are very carefully designed. That specific design may be common to a group of firearms. So by examining the imprint of particular features, we can begin to associate a mark with a group of firearm brands which we know to produce similar implements.
Can you describe the different, well, describe first what a class characteristic is and then what the different class characteristics are when you're talking about cartridge cases?
So a class characteristic is a feature which is going to be common not just to one item, but to a class or a group of items of a similar design. So a particular shape of firing pin may be common to firearm brands X, Y, and Z. This group of X, Y, and Z is a smaller, more restricted group of the potential brands out there. When we do a type and caliber analysis, we're using these features. We call them class characteristics. When looking at a cartridge case, some of the most important class characteristics will be the caliber, the shape of that firing pin aperture, as well as the shape of the firing pin itself.
And again, the aperture is the hole that's in the breech face, correct?
Yes, it's like the donut hole in that breech face, and that actual shape can be impressed onto the discharge cartridge case.
And the firing pin is the piece that strikes the primer that, as it strikes it, it also leaves an imprint of the shape of the firing pin?
That's correct.
Okay. Can you talk about the class characteristics you see up here?
So this is just sort of illustrating that process of narrowing our candidates. So we begin with the caliber. At the bottom left, this is just an image of a cartridge from the laboratory. You'll see at the center that circle is the primer, and you'll see writing impressed to the outside of that primer. That's called a headstand. It's placed there by the cartridge manufacturer. And simply by reading this headstand, also comparing the basic dimensions of that cartridge case, we can determine the caliber of the cartridge. So this particular one is a caliber called 9mm Luger.
Okay, the next class characteristic?
Again, to describe that hypothetical firing pin aperture, this is a laboratory gun. We're looking at that breech face. The dark circle in the center is that hole, the firing pin aperture. The firing pin is going to protrude from that hole upon discharge. And the shape of that hole may vary. Some of the shapes that we commonly run into would be round, which is pretty generic, a rectangular shape, or sometimes even a teardrop-shaped aperture.
Now, when you talk about caliber, to the right of the word caliber there's 5 boxes that each have a number and some letters below it. Are those common calibers of cartridge cases that you see?
Right, so this is just illustrating a hypothetical, but these are 5 different common calibers. They usually have a very specific name that can be shortened and placed onto a cartridge headstand.
So a fire cartridge that you'll see will have a caliber associated to it, correct?
Yes.
And then it will have the aperture shape, which will be is more than likely to be one of those 3 shapes that you have listed up there, correct?
Very commonly, yes.
Okay. Sorry. Can you describe what you're showing with this next illustration when it comes to the aperture shapes?
Yes, so at the bottom of this illustration, we have images of 3 different cartridge cases, and these have accepted that imprint of the aperture shape. So at the right-hand side of that image, you'll see a dotted line outlining a circular aperture. In the center, the dotted line is outlining that rectangular shape aperture. And at the left side of the image, you'll see the dotted line that's actually in a teardrop-shaped configuration. So these are just examples of the different shapes that we'll be assessing.
Each one of those 3 is a different example, just showing the different shapes that you can see in 3 different guns, correct?
Yes.
Okay. The last class characteristic you talked about was the firing pin shape. Can you describe that for the jury?
Sure. In the bottom right, this is actually a magnified image of a firing pin. It's about the size of the tip of a ballpoint pen. This particular one is round or hemispherical. It's a very common shape of a firing pin. That round outline will then be imprinted into the cartridge that firing pin discharges. Again, there are different types that are commonly found to be manufactured by different brands. These again would be round, rectangular, and teardrop shaped. The aperture and firing pin shape do not have to match. So these different combinations give different classes their distinctive features.
So I just want to put a finer point on that. Just because the aperture of a firearm is round does not necessarily mean that the firing pin itself is also round. It can be a different shape.
Correct. It's up to the manufacturer, and they can combine those as they see fit.
Okay. All right. And then do you have examples of those different, what those different firing pins looks like when you look at them in the laboratory?
Yes. So these are the same images. Here at the center, you'll see a depressed area that is then outlined with a solid yellow shape. So at the right side, you'll see that the outline of the actual firing pin that was pressed into the surface is round. In the center, it is rectangular. We may also call this elliptical. And on the left-hand side is a more distinctive shape, that actual teardrop shape that can be caused by the firing pin itself.
Okay. Go on now. You said you actually did an examination in this case of 2 fired cartridge cases, correct?
Correct.
When you are assigned to do this type of analysis, a type and caliber analysis on fired cartridge cases, what's the first step that you take in the laboratory?
First step is to obtain the evidence. It's going to be actually stored with the property system. I'll go check out that evidence, bring it up, log it into our computer system, and perform an inventory of the evidence package.
In order to check the item out of property, how is it that you do that? Is there some number associated with it?
Yes, each investigation at LAPD receives a number. This has been called, for most of my career, a DR number. I think it means Division of Records number. This is simply a number that identifies a particular investigation. Evidence that's collected associated with that investigation will be filed under that DR.
In this case, was the DR number 2106-18784?
May I refer to my notes?
Yes.
Thank you. 2106-18783.
All right. When you went to property division, did you obtain the envelope that we see here that was previously marked People's 32? And let me freeze that up there. Bring it to you if you need to inspect the envelope yourself.
Thank you. Yes, this is the envelope that I received.
Okay, and how is it that you recall that this was the specific envelope you received?
It bears the DR number as well as the number 1, meaning it is item number 1 booked to that DR number. On the back side of the envelope, it has my initials, my stylized initials, my serial number, as well as the date that I opened the package.
Okay, I see it. What I have frozen up on the screen there, is that the front side of the envelope?
Yes.
And putting up the back side, are these the initials that you were referring to?
Yes.
All right. Take out the smaller envelope. I'm going to show you the back side of the smaller envelope. You need to approach because the tape's constraining it, let me know, but did you receive this smaller envelope as well when you did your examination?
Yes, it bears my stylized initials and information.
Are they up here just below the tape?
Yes, that's where I marked the envelope when I opened it.
Okay. Then lastly, we take the 2 items out of the smaller envelope. Up here. You can approach with these, if you would. You tell us if these are the fired cartridge cases that you examined in this case.
Yes, their external features match the features that I documented. And there are also engravings on the inside of the actual cartridge case. When I receive evidence, I will engrave it with the item number, portion of that DR number, my initials and serial number inside the mount of the case where it will not obscure your marks.
So that you know later that they're the same ones.
Yes.
Okay, I'm going to put them back. Smaller envelope. Back in the larger envelope of People's 32. So after you received that envelope and those specific cartridge cases, what's the next step that you take in your examination process?
So the next step is going to be filling out some worksheets with the basic observations and features that are observable on those items. Both of these were booked as item 1, so I did designate one of the 2 as item 1A, the other as 1B. Then I documented the material and general features that we will systematically do in the opening stages of an examination.
Okay, and then the next step after documentation, what did you do?
So that point would just be to sort of classify those actual markings that were observed, the aperture shape, the firing pin shape, and these are just outlined in preparation for the interpretation part of the actual analysis.
Okay, so you talked about in your prior testimony looking for those 3 class characteristics, the aperture shape, the firing pin shape, and the caliber, correct?
Yes, among others, but these are the most prominent and useful.
Okay. So is that what you're talking about when you look at them in the laboratory? You're documenting each one of those class characteristics.
Yes.
All right. So let me go back to your presentation here. Now you're going to start talking about the specifics of this case, correct?
Correct.
All right. Let's start with slide 40. Can you describe for the jury what we see here?
Yes, so the photo at the right side of this slide is a digital image that is from the computer database system. It's called NIBIN, N-I-B-I-N. This was taken before my actual analysis, but it's a good depiction of what I was looking at. In this picture, I've got the numbers 1, 2, and 3 there. So first, I've categorized the actual caliber. It is a 9 Luger caliber cartridge. Looking at the imprint on this of the aperture, I classified that as teardrop shaped. Looking closer into that actual depression in the primer, I classified the shape of the firing pin as also being teardrop shaped. So in the bottom left, there's a simple diagram outlining those features that I observed.
Okay. All right, let's go on to the next area. If you would describe sort of the value of the class characteristics that you observed, that information you just talked about.
Right, so now I'm beginning the interpretation stage of the examination. That first stage, here illustrated on the first line next to the one, is the determination of caliber. That was 9mm Luger. This is very common. In our lab, it's the most common caliber that we run into. So while that is interesting, it narrows our pool of candidate firearms to some extent. It's still a very common feature. Down at line 2, I'm then going to move to begin to interpret what does the teardrop-shaped aperture mean. How does that allow me to further restrict the list of candidate sources?
Okay. Let's move on then. If you would talk about after you document those 3 features, those 3 class characteristics, what's the next step that you took?
So at this stage, it becomes a bit of a research project. I'm using literature from my field in order to get the broadest list of known candidate sources with a teardrop-shaped firing pin aperture. The left side here is depicted just a couple of articles that I used. These are from the Journal of the Association of Firearm and Toolmark Examiners. This is a peer-reviewed journal that's been in print since 1968, I believe. A few of these articles started me down that path. There is also an electronic forum that's operated by AFTE. It's available to AFTE members, AFTE, Association of Firearm and Toolmark Examiners. This is an electronic exchange for professional examiners in a members area of the AFTE website. It allows them to interact and exchange information about new observations that they have in casework. And this is more responsive than the actual articles. We can disseminate information quicker by those means.
And these were the sources you used to kind of determine how big the pool was of potential candidates to compare to those 3 features.
Correct. I'm just looking for a list of suspect guns, if you will, brands which we know to include just that one feature, the teardrop-shaped firing pin aperture.
Okay. So it was specific to the firing pin aperture.
Correct.
All right. Let's move on. What was the next step you took?
The next resource I used is called the Class Characteristics Matrix. This is a developing database, also operated by AFTE. It allows me to just, you may enter different features, such as caliber, and firearm pin aperture shape. I did so in order to try to broaden that list of potential makes known to the community to produce teardrop-shaped firearm pin apertures.
Okay. After looking at those resources, what did you determine was the potential list of firearm manufacturers that could have contributed to that aperture shape?
Right, so from all the manufacturers operating, the list that is known to me as a result of consulting these sources comes down to just a list of about 5 different manufacturers. So we've narrowed that candidate group considerably just using that one feature. These images there are logos or images depicting those 5 sources.
Okay, so you went from 9mm, very common source, to now whittling it down to 5 manufacturers, just with the aperture shape, correct?
That's right.
Okay. If you would talk about the kind of next step in your research project.
So moving from the aperture now to the actual firing pin. At this point, it becomes a little more challenging because the firing pin that I'm looking at in this case just happens to be quite distinctive. Fortunately, several months before the occurrence date of this case, I initiated a project where I collected samples from firearms that were coming through the firearm unit. We regularly test fire pistols that come into LAPD custody to be entered into the NIBIN database. I collected 229 different firearms examples, and these are specifically what we call ghost guns. It's a new sort of phenomena of firearms. By examining the samples from those this sample set, I was able to locate a few species that actually exhibited the firing pin consistent with the one that I observed in this case.
The teardrop shape, correct?
Teardrop-shaped firing pin, correct.
Okay. And when you add that class characteristic to your analysis, so now you've gone from caliber, you've narrowed some out with the aperture shape, and now you've added in those that have the same aperture shape and this unique firing pin shape. What were you left with?
Right, so I'm left with the logo there you see on the left is not an actual manufacturer, it's just representing what we call ghost guns. So there's one particular aftermarket slide which is common to a particular frame size of ghost gun. That particular product exhibited the firing pin shape that I observed on the evidence. It also has some compatibility with frames that are produced by Glock.
Okay. Before we talk about ghost guns, you mentioned NIBIN. Would you describe for the jurors what that is and how you used it specifically in this case?
Sure. We may be more familiar with DNA databases. Samples from a crime scene may go into a database. Samples from suspects will also go into the database. The computer will attempt to match samples and potential suspects. We have a similar database in firearm identification. This is called NIBIN, the National Integrated Ballistics Information Network. So when we have a group of evidence cartridge cases, such as the ones in this case, we can enter it into the system and attempt to look for potential matches among tens of thousands of candidates that are in that system. At the conclusion of my examination, I took the actual items that were previously imaged into the NIBIN system and had them correlated again. This means those images of our evidence were searched against the database again in order to see if I could find any other makes of firearms depicting that particular firing pin shape.
You described using the AFI resources, or the resources from your association of other tool market examiners. would NIBIN essentially have been kind of like a double check to your research that you did on the API resources?
Right, so the API resources, I'm trying to expand my list of possible candidates. I expanded that list, and those resources also told me what types of firing pins I expected to see. I didn't just take that at face value. I went, looked through NIBIN in order to attempt to confirm whether those resources were accurate. According to the samples that I looked at on this database, they were as advertised or published in those resources. Finally, I used NIBIN again as a second sort of double check, putting our actual evidence in and seeing if there are any other brands I'm unaware of that had similar marks.
Now let's talk about ghost guns. You used that term a couple times. If you would describe what a ghost gun is.
Sure. Well, this slide sort of depicts I guess, mainstream way of manufacturing and distributing firearms. So they're typically made by a licensed manufacturer, shipped to a retailer that has a federal firearms license, and they're sold to us in the public from that retailer. So that is how typical guns are distributed. I say guns of typical manufacturer as opposed to the species that are commonly referred to as ghost guns.
Okay, moving on to that. Can you describe what you are illustrating here?
Right, so the ghost gun species uses a frame that is the portion you're going to grip. This is the part that needs to be serialized and controlled if it is manufactured and shipped to you, the consumer. Ghost guns use a product that is an incomplete frame. It requires you as the consumer to make just a few adjustments, drill a few holes in order to make that frame operational. You can order these over the internet. You can also order what's depicted there. The frame here is in that pink color. You're also going to need the other firing components, such as the slide and the barrel. These can also be ordered online. Then, using simple hand tools, as most of us would have in our garage, these aftermarket parts can be assembled and to produce a functional gun. Now, this gun does not have a serial number in that state, because when it was shipped, when the frame was shipped from that manufacturer, it was shipped in an unfinished condition, which did not require it to have a serial number. This is where the term ghost gun, I think, has taken hold, because it does not have that serial number that's known to law enforcement.
You talked about three parts of the gun, and you said the pink part that you have illustrated up there is the frame. What are the other two parts? The gray rectangular shape on the top and the kind of orangish cylindrical piece underneath the pink part.
These are the main other components. Okay, so the pink part is that frame. That orange tubular shaped item is the barrel. That is where you load the cartridge, and that's where the bullet's actually going to travel, go towards the target. The gray object at the top of this image, that's the slide. It contains the breech face and the mechanism associated with the firing pin. Marks on the cartridge case are primarily coming from that component, the slide component of the firearm.
And are you illustrating that you can essentially purchase these individual pieces separately? So you could just buy a frame if you just wanted the frame?
Correct. You could buy the kit that can be used to produce a frame, and then the other components can be purchased separately from various retailers.
Okay. If you already have a working firearm, but you want to exchange a piece like the slide for the frame, can you do that by removing a piece and then adding an aftermarket piece?
Yes, you can. Just like my car has a license plate, it's licensed, I can change the rims on my car. I can buy aftermarket ones and slap it on there. That's what we're essentially allowed to do with these components of the gun outside of the frame itself.
Okay. One. I think you already described they can be assembled using hand tools. What are you illustrating here in slide number 5?
So this just illustrates a couple actual products that are out there for privately made firearms is one of the terms. The slang is goes with. These products show some tooling that can be used to actually complete the manufacture and make the kit, which is sold into a functional frame that can be joined with a aftermarket slide and used as firearms.
You said there's 2 brands that are illustrated up there. What are the 2 brands?
These are 2 very common brands. One is at the bottom center is Polymer 80 with the P80 logo. There is another brand, the firearm is marketed as an SS80, and that's depicted in the top right portion of the slide.
Okay. All right, moving on. Would you discuss kind of the manufacture or the features of some of these ghost guns?
Right, so this image is depicting the fact that these kits are produced to mimic a typical gun that's already in mainstream production. So there are 2 actual models here that are listed there. On the left-hand side, there's a SS80 is one. There's a PF9SS. That's another. These 2 particular ghost gun frames are compatible with a particular model of Glock, and that Glock is called a Glock 43. So they are made to be sort of imitation frames of that Glock, and they're compatible with those aftermarket parts which are also compatible with that particular model of mainstream manufactured Glock.
So when you were first explaining to us how, kind of the origins of what a ghost gun is, you contrasted that to a gun that came from a licensed manufacturer. Am I stating that correctly?
Yes.
Would the Glock 43 being produced by the Glock Firearm Company, would that be what you're talking about as being produced by a mainstream licensed manufacturer?
Yes.
And the ones that you have listed here on the left, the Polymer 80 PF9SS and the Glock SOR SS80, would those be the ghost gun versions of a Glock 43?
Correct. These are the privately made firearm or ghost gun versions of the frame of a Glock 43.
Made to mimic a Glock 43?
Yes.
Okay. All right. What are you illustrating here?
So here it showed one set of aftermarket parts just illustrated there. The markings I found on these evidence items can be linked to a particular aftermarket slide. This particular aftermarket slide is known to be compatible with a few models of firearm frames. These include the Glock 43, 43X, the left-hand side that's depicted by that dark black colored frame. On the right-hand side, the pink frame is representing the ghost gun equivalents of that Glock frame, which may be marketed as the SS80 or PF9SS.
In your explanation just now, you said the evidence items that you examined. Are you talking about these cartridge cases that were item 1 in that exhibit People's 32?
That's correct.
Okay, and you're saying that the class characteristics that you saw on these cartridge cases, those 3 characteristics, that it was 9mm, that it had a teardrop-shaped aperture and a teardrop-shaped firing pin impression. Those are the characteristics you were using to narrow it down to these 4 types of firearms?
Yes, that grouping of class characteristics is known to me through those resources. I've only been able to associate it with this one particular aftermarket slide. And this aftermarket slide is compatible just with a few styles of guns. The known brands and models are listed there.
Those 4, right?
Yes.
Okay. Well, let's talk about your finding, or the conclusion to your analysis. Have you summarized your conclusion on this slide, people's 59? Go back to.
Yes. Final conclusion. What you're not going to find in the report, I cannot say this configuration only comes from brand X. What we know is that after some considerable research, I can give you the list of candidates that we know to be consistent with these items. While these are consistent, we cannot really say that these are the only ones which will ever be manufactured with those general features. Due to that, the qualifying term, but not limited to, always appears in type and caliber findings, such as the ones I've used here.
So why is it, again, that you put that qualifying statement in your analysis? Because, correct me if I'm wrong, but you stated 9mm is a very common caliber, correct?
Yes.
But at the end of your type and caliber analysis, you really narrowed it down to those 3 features were only really typical of 4 different firearms that you have seen come through your laboratory, through your research on the AFI resources, and cross-comparing that with NIBIN. Am I stating that accurately?
Yes. Based on the research that I've described, I have only encountered empirical evidence showing me that this grouping of class characteristics exists as a consequence of that particular aftermarket slide. That's all the information that I could determine after some relatively considerable evidence.
But you don't limit it to just those 4 firearms, fair to say?
Correct. You can't state that it's those 4 and only those 4, because these class characteristics are voluntarily chosen by the manufacturers. They can change. It's also possible that there are other items out there that we have not run into. Any research material I use is finite. So for that reason, we include that qualifying mark to be overt.
But after your research in this area, you narrowed it to 4 that you, those 4 different firearms were the only that you could find that had those 3 class characteristics among them, correct?
Objection has an answer.
I'm sorry. Thank you, Your Honor. That's correct. I'm only aware of the aftermarket product that's compatible with those 4 models.
Okay, that's all I have, Your Honor.
All right, we'll take a 15-minute break, folks. Please be outside the courtroom doors at, let's make it 3:20. Please don't discuss the case.
prosecutor. But he went after Wally. And in some ways, if you were just reading the black and white of it, it could be considered at times that it was compelling at times. The challenge is the jury reacting to it? And is the jury care? Because does the jury care? And again, I'm not saying whether Lewin, that he did a bad job cross-examining Wally, but he's cross-examining a witness who was called to literally say, I didn't manufacture and fabricate these videos, these audio recordings. So he spent a half an hour, maybe longer, an hour or 2 hours, whatever it was, cross-examining Wally, drilling in that Relli said this, Relli said that, Relli said this. But Relli himself, who's the state's witness, said, that was AI, it wasn't me. So
That's not a lie, right?
Well,
That's a lie.
It's clearly a lie. And the interesting question that comes out of it is, can the state pull back? Can it, when I was talking to Michael the other day, we were talking about if you could assign value, numerical value to a witness, if there's only 100 to be gotten total, what would you give Relli's testimony and his credibility? 1 is the worst you can get. So if you're the state and you start off with your witness at a 1, the best you can do to try to pull that witness back from the 1 yard line more towards the center is to cross-examine the heck out of somebody who, in cross-examining, you have essentially proven that the witness was lying. I mean, all the cross-examination did was show that these guys are, maybe neither one is ultimately reliable, but only one of them is the one that the state has to hang its hat on.
Yeah, we kept talking
about the directed verdict point is that I wanted to just tell you that what's so interesting is one snippet where Joe asked the lead detective again and said to him, is there any evidence on that video of a gun being fired, of a weapon being discharged? And the answer was no. And this is a case not about possession of a object that looks or is fashioned like a weapon, or an object that looked or appeared and seemed like a weapon. This is a discharge of a firearm at somebody case. And you got a lead detective saying, I don't see any evidence of it on that video. We have no evidence of the slugs, no evidence of the shells, no evidence of bullet holes in a fence, in the ground, no ricochet in a nearby car. So, it begs the question, when the police found out about this case, did anybody go back and even attempt to find anything at all that you're telling me, if there was a bullet hole out there, nobody went back to go look for it or find it. Nobody found one. So there is very little that pulls Relli's testimony back from the depths of between the 1 and the 10 yard line.
Yeah.
That was
the
the question we had, was that, let's assume best case scenario, he's worth 10 points, as a witness. Who is going to lift him up in a case where his testimony is, in my opinion, the only testimony that's going to mean much in the long run? None. So Torres, he's not saving the day. I just don't know. Linda, who's coming in to rescue this case?
Nobody. I think the lead detective. I think that Joe converted him to. I don't know why they waited him for last. I mean, I think Joe converted him into the defense witness. To me,
defense witness. That's
the ultimate witness.
And by the way, for those who don't know, that's the ultimate compliment you can pay a defense lawyer, is taking a state's witness who was put up there with the intention to help to sink the case or to make the case for the state, and converting that witness to your own witness. And I thought Joe really, from what I saw, did a pretty good job with the state's witness.
What I thought was good too about the cop was he seemed very even-handed. He didn't sound like he's there to promote the prosecution or the defense.
Wasn't trying to push an agenda.
He's what I call a dragnet witness.
So one of the things that you get out, which we don't give juries maybe enough credit. I just had a case that just finished where the jury literally said to the prosecutor after the jury was out 10 minutes and then acquitted, went back and talked to the jury, and for a minute just to thank them. And the jury turned to the prosecutor and they were like, what were we doing here? This was like a waste of time. Now, I'm not saying that shootings are a waste of time, but when you take it together, Relli went back to the East Coast. He went back to the East Coast for medical treatment, allegedly. He has wounds on his knuckles that look like he scraped the ground. His wounds are less serious so than I've gotten if I happen to brush my arm up against some, a brick wall. They do not look like a bullet graze. How would, and Linda, you would know this better than anybody, you and certainly your husband, Michael, how would a bullet graze all of the knuckles, right?
Right.
I mean, how?
It's a miracle, Neil. It's a miracle.
I mean, you can't even, I mean, maybe I'm getting old and I'm a little arthritic. I can't even get my knuckles to align in a way where my forefinger and knuckle and my, I mean, how?
It looks like a punch. I mean, to me, it looked like he fell, and scrape, whatever.
To the
It's
issue of the
ridiculous.
directed verdict. So
Okay.
this would be a saving.
Let's explain to our viewers what a
Absolutely.
directed verdict is.
Okay, so a directed verdict is at the end of the state's case, the defense can move for a directed verdict. And what the standard for a directed verdict is exceedingly high. It's as high as it gets for a judge to grant it. It is called a directed verdict of acquittal. It is essentially the judge looking back at the case and saying, I look at the evidence that the prosecution presented. I take it in a light most favorable to the prosecution. That usually is the death knell of directed verdict motions. Right. But saying that I look at it in the prosecution's best case. I take their very best case. I look at it and I decide whether or not this case a reasonable juror or any reasonable jury could find in favor of the prosecution based upon that evidence. They are very rare. I'm sure Linda's won more directed verdict motions than me.
No. I don't even think I've won one.
What's that?
I don't think I've won one.
I had one, and it was
career, right?
There were like 8 counts, and we got one out of
the 8. That I've
the
had.
Prosecutor wanted.
Yes,
this is the kicker, then, and the prosecutor wanted to appeal. Wanted the judge said, I'm granting a directed verdict on count 13, and that was the toughest count for my client, and we were all high-fiving, and the prosecutor goes into, hey, Judge, you need to, Judge, I want to stay it. I want to argue it some more, and I want to stay it, and I want to go to the Court of Appeals. And we were like, sorry, man, that's double jeopardy. The judge has directed a verdict of acquittal. It's not like you can't stay it and appeal it, at least not in Michigan. So if the judge, are there some facts, and this is something for your viewers to analyze, are there some facts taking away, looking at the state's evidence in its best possible light? Does the state have any case at all? Just be in its best possible light.
I think the only way you get there is if you believe that Relli was not lying. Because if he comes off as having lied about so many details in this case, then you can't get there. You have to believe that somehow he's telling the truth sometime when he's talking about the details of the incident, and he's lying at other times. And the court's going to have to make that decision that no reasonable juror could find that he was truthful about the facts of this case.
Now, it's not even just truthful, that believable. Let's say believable versus truthful, right? Because the standard is, could a reasonable jury find Relli believable beyond a reasonable doubt? Forget about truthful. I prefer to say believable, because believable, that there's a standard there. Is he believable beyond a reasonable doubt? So here's my question. I am aware of only a couple of cases, and I was trying to quickly try to find them as we began our conversation just now, where judges have made findings that witnesses, and typically informants, where a judge has made a determination that a witness is just not believable is so unbelievable that he can't even cloak it in the witness has the in a light most favorable to the state. And Michael, I take your point to sort of mean that, which is, it's not like Relli was caught in a couple of lies or a couple of misstatements about one point. He flip-flopped back and forth. You would have to carve out little pieces of his testimony and then attempt to glop it together and say that it's believable. That is a very tough, that's going to be an interesting test for the judge. I assume that's how Joe's going to argue it. I'm interested if that's going to be an interesting test for the judge. If he sticks to the traditional, I'm going to let the jury decide, then he's probably going to deny the motion for a directed verdict. But if he's surgical about it, if he really wants to get into it, and he thinks that Relli lied to the jury, like that's another question. If the state's witness lied to the jury, and the judge believes that the state's witness lied to the jury, can you send the case? Because now it's a concession that the witness lied. If the judge concludes that, can you send that case to the jury?
And that's where I'm having an issue here. Even when I can understand they took the case, okay, although I think I'd have certain problems taking the case when somebody comes and says, I want 30 million, and then comes and says, I want 30 million, give it to me in cash because, I got to do it through a lawyer to get that bag, and I'll disappear. So the prosecution will never find me, right? I'm going to disappear, and they'll make it very difficult to you. But I think you get to the point where aren't you suborning perjury if you are a prosecutor? Or isn't that a consideration you have to think about? And if you're a judge and you think that this witness lied over and over again on the stand, how can you as a judge then let even a jury decide it? Don't you have to take it away from the jury and say, no, I'm not going to let this go? And our reporting has indicated through double sourcing 2 different times that the judge at first had some questions to the prosecutor about whether they continued the case because of ethics and whether they could continue the case. And we stand by that reporting. Now, let's assume that's true. There's people arguing that, no, he wouldn't have said something like that. But let's assume that's true. If the judge has had that, and now we see Relli lying, and we've all agreed they lied. The whole AI thing, lie. I mean, it's not me, because he knows he doesn't want to be seen as extorting money, right? How could a court let this go to a jury?
So the way that you obviously framing issues is very important. I think the way that you frame that issue, Linda, really is probably the best case for the judge pulling the plug on the case, which is that if there's a concession or it's clear that the witness lied a number of times, lied about something significant in the case, and how can you, it's indisputable that the witness lied if that's the position and the judge felt that there was a question. Let's again, just assume, again, I wasn't there, just assume that the judge did raise that issue with the prosecutor. The judge raises that issue, then essentially saying, well, I'm going to let the jury decide, means that at one point you're thinking that this could be an ethically challenged prosecution based upon someone who's committed perjury on the witness stand. But at the same time, you're going to let a jury decide the case. That is that's a conundrum.
Yeah, I would not want to be wearing the robe in this particular case. And we talked about it, Neil, how it really, the prosecution in a way should be hoping that he does that, because it really lets them off the hook and protects them from whatever might come in the way of misconduct charges or an investigation. Then they can say, well, the judge did that.
What's interesting, though, is you have 2 different, and you guys have commented on this a lot, and I've heard you've been, I think, very complimentary about the style and approach of the lead prosecutor, who comes across having the attitude of someone who is, hey, I'm just here to put my case on. I'm going to put it on. Whatever happens, happens. I'm sure he has a belief about the case, but he's not twisting anything, right? He's just believable, likable, that's really, in my opinion, the best type of state's attorney to have is someone who's believable and because they represent all of us. They represent the entire state. So if he's doing that, the question is, you know, would he think that is acceptable? Now you got John on the other hand. John is,
It's Mr. Lewin, the John Lewin.
I mean, Mr. Lewin, I mean, John is pressing ahead. I'm just going to go back to, I think a directed verdict in some cases can have the effect of taking a lot out of the hands, taking it off the prosecutors. Hey, you gave it your best shot. You gave it the case. You tried. You put forward your best case. It's not your fault. Your witness stunk. So, but I'm not going to put the defendant, you know, I'm no longer going to hold him in jeopardy for this. Directed verdict of acquittal. You're also telling the jury, like, look, this.
All right, just to let you know, folks, we're going to start at 10 o'clock. 10, not 10:30. We're back on the record. All parties, jurors, and counsel are present. Mr. Siegel, Berger, thank you. Yes.
Good afternoon, Mr. Firearm.
Good afternoon.
You're employed, you said, as an analyst by the Los Angeles Police Department.
I'm sorry?
You're employed as an analyst by the Los Angeles Police Department. Is that right?
That's correct.
Okay. And specifically, you work as a criminalist in the department's firearm analysis unit?
Yes, I have for 20 years. Technically, my assignment has just recently changed. But yes, I operated as a criminalist in that unit during this examination.
What's your assignment now?
The toxicology laboratory?
Okay. Which obviously has nothing to do with ballistics.
Correct.
Okay. But in your prior role in ballistics, you were asked to examine the 2 9mm shell casings that we've been talking about, right?
Yes.
Okay. And you prepared a report containing your opinion regarding that analysis, right?
Correct.
And you finalized that report on January 8, 2024?
May I refer to the report?
Please.
Thank you. Yes, the technical and administrative reviews were completed on January 8th, 2020.
More than a year ago.
Yes, 1 year ago.
Okay. Are you aware that your report was only provided to the defense counsel, meaning us, 2 weeks ago on January 23rd of this year?
Objection, Your Honor. Irrelevant.
Sustained.
Let me ask you this then. When did you provide your report to either the detectives or prosecutors in this case?
Once it was signed off, I would email it to the requesting officer, so that should have occurred in January of last year. I don't know the date that I actually emailed.
Okay. Would it have been signed off on by, let's see if I see the name here, someone with the last name Harbison?
Correct.
And who is that?
This is another Crim 3 in the Criminalist 3 in the Firearm Analysis.
And what's that person's full name?
Amanda Harbison.
Is she a supervisor of yours?
No, she is another technical lead. We have 4 details in the firearm analysis unit. She is a criminalist 3 technical lead in one of the other details.
Okay. And she signed off on this report after you on January 8th, 2024?
That's correct.
So it would have been around that time that it was provided to the detectives in this case. Is that fair to say?
Yes, it's my habit and custom. As soon as I get it back, just go ahead and email it out before I submit the case package for filing.
Now, you were asked by Mr. Preslomic on direct if you evaluated any actual guns in this case, and you said, no, you did not do that. Is that right?
That's correct.
Right. You also did not examine those 2 shell casings to specifically determine if they would discharge from any particular magazine. Is that right?
The cartridge cases
Yes.
were not compared for cycling marks to a particular magazine. That's correct.
Okay. And as a criminalist, you're certainly aware that there is, you made a reference to this now, a forensic evaluation available to determine whether shell casings were fired from a specific magazine. Is that right?
They aren't fired from a magazine. So what we're talking about is a cycling mark. This means just basically based on the fact that a live round can be pushed through the magazine into the gun. It's possible for marks to be distributed onto it without the discharge pressures, but it's not a typical examination that we do on a daily basis.
Right.
Your Honor, I'd like to launch the objection to get approach.
No, Your Honor,
It
just
goes to
state
a floor
the
two.
objection.
It goes to a 402 of the court previously ordered.
You can't say it in open court, Your Honor. You need to do it, sir. Yeah, this, we did cover this. So this is off limits. I do recall now. This is off limits. No.
Let me continue. No. So, in firearms analysis, class characteristics are general features shared by a group of firearms which are used to try to narrow down possible firearms that could have possibly fired a bullet. Is that fair to say?
Yes.
Okay. And those class characteristics do not identify a specific gun. Is that right?
Correct, as the name sort of implies, they indicate a class, a group of guns that may share a particular feature.
Right. And in contrast, individual characteristics, why don't you tell us, what are individual characteristics?
So individual characteristics are unintentional flaws that actually are created when the firearm is manufactured, also as it wears or corrodes over time. These microscopic flaws are pretty amazing because we can actually take guns off the assembly line and distinguish marks from guns even when they're manufactured one after the other. So these are individual characteristics that we would use in a traditional, I guess, microscopic comparison.
Thank you. So based on that, then, is it correct to say that class characteristics place an item within a category, general category, while individual characteristics can uniquely identify a specific item? Is that right?
That is how we intend to use them. Yes, the individual characteristics can be used to form an opinion of common origin, meaning that the examiner has determined it's their opinion, they agree because they were fired in the same gun.
Right. And in this case, you didn't look at individual characteristics, right? You just limited your analysis to class characteristics. Is that right?
That's correct. For type and caliber analysis, that's the procedure.
Right. You looked at those class characteristics to try to narrow down the possible firearms that could have possibly fired these 2 shell cases. Is that right?
We're looking for evidence of known guns that produce similar marks. And we attempt to produce that list because it can be advantageous.
Advantageous how?
It can eliminate whole groups of guns, especially calibers. There's, as I testified, there's a great number of calibers out there. We can immediately sort of push those off the table as potential sources. At the same time, we can generate a list that may be of interest should a gun of that make come across an investigator's desk. It should sort of let them know that it's possibly useful to pursue additional examination and leverage.
And what you just said was that you do this examination to eliminate, your words, potential sources for the cartridges, right?
The class characteristics
Yes.
will eliminate a great deal of sources out there. Even our most common set of class characteristics are still eliminating huge numbers of guns.
Sure. And the purpose of eliminating those potential sources responsible for possibly firing a shell casing or a cartridge is to leave open other potential sources from which those shell casings derive. Is that fair to say?
Could you repeat that? I think I lost it.
Sure. You're eliminating potential sources for the shell casings, right?
Sources that are apples and oranges, don't have the same class characteristics, they will be eliminated.
So
That's
yes,
correct.
my question is correct. Yes?
That's correct.
Okay. And the reason you're eliminating those potential sources is to leave open the possibility of other potential sources from which the shell casings came.
Yeah, logically, that's correct.
Right. Okay. Now, what you did was that you looked at the shell casings and you determined that they exhibited these general class characteristics, the ones you talked about. Is that right?
Yes, there are cartridge cases. I don't think we're going to mistake what you mean, but yes.
Okay. You understand that when I'm referring to shell casings, what they've been referred to throughout this trial, I'm referring to cartridge cases. Do you understand that?
Yes.
Okay. It is okay if I continue to refer to the shell cases?
Please, I don't think it creates any misunderstanding.
Thank you. And you determined that the class characteristics that you saw were consistent with having been the shell casings discharged from a number of different aftermarket firearm slides. Is that right?
They are known to have come from a particular style of aftermarket slide made for a particular size frame.
Well, in your report, you noted that the shell casings, this is page 1, exhibit, these are your words, characteristics typical of aftermarket slides for a series of subcompact pistol frames. Is that right?
That's right.
Right. And then you identified a number of potential frames that were consistent with the characteristics that you saw. Is that right?
The frames don't create the characteristics. So the frames are compatible with the slides, which I know to be consistent with the characteristics.
Appreciate you saying that. Thank you for clearing that up. And to be clear then, you're not comparing the characteristics with firearms themselves. It's the aftermarket firearm slides that you're using for comparison purposes. Is that right?
Yeah, I'm sorry, one more time.
Sure. You're looking at these class characteristics and determining that they are consistent not with actual firearms themselves, but with the particular part of the firearm, the aftermarket firearm slide. Is that right?
The slide of the gun is where these marks originate.
Right.
So that's what we can associate or evaluate.
Right. I think you just clarified, not the frame itself, but the slide that goes on top of the frame.
Yeah, that's exactly
All right. And in particular, with regard to the class characteristics, you observed that the shell casings in this case have a teardrop-shaped firing pin aperture. Is that right?
That is correct.
Okay. And the firing pin aperture, you spoke to this, right? It's really sort of just it's a hole in the breech face of the slide where that firing pin passes through. Is that right?
Yes.
Okay. And you also observed that the shell casings have a firing pin impression which is also shaped like a teardrop. Is that right?
Correct.
And You said that the firing pin impression also has a metal injection mold seam. Is that right?
It appears to have a linear mark that we associate with that particular manufacturing process, yes.
Okay. And just dealing with that first then, the metal injection mold, and that's simply just a line left in the firing pin from the manufacturing process. Is that right?
Correct.
Okay. And the firing pin impression, you spoke to this, that's just a mark that's left on the primer, the fire cartridge, when the firing pin strikes it in the back, right?
Yes.
Okay. Now, after making your observations of the shell casings, you searched, you alluded to this, various databases for categories of I guess, firearms and firearm slides that exhibit those general characteristics. Is that right?
That's correct.
Okay. And in particular, you searched, what is it, the AFD website, class characteristic matrix, that is called?
The class characteristic matrix, yes, is a search tool on the AFD website.
Okay, and the AFD, AFTA, that's just the Association of Firearm and Tool Mark Examiners, right?
That's correct.
Okay. Now, you looked at that database, or rather, you looked at, in addition to the AFD database, you looked at the database within your own firearms analysis unit, and that's the NIDIC, is that right?
Yes.
Okay. And in addition to those databases, you also searched the firearms analysis units, your own units, ghost gun collection of 229 discharge cartridges. Is that right?
Yes, cartridge cases. Correct.
Now, I think we spoke of this, but after conducting your search in the databases and making your observations, you rendered an opinion that the class characteristics that you observed on the two shell casings were seen in certain aftermarket slides for firearm frames, which included the Polymer 80 model PF9SS. Is that one of them?
That is.
The Glock model SS80. Is that right?
Yes.
The Glock model 43, right?
Correct.
And the Glock model 43X. Is that right?
That's correct.
Okay. Now, is it fair to say that this process that you talked about, looking at firing pin apertures, firing pin impressions, and determining whether they look like, in this case, teardrops or D shapes or semicircles, it involves some level of subjectivity?
Yes.
Right. And in fact, that's why sometimes multiple people have to make determinations regarding how a firing pin impression or firing pin aperture should be characterized, right?
No.
No. Okay. So in determining whether or not, you just said this, determining whether the firing pin impression or the aperture looks like one type of shape or another, if it fits into a hemisphere, I think that's one type of D shape, one type of firing pin aperture, right? Hemisphere, is that one?
Hemispherical is the more accurate term for something I just called round.
Round. Okay. Is there a semi-hemisphere?
I don't know that term. No, there's one that is sort of a modified hemispherical shape that has sort of a beveled edge on one side, but it's not really called semi-hemispherical. It's been referred to as a D-shaped firing pin.
Okay. But in making the assessment, I think you said this already, there is some level of subjectivity.
To looking at shapes?
No, to determining what the shape is, right? In other words, these firing pins aren't standardized, right? You have how many different manufacturers making these firing pins? They're not going to be one particular shape, right?
They all make firing pins, yes.
Right.
And they
Different shapes.
use a range of different shapes.
Right, essentially a broad range of shapes, right?
At least three.
Okay. And in making the assessment whether or not a firing pin is one shape or another, you said this already, there is some level of subjectivity to this, right?
Yes, to looking at shapes.
And in that regard, that level of subjectivity doesn't just apply to you, but to the people who enter information in the databases that you rely upon, right? When they're entering information into the computer system, the same level of subjectivity that would apply to you would apply to them, right?
Sure.
Okay. Now, you identified these 4 pistol frames that would be consistent with the class characteristics that you observed, but you'd agree that those are not the only ones having aftermarket slides exhibiting the characteristics that you observed, right?
Not exactly. So the marks are known to come from particular size of aftermarket slide. That slide is compatible with these 4 frames that I know. That was what is meant by the report and notes.
Your report expressly states that the 2 shell casings exhibit characteristics typical of aftermarket slides for a series of subcompact pistol frames, including the phrase we saw on the screen there, but not limited to the 4 that you identified, right?
Correct.
Okay. Now, your analysis relies on the databases that you use for comparison purposes, correct?
For reference purposes, it's not a side-by-side comparison of marks. Yes.
I understand, but sure. Now, obviously, certain firearm slides, or let me just back up on this, I want to make sure the record's clear. In order for you to make or render an opinion, you're relying upon databases, right?
Published information, yes. One database is what I would call it, that class characteristic matrix. That's a searchable database.
Right. That's the APT, correct?
That is housed on the APT website. Yeah, it's one of their tools.
Right.
Correct.
And you use that tool to enter in search parameters, I guess, the firing pin aperture of a teardrop shape that you saw, and it generated a list of potential firearms or firearm slides that match that characteristic. Is that right?
That use the same shape.
Right.
Yes.
Okay. And you'd agree that the databases that you looked at are still being developed, right?
The class characteristic matrix is definitely a newer one. I would call it a developing database. Yes.
And to be clear, the list of firearms generated from your search are not all inclusive of the firearms consistent with the class characteristics that you observed. Is that right?
It can't be considered all-inclusive because it's based on finite reference information.
Right.
It includes all the ones that we're aware of. It is possible that there are, always possible there's facts we are unaware of.
Right. And obviously, certain firearm slides or class characteristics are not contained in your databases. They wouldn't be available for reference purposes, right?
Yes.
Right. In fact, you testified on direct that there are other possible items you didn't locate which are compatible with the shell cases, right?
There are other possible items.
Your words. Did you say that on direct?
I don't recall exactly, but there are, you're talking about candidate sources that use this style of class characteristics. Is that what the testimony was about?
It's your testimony. Can you tell me, or you don't recall?
I don't recall.
Okay. So, would you agree that there are other possible firearm slides or firearms?
Objection to the word possible, Your Honor, in the court's final ruling.
Okay. Would you agree that there are other possible or potential, your words,
Potential is a better word.
fine, potential firearm slides or firearms that you did not locate which are compatible with the shell cases?
That's what I attempted to look for. I looked for them because they could be out there.
Right. And if they're not in your database, you would locate them, right?
They're not in the physical exhibits that we have in-house. What was great is that I collected those and then 2 years later double-checked against all the guns that had come into LAPD custody over that period. And either of those groups that are bookending the actual incident date came back with no other candidates that actually had that firing pin.
So when you say you examine them, are you talking about the database? Are you talking about your collection of ghost guns? Is that what you're talking about?
The exhibits that I collected from the test firing of ghost guns, the physical exhibits that, yes, are actually in the laboratory, that's one set of data.
Right, that's the 229 ghost guns that you have, right?
Yes.
Okay. How many different makes of aftermarket slides exist?
There are dozens of manufacturers. They are pretty hard to track.
Right. Dozens of manufacturers. Could it be hundreds?
It's possible.
Right. And each of these manufacturers can make how many different aftermarket slides? Do you know? How many different types?
How many actual units they can produce?
No, types.
Types per manufacturer.
You don't know, do you?
No, they tend not to actually mark these components,
Right.
so it is very difficult to track.
Right. And because you don't know how many different makes of aftermarket slides exist, you would know how many different makes of aftermarket slides specifically have a teardrop firing, an aperture, and a teardrop shaped firing. You couldn't know that, right?
Again, we treat it as an aggregate brand, okay, because we don't know who's actually making them. I try to cast a wide net and look at all the products I can get my hands on that they've made. I only was able to find one select species that was congruent with the evidence.
Right, based on what you can get your hands on, right?
Based on the intake into the Los Angeles Police Department, as well as that database, which is constantly growing. Correct, the NIDA database. It's constantly being fed.
Sure. And there's a reason that's still developing, right? Because you're looking for more information.
The developing one is the class characteristics matrix that is on the FD website.
Right.
I call that developing because typically we use a database of bullet rifling, and that's got like 15,000 exhibits in that database. It's been around for decades. That's a pretty robust database. This class characteristics database on that website that applies to cartridge cases is developing. So I used it to broaden candidates I might want to look at, but not as a resource that I would consider all inclusive at this stage.
Now, with regard to these aftermarket slides that have a teardrop firing pin aperture and a teardrop shaped firing pin, how many of them, let me rephrase it, how many firearms are there that are in existence right now, types of firearms, that are compatible with aftermarket slides with a teardrop firing pin aperture and a teardrop shaped firing pin? Can you give a definitive answer?
I can give an approximate based on my experience here in our flow of firearms into the LAPD. Is that sufficient?
And you would give an approximate answer without knowing all the different types of aftermarket slides that exist? You think you can give an approximate answer?
I can give an approximate based on how many in this group that we see relative to the total amount of guns that come into the unit.
Right. But those would be only the guns that are logged into your database. If they're not in there, you can't use them for reference purposes, right?
Those are guns that come through NIBIN on a daily basis. So it is part of our daily business just to have these guns that are handguns will be input into the system every day.
agree that Glock's a very popular firearm manufacturer?
I would.
Would it make sense that you find many Glocks in your database because of that,
Yes.
including Glocks with aftermarket slides?
They do come through the unit. Aftermarket slides, sometimes on lock frames, overwhelmingly more common on the unserialized frames we call ghost frames.
By the way, do you have any Glock firearms in existence in the United States now?
Objection relevance rule. Oh, Glock 43s.
Glock 43s. Thank you.
In the United States.
Sorry?
No.
Glock 43Xs? Yeah.
No. In terms of our intake,
No, in the United States, at present. If your intake doesn't intake every single firearm in the United States. How many exist in the United States? If you know, you don't?
I don't in the United States.
Okay. How about the Polymer 80 model PF9 SS Ghost Gun frames? Now, how many exist in the United States?
No.
How about Glock's model SS80 Ghost Gun frames? You know how many of those exist in the United States?
No.
Now, in addition to the ones we just named, the PF9SS, the SS80, the Glock 43, and the Glock 43X, your database search revealed other firearms with a teardrop firing pin aperture. Isn't that right?
Yes, as well as the published literature. Yes.
Right, such as Smith & Wesson, right?
Yes.
Mossberg, MC1SC, right?
I'd have to verify that model. It sounds correct, yes.
Okay. How about other Glock Generation 5 pistols? Did you find that when you did the search?
For the teardrop-shaped firing pin aperture,
Sure.
not the firing pin
It's a
itself.
firing pin aperture.
Yes.
In fact, when you did your search, that was the term that you entered in the query. You were looking specifically for just firing pin apertures with the teardrop, right?
That's for that one particular, the APT class characteristic matrix. That is the only feature that I entered. So that's only going to restrict based on the aperture.
Should the answer to my question was yes. That's what you looked for, right?
That's where I wanted to be clear.
Okay, thank you. And you agree that that teardrop firing pin aperture has also been found on a Taurus firearm, right?
Yes.
Right. Specifically the Taurus GX4, right?
Again, that model sounds correct. I can check my notes.
If you want, just so it's clear, it's on page 8 of your report, if you want to see it.
Yes, I'll return to page 8 of my case package.
It's the fifth result on the page.
Yes, the Taurus model with the teardrop aperture that I'm aware of is a model GX4.
Now, as you said, you observed on the two shell casings this teardrop-shaped firing pin impression. Is that right?
That's correct.
And you'd agree that the Glock 43 exhibits class characteristics which include a D-shaped firing pin impression, right?
Yes.
Likewise, the Glock 43X exhibits class characteristics which include a D-shaped firing pin impression, right?
The Glock manufactured slides. That's correct. They have a different shaped firing pin impression than the one that I observed.
Right. The teardrop shape is distinct from the D shape.
Yes, very much so.
So to be clear, the Glock 43 and the Glock 43X do not depict teardrop firing pin impressions that are even remotely similar to the shell casings that you examined. Is that right?
That's correct. It is the aftermarket slide, which is compatible with those two frames that you just listed.
Right. Not the Glock
That
40.
aftermarket slide does produce those models.
Right. But you didn't connect it to a Glock 43 or Glock 43X that you said are typically sold here in the United States, right?
That's correct. The standard manufactured Glocks
Right.
don't match.
Okay. So in other words, the shell casings you recover are inconsistent with the class characteristics of Glock 43 and Glock 43X firearms, right?
These slides manufactured by Glock and sold That is the part that does not match. The slides that are aftermarket, which are consistent, are compatible. The Glock 43 and the Glock 43X.
And the slides that are sold by Glock for the 43 and 43X are not compatible, right? The Glocks themselves, I'm not talking about aftermarket slides. I'm talking about Glock. You go to the store, you want to buy a Glock that's sold from Glock. Glock 43, Glock 43X. It's not your those shell casings did not come from a Glock 43 or 43X, did they?
They did not come from a slide that is manufactured by Glock,
That's what I'm asking.
such as I'm aware of.
Thank you.
When I say compatible, we are talking about the compatibility of a slide and the frame. So the frame is manufactured by Glock. The slide manufactured by Glock, they're compatible, they can work together. The slide manufactured by Glock does not, however, produce these models.
And for that matter, most of the polymer 80 model PF9SS and the Glock Store model SS80 samples that you looked at in your post-gun collection exhibited a D-shaped firing pin. Is that right?
Yes, it's a smaller group of those ghost guns that actually have this particular slide in my collection there.
And in fact, in your collection of those 229 ghost guns, only 2 Glock Store model SS80 samples exhibited both the teardrop firing pin aperture and the teardrop firing pin impression. Only 2 of them, right?
Yes, it's rare.
Yeah. So most of the PF9SS and SS.
Excuse me, I was just napping. Sorry.
I was gonna, buddy, you and I think alike. I was gonna say the same thing to you. I was gonna come out and be sleeping on the side. But, you know, since all of our viewers have been watching, we're gonna actually lower the tone of this. We'll monitor it for what's happening. But let me tell you what's happening. Nothing is happening. Remember I asked our viewers to look up how many Glocks are made, how many Glocks would be compatible, and they did, and they're gone here. And this is like, you know, if you don't have any evidence, you just put on a nice person.
Well,
you know,
I knew immediately that this was a nothing witness because who's doing the cross-examination?
not Joe Tacopina.
Not Joey T. So I'm sorry to second chair guy who I don't
Wait
know
a second. Wait. When I do the cross-examination, when I'm in the case with the triple chairs, they don't say that.
Are you in this case? You're not in this
no,
case.
I'm not in this
That's
case.
an exception.
No.
But clearly, with Joe running the show and everything we've seen him do, he's not going to sit back if this guy is important. He's not. He's basically just telling the jury doesn't warrant my time. And to be honest, he doesn't warrant the jury's time either.
Right, right. The jury's probably saying, "Oh gosh, rescue me, rescue me,
Yeah.
rescue
So
me." Hey, we have a show.
Yeah, we'll monitor that. We'll jump in if if Lewin does cartwheels or something else. We'll do.
Well, he did this morning. We're going to show it tomorrow. The clip that he did when he came back from lunch. He went crazy, and the judge told him, "Just sit down. Stop it, Mr. Lewin. Stop it. Stop it." And I kid you not, that was the judge.
No, I believe you.
My impression.
So we have a very special guest here, and it's going to get us into some areas that we've been talking about this week, but and not specifically related to Mr. ASAP Rocky, but of course, when we want to know what the hell's going on in Georgia, we got the go-to guy, and you know him, you'll love him. There he is, Doug Weinstein of now. Hey, Doug, what's the firm name? I want the brand new firm. What is it? Oh, I'm not hearing Doug. Hold on a second.
Muted. I'm sorry.
Here we go. Yeah, I got you now.
That's you. That wasn't me, by the way.
No, it wasn't. I'm blaming Missy.
Did you see? Did you see our little thing that we put up in the top corner, Doug, with your glasses?
No,
we made a little thing of you.
I like it. I'll take it. I'll take it. That's fine. Right? What?
We're trying to get you. We're trying to get you a contract with the glass company. Actually.
There you go. Talk to Pear. Talk to whoever. I'll take them.
Yeah.
I'll take it. Talk about second chairs. I was talking to someone this week that ran into a friend from across the aisle on the YSL case. And she was second chairing a case, not first chairing a case. So
really?
I don't know what's up with that.
That could not have been a demotion, could it? No.
I don't know. No. I don't know. Because
I hope not training somebody.
I know that Miss Willis came out, I'm sorry, Madame DA came out praising her. So
Oh,
To have her sitting second chair, that's stunning.
So
yeah.
we want to know if you got your we want to know if you got your invitation to Fonnie Willis's inaugural ball for $25,000 inauguration
Yes.
ball. Did you? You
Somehow,
really?
I don't know about that. I got left off that list. I think myself and Ashley were not on that list for some unknown reason.
Some mix-up.
Oh,
Some screw
wow.
up. So I don't know. I'm calling it Weinstein law for now because I have absolutely
Okay.
no.
Woo!
So that's
Yeah,
exciting. Congratulations. That's very
Congratulations.
exciting.
Terrific. Do you
Thank
have a
you.
website? Do you have a website you can
I
plug?
have like a kind of a placeholder website.
Yeah,
Yeah.
placeholder. Well, give us the
Place-
placeholder name.
It's weinsteinlaw.us.
Okay.
So you can find it there. All you folks looking for a criminal defense lawyer in Georgia, hopefully the metro Atlanta area. I'd like to travel a little less. I had to drive down to Tifton today, which is about a 3.5 hour drive for a
Ooh.
9 o'clock court hearing. So,
Oh, yeah.
Oh,
but we
that's
got bond. All right.
All right.
Hey,
Yeah.
yay, yeah.
Yeah.
Laudner
Clearly,
Amber
clearly
says
not
maybe
Fulton County.
Laudner and Amber said maybe some love happening in Fulton.
Yeah. So, I think there's some movement in Yak's case a little bit.
Good.
Not-
What's the latest?
I'm not going to tell you.
Okay. Well, thank you.
Not
Okay,
public
we
yet.
won't.
But check Odyssey later tonight, or even now. I don't know.
Okay.
Okay.
But
Okay.
I hear good things are brewing for him. So there's some movement going on.
Okay,
Which
we'll
is
have
great.
Our producers check right now and see what's good.
Y'all heard
I
it
mean,
here for
let's see. It's only been, when was the verdict of not guilty rendered?
December 3rd or 4th.
Yeah. So 2 months.
And it's only February 6th. Well,
Yeah, but I
Moving
saw
quickly.
him last week twice.
how is
He's in
he?
great spirits. He's in great spirits.
Yeah. Good.
He's not in Wright Street. He's in the South Annex. So
Oh, yeah. Okay, good.
it's a much less awful place to be. Yeah.
Well, we were worried about his safety staying in Rice Street after obviously the not guilty verdict was entered. I don't think anybody's
Right.
safe in Rice Street, but
No, they aren't. They aren't safe in Rice Street. So
Yeah.
you're going to have to do a show, and we can focus on the DOJ report on Rice Street.
I would love
Yeah.
to. We'd love to. As a matter of fact, we talked about early on, and we got so involved with the trials and why with your trial and all about the young man who was, I think, autistic and ended up there and then ended up dead. You know about the
talk
case.
to Rachel. You got to talk to Rachel Kaufman about that because it's
Okay.
she was representing him, and she may even be representing the family in a 1983 action on that.
Yeah.
Okay, writing his name down.
But again, something else involving Miss Love. But yeah. So there is some more news, and you want some just random thoughts, some random news in Georgia?
No, yeah,
There's
absolutely.
a version of the RAP Act is being introduced in the Georgia State Legislature.
Oh, wow.
And it is sponsored by a number of Republican legislators.
Wow.
Yeah.
Wow. I never thought I'd see the day.
Yeah,
That's
so it's got bipartisan sponsorship. And I'm not going to beat on it too much because I'm just going to let the legislators do their thing.
Yeah, that's great though.
But that's huge news if they can get that through. I'm working with the Georgia Association of Criminal Defense Lawyers, GACTL, on hopefully getting some changes to Georgia's RICO law. So my two hobby horses hopefully will get maybe some movement or beginning of movement of the state legislature.
Yeah, we mentioned the other day, we saw the group photo with Max was there, I think, and it was like it was getting the band back together. Right?
We were at a conference, again, a GACTL conference, and Brian and Keith were speaking to criminal defense lawyers. They're really inspiring speakers. And then afterwards, we had a group photo. So it was Shaquille Kokomo. It was Brian Steele. It was Keith Adams. Let's see, myself, the ugly guy, Max Shart was there.
You and Max, you're cute. You're cute.
Angela D. Williams was there. So we were missing the Matthews and we were missing Bruce and Nicole, but the rest of us just happened to be there. So yeah, we got a group photo.
That's great. Now, speaking of that is it's just great. I mean, it's just great. So maybe good things are coming as a result of bad things. We were talking today, and I want to get your comments about how we've seen this week a number of not guilty verdicts. We're seeing all sorts of. Michael calls it. What did you call it, Michael?
I'm not sure. What did I call it?
Not swinging of the pendulum.
We talked
Pride.
about a sea change. I think we talked
A
about a
sea
sea
change.
change.
Well, you know, did you cover? I assume you probably covered or at least tweeted out Brian and Keith's victory down in Brunswick.
Of
Well,
course,
that's what
and
we want
that's
to talk to you about. Yeah.
exactly.
That was a huge victory. That was and again, this has nothing to do with obviously the killers of Ahmaud Arbery were reprehensible, and they certainly deserve to have guilty findings against them, I think. But this was the circumstance where the state brought charges against the prosecutor, alleging that she failed in her oath of office and that she did something to obstruct the investigation. There were 2 counts, and Keith and Brian got directed verdicts, I believe, early on
The
the
misdemeanor, right?
yeah.
On the misdemeanor.
right on basically the obstruction type charge. And then what, 2 days ago or yesterday,
2 days.
they got a motion granted dismissing, and I guess it was a demurrer, is what I'm guessing. I didn't see
Right.
the motion. I'm assuming, yeah, a demurrer, which is, by the way, a demurrer for. I'm sure you've explained it to your audience, but I'll go ahead and do it again.
I tried last
we
night.
did.
Okay, but please let us know.
Yes.
The simple way that I try to explain a demurrer, and anyway, I love the term. It's such like an old law type term that we've tried to expunge from the law, right? We try to go to plain English. But anyway, a demurrer is where the defendant says, look, I can admit to each and everything in the indictment, and it is not a crime. And that is what happened. They said that she violated, the prosecutor violated the oath that she took in 2010, and the oath having certain criteria. Unfortunately not unfortunately, the indictment was very sloppy, and they charged her with violating her 2010 oath based on a change to the Constitution that happened, I believe, in 2018, 2016, 2018. So so the oath that she swore to in 2010 did not contain the constitutional violations that they say she breached or violated.
Yep. Good.
So the judge really had no choice in that case but to dismiss.
Yeah, I was talking about the demurrer in California. We actually use them all the time. It's an early in the process type maneuver. It's very seldom would you see it, in the midst of a trial. I had one once. You never go in thinking you're going to win them for the reasons you mentioned. It's basically, it's like a directed verdict. It's like a verdict, a judgment notwithstanding the verdict. It's a very tough standard. But I won one against against the state under Prop 65 in California, which is one of the everything causes cancer propositions.
Okay.
And my client was a chili making company, and they would spew. They would release, gases out their stacks, and they had done computer modeling to determine where it would fall, and therefore who would be affected, and potentially that was a violation of Prop 65. So we raised that on demurrer, and we won. And you walk out going, "Whoa, I can't believe that just happened." So
yeah, I think I'm guessing what happened here, and again, you probably know the details maybe more than me. I imagine that Brian did not file that demurrer until after the jury was sworn in, because if you wait till after the jury is sworn in, obviously double jeopardy attaches. And I think he did something similar in YSL, but he lost the demurrer in YSL. But if you're going to indict one of Brian's clients, Brian is going to scrutinize that indictment. And you better make sure you dot the I's and cross the. That's something that I've learned from him. Is like a lot of times I think criminal defense attorneys, we kind of blow off the indictment. We don't, but he'll look at every word of that. And here's the circumstance where he and Keith, I should say they and not he, they got their clients their case dismissed based on a defective indictment.
it's a great catch. Really.
Yeah, it's a terrific
really
catch.
impressive.
And I think, if I recall reading, that Brian spoke to Ahmaud Arbery's mom, and the judge spoke to both the jury and to the mom, that they thought what happened to the son, just awful. But that this was just not, it wasn't about there. And she was very gracious, saying, look, at least we got our chance in court to see what happened, and that it was all hanging out there. But let me ask you this. In something so important to so many people, how could they screw up? Okay. I mean, I'm not talking about Brian did a great job, but how
Yeah.
could an attorney general's office screw
Yeah.
up? And this is not Fonnie Willis, it's the attorney general's office.
Yeah. You know, in my experience with the, I've had a number of cases, even though I haven't been doing this that long, I have a number of cases against the state AG's office, and they are very good. The attorneys that work in that office are excellent. I think that the Attorney General Carr, who's running for governor, I think he's a really good Attorney General. So I'm surprised they messed this up, and I think it's one of those circumstances where they just don't think that the indictment is that important, and
Right.
they didn't really scrutinize it. I mean, sometimes you'll see it in civil law where someone is sloppy with a complaint,
Right.
because they just, it's notice pleading, right? You don't have to go into that much detail, and they can trip themselves up. And I think someone in the state AG's office just really messed this up. And I know that there are many fans of the YSL attorneys, and there are fans of Brian and Keith that were disappointed they took this case, um, disappointed in the outcome that they were able to get. And I think if you're disappointed, then you don't really understand what our job is and what we're here to do, which is to protect everybody's constitutional rights. Even prosecutors, even law enforcement. It helps everybody. So I think Brian and Keith did the right thing here.
Doug, while you're with us, let's pop back into ASAP Rocky, see what's happening. I see some movement. I don't know if they're talking about tomorrow.
Maybe someone's waking up.
Yeah, yeah, right. We'll talk about that too.
What's the,
Fantastic.
so, no, just adding the last part of it. So you told them, at my instruction, that evidence was not contested. But they were not told the next part, which for that reason, you are not in any way considered as part of the evidence.
They've been told time and time again that their decision in this case can be based only on the evidence that is within the universe of this court. I don't think it's necessary to say that.
Your Honor, the last thing for us, we just want on the record, it's our understanding that the court has had us indicate who the next witness is going to be. We just want to have the defense indicate what the order of their witness is going to be as well.
I've already told them that.
Who's first on the record?
Everyone on the record. So don't ask me off the record if you want on the record. Jamel Phillips.
Say again?
12.
That's 12?
Yes.
All right, and assuming we get through 12, who would be after?
Rule 11.
All right.
Judge, now, I got this
That'll
one.
be to say.
I just say one thing. I mean, it's a constant barrage. You gave an admonition. You said, I told them 2 weeks ago not to test. That doesn't speak to the time before 2 weeks ago. So the jury can infer anything they want before the 2 weeks ago. Okay. So if they can infer, so an instruction that they can't infer.
Both sides are entitled to argue reasonable inferences from the evidence. All right, does anybody have anything else before we recess?
No, sir.
Thank you. All right, remember folks, 10 o'clock.
Okay.
No,
Or do you want to have them email us?
Time to play best guess at what
Okay,
we're fighting
back.
about.
They're fighting. The children are fighting again.
all of these times. I know no reason why these are I don't
I think they're still going. I'm not quite sure what happened.
I don't know that I even.
No, they're not. They're finished.
Is it
They were
fighting
never
or is it fighting or is it bickering? It
Well, there's
feels
no
like-
squabbling. It's a no squabble zone. That's what the judge has said many
Oh,
times.
really?
That's what he said. It's a no squabble zone, but he seems to take part in the squabbling himself.
So obviously, I've been working, but it seems that these two don't really care for each other. That's the impression I get.
You are. I think that you're right. But those of us who watched John Lewin in Durst, I mean, he's only there to make objections and to argue with Joe. He's not presenting any evidence, Joe Tacopina. And it really, it's constant. And the judge today, and I said, we're going to show tomorrow. Just he was like that. Just stop it, Mr. Lewis. Stop it. Stop. It had enough because the jury's sitting there. I don't know if you watched anything today, this afternoon. I mean,
I saw a little bit this afternoon.
Bring your pillow. Bring your pillow. There was nothing for us to discuss. They put on a firearms tool marks comparator that they called ballistics, right? To say that, well, the cartridges that this guy the Relli alleged victim brought in could have come from two different Glock guns that, there were thousands upon thousands upon thousands and thousands made, and could have, had class characteristics. It could have been, but they don't have anything to compare it against. And that was it. And they spent hours on that, hours on it. So.
Well, you don't have to tell me about tedious trials.
Yeah, this thing is lightning fast, comparatively speaking.
Yeah.
We heard the judge suggesting that they can argue to infer whatever they want to infer from the evidence that's been presented. So it sounded like they were fighting about what was going to be allowed in closing arguments or not.
I think on the directed verdict, I think that Lewin was trying to get Joe to not argue what he could argue on, because I don't think they did the directed verdict, did they?
Well, I don't think so.
I don't think so. And so I think that Lewin was arguing that Joe Tacopina couldn't argue stuff in the directed verdict and all. That's what it sounded like to me.
I think that's ridiculous because you're arguing to a judge. The judge knows what weight he can give different things. I mean, that was always the case when I would be on bench trials, is the judge would be like, it's a bench trial. I know how to weight evidence. We're going to let pretty much everything in. And in arguing a directed verdict, I think give them flexibility.
Yeah, I mean, it's a tough enough burden. What are you going to handcuff the person for,
Yeah.
So somebody said it was spicy. Misty said it was spicy.
Spicy.
Yeah.
Spicy.
Okay. Spicy.
Well, tomorrow should be very interesting.
Tell me if I've got this right. You guys need to straighten me out because this sounds nuts. So the police comb the scene right after the shooting. They don't find any shell casings, right?
Only 7 of them, though. Only 7 cops.
An hour later, the alleged victim comes back. And he finds
allegedly comes back. Yeah,
allegedly comes back. And he finds shell casings. Do I have that right?
Yep.
Yes.
He found 2. He came back.
Is that not reasonable doubt right there?
Right. Right there. Right. Allegedly, he's there for 2 minutes, and he immediately finds them. Them.
Well, some people have a knack for that. My mom, when she goes to the beach, can find shark's teeth like that.
Hey, there you go. Yes. I've been calling him Inspector Gadget because he obviously has some special way to find things the cops can't.
Yeah, not only that, they didn't find any indication that there was ever a shot. There was no windshield broken, no car broken, no granite broken, and they combed the scene, 7 of them.
And no
the
projectile.
whole thing feels like a shakedown operation, really.
Having
heard all that. I mean, does it seem that way to you guys?
Well, especially since there was a conversation with Wally, his friend, and he said to Wally, not only filing the first time that he wanted the 30 million, but he said to Wally, I want to get the bag, or this is, I'm paraphrasing, I'll get a bag to get the 30 million, but you got to get a lawyer to get the bag, or else they call it extortion.
Right.
That sounds.
Go to some private island somewhere.
Yeah, and then he said he didn't say that because that was AI, and so Joe Tacopina, out of order, brought Wally in. So you said that.
Yeah.
I mean, so why don't they charge him for extortion? I mean, that's what I question. Why the prosecutors often didn't charge him for extortion?
I don't know why they have it out for this guy. I don't really get it. I mean, to me, the case is incredibly weak.
It's horrible.
Yeah.
We've been guessing about all the political things going on. Remember, Gascon left the office. The new guy comes in 12-1. And then miraculously, John Lewin parachutes in about 4 weeks later. The case has been in the office 3 years. But I think, and again, the Relli testimony supports that nobody ever talked to the guy. No investigators really prepped him. No prosecutors prepped this guy because he was the worst witness ever. And so it just sounds like the case was just kind of sitting around, and then somebody went, "Oh man, we got the case." Paulie P., who's the lead prosecutor, seems like a decent guy. Seems like he's thorough, matter of fact, but he's not Mr. Showboat. Get in your face, messy Lewin.
Yeah. So are you guys going to cover my trial in August?
What are you doing?
What is it?
Where is it?
Okay, I'm in Liberty County, Georgia.
Okay.
My client is a retired lieutenant commander from the Navy, JAG Corps, time in Afghanistan, was in the Pentagon. He and his wife kind of fell off the map for a few years. And his wife is found they were living in Savannah eventually, which is Chatham County. And then his wife is found scattered about in pieces up around Liberty County on a hunting ground. And they have charged my client with her death.
Wow.
Well, this
That
sounds like an
pretty,
interesting case.
spicy.
Yeah. Is somebody asking for stream? If somebody has to stream it, because we'll
I
cover it even
I
if
don't
it's
know.
not
Well,
streamed.
here's some of the things that make the case interesting. If I'm going to pitch the
Yeah.
case for
Yeah.
streaming, it's a very difficult case to win. Anyway,
Now,
I
you
think
guys pitching cats a
Yeah.
difficult case to win.
we'll see what happens. I have some ideas, but my client is fascinating because of this lieutenant commander from the Navy. He's a JD, LLM from
Wow.
Ivy League schools, so he's brilliant. He wrote a short form story on either Twitter or Reddit. I'm getting him confused, but it was like serialized, right? Just
Right.
for fun. Just for fun. Sony Pictures picked it up and paid him 300 grand to turn it into a movie with some celebrity producer, actor
Right.
involved.
It's a
So
great
the
story.
whole and the state is planning on calling in Sony Pictures as a witness because they allege wrongly that there are similarities between his short story and the death of the wife. There actually
Of
are
course.
none.
That's
So I'd
Well, of
love
motion to
course
to see
you
eliminate
would.
number one.
I'd love to see this RAP Act pass because I don't think they can meet the burden.
What's
But
going to be
they
the
plan on
burden on
bringing
the
that
rap?
in.
What is going to be the burden on the rap pack if it passes? Because that's ridiculous again. It's so you really think about this. You're going to write a story and then you're going to kill your wife the way you wrote the story.
Makes no
That's
sense,
in a
right?
movie, right?
And how they allege that his wife was killed isn't even the same as the story. So I
What's his
don't.
name? What's his name, Doug? What's
His name is Casotis. His name is Nicholas Casotis. He is a really nice, super nice guy. Just one
Spell
of the
that
nicest
name.
guys you've ever. Kassotis. And he's a fascinating person. He's brilliant. He's really nice. And yet he's been in jail because of YSL. He's been stuck in jail. I think bond was set at $6 million.
Oh boy.
He's been sitting in jail in Liberty County, which is Hinesville, where Fort Stewart, I think they've changed the name probably, but Fort Stewart, Georgia is in Hinesville. So he's been sitting in the jail for, it'll be 2 years this May.
Jeez.
So we're really looking forward to getting it to trial. We had to get it specially set, but yeah.
So Disney's already found it, but what I want to ask you this question from Danny Caratan. This is a perfect question for you, Doug.
Oh,
the
man.
jury vote not guilty because prosecutor is so obnoxious and seemingly unscrupulous, even though I guess it's defendant seemed guilty.
Okay, I don't like the last part.
Neither do I.
I don't like the last part. But if you ignore the last part, I would say that part of the reason that the jury voted not guilty is because the prosecutor was so unlikable and unscrupulous.
Can't
but yeah, Nicholas James Casotis, really nice guy.
Disney's already found it. She's already found it.
There you go. There you go.
Right?
So give me the details. August when? What's trial date?
Oh, they just specially set it. I want to say like somewhere between the 2nd and the 6th.
Okay,
and the
first
DA,
week of August.
Yeah, my prosecutor says it's going to be, they have like something like 80 witnesses. It's all circumstantial.
Witnesses?
It's all circumstantial.
80 witnesses. How long are you going to be in this case this time?
3 or 4 weeks.
Okay.
But I don't know if you've ever been to near coastal Georgia in August, but the weather is delightful.
I was in Brunswick. From an Arbery, which was in the summer. So it's Liberty County. What's the actual town?
Hinesville.
Okay.
Hinesville.
Like ketchup?
Like the ketchup people.
Okay.
Hinesville.
Is that really? Is that
No, it's just that's just
okay.
It's not the ketchup people. They're from Massachusetts, I think. But the town is a great German restaurant, and the people there are all universally lovely. If you guys in Hinesville are watching, I love you all. You're the dearest people. No, you're like my people because I'm from Jacksonville, Florida. I'm from very close. That's kind of my region.
Which is like southern Georgia, Jacksonville,
It's like
Florida.
southern Georgia.
Yeah.
It's exactly like southern
Is there a plea right now, August 4th on Google now? Look at this. You come and you see, look at our viewers.
You guys are all over it.
Look at our viewers are all over it already.
I know. I just got the notice a couple of days ago.
Well, our viewers are all good eating on the Georgia coast. Let me see. Hey, Dougie
Yeah.
Fresh, what's up? Well, this is what's up.
Are you
Dougie
familiar
Fresh, what's
with
up?
the Tybee Island?
I am familiar with Tybee
Yeah.
Island.
There
So
was a
it's
case.
coastal. It's great.
Yeah, it's beautiful. They have the lighthouse there, right?
Look at this, Doug. You're doing court. Did you know you're doing court
February
February
27th for a plea
27th
hearing.
for a plea
Yeah.
hearing?
Yeah, I'll give you a clue. We're not taking a plea.
Yeah, well, yeah, but
Breaking
that's interesting.
news.
That's
Breaking news.
breaking.
Breaking
Breaking
news.
Where's our breaking news? Where's our breaking news?
We are going to trial for Nicholas Cassell.
breaking
This
news.
just in.
Yeah, we're not
Nicholas
taking a plea.
Casotis. There you go. Say it again. Breaking news.
Nicholas, we're not going to take a plea. We're going to go to trial. This thing is going to trial. So
Okay.
don't worry about it pleading out on February 27th.
All
I'm
right.
trying to avoid going down to Liberty County on the 27th. I think I'm going to be in trial on the 27th.
Will they let you appear remotely?
Heck no. They're not going to make it easy for some Atlanta lawyer to work down in Southeast Georgia. You got to keep your local lawyers employed. Let's make it as difficult as possible for the Atlanta guys to appear.
Do they make you get a pro visa to go from one Carolina to
Yeah.
Yeah.
Almost.
It's a different country, isn't it?
Almost.
Look at that. Look at there you go. There's your Jug Slimestein
Emoji. Yeah. I mean,
Look
maybe
at
the
that.
glasses should be a green tint, but that's okay. I'm
That's
wearing
all right.
green today, but
Oh, you got the green ones today?
the problem is my light. I need anti-reflective lenses.
Oh yeah, the ring
So
light.
see, if you need the
So-
glasses line, needs a glasses line. Doug Slimestein needs a glasses line. Everyone loves you. Everyone loves you here. As his word spreading that you're on, you see, people are growing. So what else is up? So did you talk to Brian after the victory that he had? I guess it
sent
was
them-
Adams also, right? Keith Adams.
Right, Brian Keith. I sent them congratulatory messages when they got the verdict, and I heard back from them. So
What
they're
about
doing great?
the judge wouldn't let the cameras in?
No.
What do you think about that?
I think that I don't know why they were kept out. I don't know if Brian or Keith wanted them out. I don't know what happened there.
Well, they blamed the judge, so I don't know if that's what
Okay,
happened.
well,
but-
I just know that as you heard our judge say, and Judge Glanville, if you heard all the judges say, in Georgia, the default condition is pretty much that cameras get in. Now, so I'm a little surprised they didn't stream it, but I guess Miss Sylvia was in there with the camera and would just show it later. They just didn't have live streaming.
She missed the verdict or something. The camera didn't get set up in time to get not the
Miss
verdict,
Sylvia.
to get the dismissal.
decision.
Get the dismissal. She's great. I mean, I haven't met her, but Michael said he met her.
Yeah,
when he went down
I
to
sat there
YSL.
with her, and
Yeah.
you know, she's part of that little cadre there. Speaking of that, I keep forgetting to reach out to you about Tash to you know, see if you can, you know, give our information to her so that, you know, if she wants to reach out, she can.
Oh, you missed Tasha?
Yeah,
I
yeah.
don't know if I want her coming on y'all's show till
Until he's out. Until he's
till
out.
Bruce and Nicole get Diamante through all this stuff.
Well, that could.
Oh, I see. Yeah,
I know
yeah,
you
right.
said things. You know, some good things are happening, but
I think
isn't there
some
a
good things are
court
happening.
date like next week?
There was supposed to be a court date tomorrow, and that has been canceled.
It has been.
Yeah,
Because
it
that
actually,
relates
yeah.
to-
People
I'm
don't
gonna keep
know that.
refreshing my Twitter.
Okay.
I'm sorry.
I-
Yeah, people don't know that it has been canceled for
Okay.
tomorrow.
Because I knew it was. I thought it was the 7th or the 12th. I couldn't remember which.
Yeah.
So do you think
That
it's
was on
related
the
to whatever's going
probation.
on?
That was on the probation revocation for tomorrow,
Right.
in front of Judge Leftridge, and that has now been canceled.
Okay.
Okay. All right. So we should
maybe
keep.
that's,
We should keep looking.
Maybe that's somehow connected to whatever good things might be
Maybe.
happening.
I don't know. I'm clueless.
Okay. All right.
Oh, we're not going to push it, but we're going to put Doug Weinstein's now on for your questions right now. So, are you following any other trials? Been following this Rocky ASAP?
I've been following the Rocky ASAP trial some, yeah. It's hard right now just because, just as you can imagine, just how busy we are post YSL. I get very little time during the day. So it's hard to follow. I've been trying to see like recaps at night, and I've seen y'all, I've seen Megan Cuniff's stuff. I've seen
She
some
doesn't.
of
She
Sylvia's
apparently.
things.
She apparently may not like us.
You just got her started, Doug. You just.
I don't know. I'll be
wrong
very.
thing.
We broke 2 breaking news stories about what was going on in this trial, and without mentioning our name, apparently, something
She called us
about
liars.
Basically.
Our names.
right,
You know,
basically. Yeah.
I didn't get dragged into that meet cute between Sylvia and Brian. I'm blanking on
And we
Byron's.
haven't either. We just
Yeah,
ignored it. We didn't want to be in the
so
gutter.
those two were going at it throughout YSL, and I didn't kind of get involved in the middle of it. So I tried to stay press agnostic. I'm like Switzerland. I'm like Switzerland when it comes to members of the media.
Yeah, no, we did too. But we're reporting what we know, and so far I think we've been we're young, but we've been pretty accurate. And we'll feeling is I feel like if you lift the gag order, you don't have gag orders, then people can tell you, you're right. Did you get it right? Did you get it wrong? We were by 1,000%. But then prosecutor, you ask for a gag order, lift it. If there's an issue, let's find out.
I will say that guy Academics is a piece of crap. So I'm no fan of his.
I don't know that one.
Oh, good for you. Don't know. But now you know what? Now I'm going to have a Streisand effect.
Now you've promoted him.
Everybody's going to be looking up Academics. Don't do it unless you're just doing it to block him.
Oh man, okay.
He's the one that leaked like Diamante Kendrick's interrogation video, or I don't want to say leaked it. He kind of resurfaced it, toward the end of trial when it had been, ignored for a long time, and he's just I'm not a fan.
All right.
No, which as you know, we had you on. I met you at Long Crime, as you know, and I was so impressed with you. I think it was one of the first interviews you did, one of the only interviews you did. I was so impressed with you, and then we went out around, and I said, "Look, we have to Doug, because you're so honest. You're so you're just what we were told at the party. You are who you are, and I think that's why you win cases too. And you're good. You're prepared. I mean,
and what is he?
Prepared.
What is he? What's the important trait?
Likeable.
Oh, I'm
likable.
I'm likable as all get out.
Yeah, you see that? I see our little thing on the top.
Unspoken Riz.
You have unspoken Riz.
I don't even know what that is because I'm so stupid. I assume it's a good thing, and thank you.
Go ahead, Michael,
It is a good thing.
Give them the story about how it happened.
Okay, you probably remember Bob Bianchi, who was also a host on Law and Crime. Yes. I had him on. He was guest hosting for Linda, who was on assignment, and he had posted something earlier, so I brought it up on the show, and I said, "What's this deal?" He does a couple of nights a week as an EMT, and he's wearing his EMT, goes into a 7-Eleven or convenience store, buys whatever he buys, doesn't say a word, and the clerk looks at him when they're done. He says, "You have unspoken Riz," and Bob, like us, said, I don't know what that is, but I guess it's good. So he looked it up. Riz is charisma.
Well, I'm looking for testimonials for my website. So if you guys are willing to be quoted on that.
Yeah.
Yes, absolutely.
I can add that. Or if you wanted to give me a Google review and say that Doug has unspoken Riz.
Unspoken Riz.
You have unspoken Riz. Yep. Yeah.
Because it's all about the Google reviews when you're solo,
yeah, it doesn't hurt.
No, yeah. Well, I mean, you've got you're one for one, and everybody on this website.
Undefeated.
Criminal trials.
Evan said free yak.
Somebody asked how Thug was. Have you heard of Jeffrey Williams? What's up?
I don't know how Jeffrey's doing. I don't know. I know that I think Shaquille Kokomo has been in communication with him. I'm sure that Brian and Keith have. I saw the things publicly reported that and I think maybe even Keith said some of this, that he had regretted perhaps taking that plea. And I know he caught criticism, and I'll say what I said before, which is he really shouldn't feel that way because you never know what's going to happen in a case. And there's no way Brian could promise him not guilties. So
it's easy. It's Monday morning quarterback. That
it's so easy.
Yeah, and you never know whether the next night somebody was going to come up a pipe in the G. I know he was in Rice Street in the pipe and kill him. I mean, the way it was going.
Well, think of that alternate that was so vocal after the case that thought they were all guilty of everything. If he had been on the jury, we very well could have had a hung jury.
Yeah.
So you never know what's going to happen.
Yeah.
Right? I mean, I don't have to tell you guys. You've been
of course. Of course.
But going back to Bob Bianco, Bob, when he was a younger person, was an EMT, and he was the prosecutor in a county in New Jersey where I'm from. I mean, the head honcho. But now that he's now back in private practice and he doesn't have to deal with being on the air, with a schedule set by somebody else, he wanted to give back to the community again. And he actually got recertified at his age, right? And went back, and now he's doing several nights a week from 6 p.m. to 6 a.m., along with his full-time law practice.
Oh my God, that's wonderful though.
Yeah, it is.
Isn't that a great story?
That's
Just
great.
a
I
great.
have a law classmate that's an EMT now. So
Yeah, it's good. It's just great. Just great. Doug, here's somebody's. Doug, we need you at the Rocky trial.
you know what? You got Joe Tacopina at the Rocky trial, and he has far more. He's rizzier than I am.
Rizzier.
Nothing about him is unspoken, though. I'll tell you that. There's no unspoken taco.
No, all I had were my little glances and looks, right? Because I have no poker face whatsoever.
Yeah, no, and I compliment on the air. I've been complimenting how Joe is handling this case because you try cases differently in California, and I think he is, except when he's dealing with Lewin, which you need to have. They are two. They're going at it. I think he has built his blocks. I think he has toned it down. I think he has treated people with a great deal of respect. He's prepared constantly. I think he's done an amazing job. Now, it may be a different style than you have when you try a case in New York. It's just different.
Yeah, I mean, I can't imagine me trying a case up north. It's not, my personality is not a northern personality. I'm definitely of the South, I think.
I always tell the story. I tell the story, Douglas, when I was doing work for the NAACP Legal Defense Fund and the Innocence Project on a case that was reversed by the U.S. Supreme Court that led to the way you don't have to argue absolute innocence. You could argue a gateway to innocence, and that's the case out of Tennessee. And I had to go after it got reversed to try to get this man who had been on death row out, and we did. But I went to Maynardville, Tennessee. All right, literally 40 miles outside Knoxville, but it was more. It was could have been 700 miles outside of it. Amazing.
Yeah.
And then when we had lunch among all the Confederate flags and the rabbit feet and all. And I was from New York,
How did the Chanel work there? How was that Chanel?
I didn't blend very well. Neither did my accent. But they were all gracious to me, except for the first night that the director of the Innocence Project at that point, who was Black, and I was obviously a white female, landed at 11 o'clock, picked up at the Knoxville airport, and the hotel literally was 5 minutes away. Well, we went on a 40-minute cab ride. Right? We were looking at each other like, oh dear,
yeah. But see, I used to live in Tennessee. You were in Tennessee has 3 grand divisions. You were in the Eastern Grand Division.
Yes, yeah. Maynardville, Tennessee. Very poor, very tragically poor area.
Yeah, where I lived was a pretty poor area as well.
Yeah.
Where'd you live?
I lived in the Copper Hills area of Polk County, and it was an area that was heavily into copper mining. It was the site of it's the first Superfund site in the U.S. from the early 70s. Was there, but it's all been restored. It's beautiful now, but because the copper mines played out, the folk there's no work there, so most folks just had to move away. It's pretty much abandoned, but it's beautiful. It's beautiful.
I've got my sister lives there in Franklin, which is one of those big burbs outside of Nashville that has just exploded.
My ex-wife lived there. Very, very, very. I'm not going to say anything more. She lived in Franklin, Tennessee, and 2 of my kids went to high school there. So
wow. Oh, okay. All right.
Franklin's beautiful.
Here's another Tennessee connection. Back when I was doing the Legal Edge, my syndicated feature, we were sponsored by the Tennessee Trial Lawyers Association, and so we were on in all the markets in Tennessee, and there are really 4 big ones: Chattanooga, Knoxville, Nashville, and I'm missing one. Memphis. Yeah. And then there's a little burb called Johnson City. You ever been to Johnson City?
The Tri-Cities area, Johnson City, Bristol, and Kingsport.
There you go. And what's that area famous for? What is it? What's happening there? NASCAR.
Oh, in Bristol.
So I go out there to I like to visit the affiliates and go and do an appearance on the set and all that stuff. And somebody said, well, let's go out to the racetrack. And this racetrack in Johnson City is one of the few tracks that has almost no straightaway, no flat straightaway. It's like all banked we got on the racetrack in a regular car, and we're driving as fast as we could on this. I couldn't believe they let us do it. It was crazy.
Wow.
That was
That's-
Johnson City.
That area is beautiful, by the way.
Yeah.
I love that region. There's a big there used to be a big semiconductor plant there. TI had a big facility there for a while. They made the Speak and Spells. They remember Speak and Spell, and we would many Vanderbilt engineers would summer there, and we would make raunchy Speak and Spells.
Well, my story is of course Quentin Tarantino, right? And if you, I'm the only one in Inglourious Bastards when the Brad Pitt character was asked by a sergeant, "Where are you from? Where are you?" Yeah, and he said, "Maynardville, Tennessee, sir." And I just, of course, in the theater, I'm roaring because I probably was the only one who knew, but Tarantino, because he's from Knoxville, as you know, always has some kind of Tennessee reference in his movies, because he's from Knoxville.
I didn't know.
Yeah. So if you go back to listen to Inglorious back
there you go,
Bastards, and there you go. You'll Maynardville, Tennessee, and I'm like, I've been there.
Well, I got two kids that are graduates of University of Tennessee, and one of whom is up in Suffolk Law School right now. Up in
Oh, that's great. Oh,
cool.
so you're gonna have a law firm with your one of your kids then?
I don't think he wants to do my thing, but we'll see.
So that's the Vols, right? Is that the Vols?
That's the Vols.
No, they had a big game, I think, today.
Oh yeah.
Vanderbilt beat them, and Vanderbilt beat them in basketball.
Okay, I knew they had a
we
big
beat
game.
Kentucky too. So
okay, so
There you
some
go.
of the points that you're still unhealthy, and the reason why I bring this up is because you and I talked, and I want people to know about the toll that these long trials take, and we've discussed it, but you have to keep reinforcing it. The toll it takes on you. You have to have a supportive family. What it does to your life every day, because you're 2 years. People don't realize it, that you have a life that you have to deal with, and you have people that love you and that you have to love them, and responsibilities. Just talk to us about that. Defense attorneys aren't the devil.
Right. It's I would go to trial, and they were bench trials, but I'd go to trial for a week, 2 weeks, 3 weeks, and I would be exhausted afterwards. I'm sure y'all are the same way. And because when you're in trial, it's just all trial, 24/7 trial, weekend trial, it's all trial. And then you do that for 2 years. And you have to have a very supportive family. You have to figure out some way to carve out time to see them. And then when this because of the nature of what we do, when this trial is over, YSL, we've got every judge in the state of Georgia calling us in. So
explain that. Explain why that is. Explain why
because
that is.
Right, because we have other cases. We have about, where I work now, like 60. We have 60 other trials to do that aren't getting done because we're in YSL. And the judges have mostly been patiently, but sometimes impatiently, waiting for us to finish YSL so they can call us in. And you're not going to get a continuation. You're not going to get an extension. Nothing like that is going to happen. Even though, like, I talked to Bruce Harvey and Nicole a couple of days ago. They have a trial, I think, every week this month, one after the other after the other. And that's how a lot of us are right now. And it takes a toll, not just during the trial, but during the couple of years it's going to take to dig out. So that is, I know I was in DeKalb County, which is part of Greater Atlanta, about a week after YSL, and Keith Adams was in trial there. He rolled right out of YSL, and about a week and a half later, he's in trial in DeKalb County. He got a not guilty, by the way.
Yeah, no, and then he was in trial with Jackie Johnson. But the best question of YSL from Katie: did the cop get the watch back, Doug? I loved how you kept on.
Everybody wants to know where that damn watch is.
I want to know where the damn watch is too. That watch is still missing. I'm going to be very interested, though, seriously, in following the civil seizure, like the civil forfeiture suit in that case, because that civil forfeiture lawsuit is still out there. It's still pending.
That's the one that the state brought against.
The state brought against. Well, it's an in rem, right? So you bring it against the goods. So it's really against Jeffrey Williams, but in theory, right, it's an in rem action. So the defendants are the watches, the jewelry, the cars. And I don't know how much civil forfeiture y'all have done, but it is usually very tough to win
You
a
can't
civil
win. It's hard to.
forfeiture.
It's usually you can't win them. Usually you
Usually you
just give
can't win
up.
them, so you settle and you're like, just give me, if you have a good chance of winning, you're like, just give me 25% of my stuff back and we'll call it a day. And that's kind of a victory because they don't have to show that the goods are guilty beyond a reasonable doubt, right? They just
Right.
have to show it's more likely than not that illegal proceeds were used to secure those goods. So they're tough to win. But and I have not talked to Brian about this at all. But to me, in Jeffrey's case,
Yeah.
this civil forfeiture suit is eminently winnable because millions and millions of dollars worth of goods were not bought by selling dime bags at a gas station on Cleveland Avenue. Right?
There you go. Tennessee women's basketball playing UConn. Tennessee up by 4 in the third.
Oh, there we go.
quarter.
See, that's why I knew it was important because UConn is just up the street here. So, okay.
Yeah.
How am I finding going back to solo practice?
Yeah.
Terrifying.
Oh my God.
No, seriously,
Yeah.
I am
No,
I am
I
terrified.
understand.
So let's see how it works.
See,
I have a feeling it'll be just fine. That's what
Hey,
Yeah,
Seti Nash, how are you doing, man?
yeah. This is awesome. Everyone's back. Everyone's like going crazy, on you. They're going nuts on you, which is
well,
great.
it's
That's
fun
the
to
way
be
it should
back
be.
on with you guys. I don't know if I'm contributing very much, but
No, we want to talk
This
about
is
you. We want to
this
talk
is all
about
we
your
do.
work.
Oh,
This
really?
is this
I
is
love it.
it.
No,
You're
we
bringing
practiced
that
law
up.
during. We practiced law during the day. Although this week, I had 11-hour mediation on Tuesday.
Oh.
I've been finding. I know. But the case settled. But
Okay.
it was long, and so that was the good news. But trying to do my regular law practice and trying to do this, especially when we have this California case that then goes on like an hour and 45-minute lunch break because it's California, right? And then they ended.
Hey, wait a minute.
That's kind of Judge Glanville-esque, but go ahead.
Yeah, I don't know if that's a California thing. Come on.
Yeah, but but it is. It's been grueling, and then this morning I woke up and I was like ready to get my stuff ready to do my calls and go to a meeting, and it snowed here. Luckily, so my meeting got canceled. But we found the Karen Reed was on, and so when you're doing the streaming thing, you have to go with like what's there all of a sudden. I'm like, Michael was out there.
Well, I was
snow.
going to snow. I had to plow. It was one of those horrible snows where it was like somebody went to 7-Eleven and went to the Slurpee machine and said, "Can you just bring that to my house and put about 2 inches of that all
like
over my
heavy,
property?"
Wet,
Yeah,
heavy,
you can't
wet
really.
snow.
It's like trying to plow, mud. It doesn't snow blow. It just snow blobs, and it, you end up doing a lot of it the good old-fashioned way. Then I've got a long driveway with a hill. It's brutal.
We just shut everything down when we get snow.
Yeah,
It's
Just
yeah.
right. But
And just recently, you guys did, right? You had
Right,
you had
We
something come
did,
through.
although I will tell you, this snowstorm was predicted to hit, and I had a judge in LaGrange, which is kind of
how far is that?
It's about LaGrange is maybe 80 minutes from Atlanta. It's towards Alabama, kind of on the Alabama-Georgia border. It's to the southwest of Atlanta. But I had a judge there, and he was calling me into court on Friday when the storm was supposed to hit. And I'm like, I can't go to that. I've got a snowstorm coming. And he's like, no snowstorm here. I'm like,
No
I'm not-
snowstorm here. Right.
I'm
That's
not-
exactly right.
I didn't go. He ended up. They ended up. The storm ended up moving a little further south than expected. But he was going to call me.
Tough
in.
guy. These guys are tough there.
I know.
Yeah, and I think also I'm wondering whether it's also because you have the win of the not guilty, right? They're pushing you. I always find that, And here's somebody, Katie, again, seriously though, I loved how you kept up with social media to form your questions. Rarely see it. Also, social media, not just your questions, but everything. I mean, the tips you were giving and the TikToks you were doing, and I don't know how you do it.
It's my first criminal trial. I'm going to take anything I can get. I mean, there were some good suggestions on social media. I'm like, you know what?
It's
That's
amazing.
A good question.
These folks are not
like,
dummies. Yeah.
I mean, yeah. Let's what's it called? Not group source. What's the word I'm looking for?
Crowdsourcing.
Crowdsource. Yeah, let's crowdsource this cross and see how it goes. Plus, the witnesses aren't testifying the way you expect, right? Because you don't know that every one of the prosecution's witness is going to go completely south on them. So it's like, well, that cross I prepared is out.
Yeah.
I can't use it. Did you guys see that? Did you guys see that I took Woody to a Hawks game?
No, I didn't see that. I miss it.
I get all
miss
your
it.
posts. Did you post something on that?
I think so. I don't know. I was
Okay.
drinking.
Yeah.
I took
I love
I
it.
took Woody and I took a TikToker that's a public defender in Macon and a defense attorney, Stara from Texas. The four of us went to a Hawks game. We got floor seats right next to the bench.
Very nice.
And you know who we saw there?
Who?
You know who we saw? Gaither.
Oh.
You remember
Okay.
Gaither from the trial?
Yeah.
Gaither was there.
Yeah, I thought. No, I did. I just. You know, that's great. That is just.
Because you know why I did
We
it?
did.
I love what Woody's doing with his life. I love it. I feel like he has turned his life. That stuff I crossed him on the stand, that was not bullshit. I'm gonna say bullshit. That was not.
Well, you can say it. You can say we're streaming.
That was not bullshit from me or
okay.
bullshit from him. I think Woody did some stuff 10 years ago, but I think the Woody right now has totally turned his life around. He's been baptized. He goes to church.
Wow.
He's out there. If you will follow him on social media, now he's living his best life, but he's also out there preaching to kids. Don't get involved in gangs. Don't get involved in crime. Respect your parents. I mean, and if it's an act, it's an act he's putting on 24/7, and he's been putting on for about 9 months. I think it's real.
And this case turned him? The YSL case turned him?
I'm gonna take you to a game, dude.
We had a. Go ahead, Michael.
Yeah, do you think the YSL case turned him? I mean, that's just what was it?
I don't know. You know, I don't know. I don't know if it was the YSL case. Maybe the fact that he somehow wasn't indicted. I didn't really. I need to ask him next time I see him why that. I mean, he said on the stand, and he said before he took the stand, when I saw him on social media, about God entering his heart. And if he was a politician, I'd call bullshit on that. But I mean, he didn't have much to gain from saying that, and he really doesn't have a lot to gain if it is an act by keeping it up all this time. And I really hope the state doesn't go after him for his testimony on the stand, because you know how vindictive they are. But
but we were saying that he finesse, man. Finesse. I'll never forget that. And that in the case we're watching now, the alleged victim Relli can only hope he had a little bit of
he
Riz.
doesn't have any. Yeah, he doesn't have Woody's charisma.
No. Woody had charisma. He really did have charisma. And
he still has it, man. When he was at the Hawks game, it took him like 30 minutes to get from the entrance to our seats because they had to stop so much to take selfies with people. I took him to the VIP lounge. Everybody's stopping to get pictures with Woody.
Great. That's the best. The great said Riz. Disney said he's got Riz.
Yeah. He's got like Riz squared.
Yeah, that is just so great. You know, every once in a while that we're allowed to ask questions. Yes, ask away. Doug is here. Ask while he's here, because everyone wants a piece of Doug. Yeah, absolutely.
Oh my God, I give. Yeah, how much you'd be charged for advice? I give out a stupid amount of free advice. But
let me just tell you. Somebody just gifted because of you, because you're here. Somebody just gifted Justice TV's 5 memberships because you're here.
That's great.
We appreciate that.
Great.
Yeah, thank you. Here comes Trauma.
Yeah. Anyway, it's good stuff, but
that's really good. All right, so
don't
we have
get
to watch.
into trouble, but if you do, call me.
Right.
So we're going to let you go. We'll talk
cool.
about. We're not going to keep you to talk about the California case. But we did want to interrupt it to talk to you. I mean, the whole point was to have you on to talk to you, especially about your new law firm.
And more late discovery in that California. There was late discovery in that California case.
Oh, you mean the day of?
The day of.
Yeah, the day of. And that was the witness who just finished up.
Yeah, and in the Karen Reed case this morning, we discovered they didn't give discovery. They gave last night. They gave voluminous discovery because the things that were downloaded had been erased. But now
that whole thing is going to blow up.
Yeah, that's another one of my hobby horses is late discovery. So whatever.
Well, look at the cases that we started talking about this. You know, the cases where we've seen blatant, hide the ball stuff, like the Baldwin case.
Yeah.
Ty Tucker case, which is a little less known, but same thing happened to him. I don't know. We're trying to figure out, is this just a trend, or is it we just happen to be stumbling on the cases that showcase that kind of misconduct?
Maybe they should take that Brady training that our prosecutors were ordered to take. How's that?
Remember that? You're sentenced to Brady training.
Yeah.
Yes.
Oh my God.
Anybody know whether they did it or not? Or they took that? Can we follow up on that?
As far as I know, they did.
So let's remind everybody of the case again. I know we had it and we had dropped it into
Oh,
our
the big
comments
trial I
there.
have coming in August.
Yeah, August
It's
4th.
State
Right?
v. Casotis. I
Casotis.
see from your comments, August the 4th.
Yes. You know when to be
My
there
guy,
now.
they got nothing linking my guy to this other than a car near the scene of where the body is, but I don't think that's enough to send somebody to prison for murder. But we'll see if the jury buys my argument.
Are you gonna? You think you'll get out? You'll get a courtroom that day is gonna lock. It's gonna work.
What's that?
August 4th. You think you get a courtroom?
Oh, for sure. It's specially set. So in Georgia, when they specially set it,
you're at the top of the pile.
All right.
Cool.
So we'll put it on our calendar. If it's free, and anytime you want to come on to talk about it, we're here for you. You know that we always told you had a free reign to come here without any agenda. Without any agenda. Yeah.
Okay, let me go take care of my 9-year-old who's running around behind the camera.
Hi.
All right.
Go to work, Dad. He's gonna jump out here and say, make sure to like and subscribe. I'll see you guys later.
We love you, Doug. As I said, we love you, Doug. Yeah. All right. Oh wow, that was great. That was great. You know what we should do is we should send Doug a mug.
Okay, we should. Let me get the
mugs.
staff on. Let me get the staff on that. Okay.
I don't have the mugs, Mr. Producer.
Okay. We'll track down his address.
A Doug mug. That's so perfect. A Doug mug. Yeah. Well, we don't have the mugs. We really, you were being a little bit sparse with them. Now I have mine here. It's here.
I'm dropping them out there every time we go somewhere. So
here it is. Here it is. Say. It is, and then when the state,
that's the black version. There's two versions. You can see this is the green version.
The green version. Yeah, I think that the green versions bring up to the studio up at the Catskills.
You're gonna take it up there.
Yeah,
all right.
The mug should say I don't recall.
What's that?
The mug should say I don't recall, says Katie.
I don't recall.
So before we go, do you want to just do 5 minutes on what happened today at the trial this afternoon?
Do you want to do that? I know we have a couple of clips of some sort, right?
Yeah, we do that. And also we have Karen Reed too, right? You all going to stay around? You're not going to abandon us, are you? Just because the fave Doug ain't here.
Yeah, I mean we could push it till tomorrow. Whatever you want to do.
Why don't we do just a little clip of what happened this afternoon?
Let me see which.
I assume that they're doing. I assume they're doing. Directed verdicts motions tomorrow, right?
I would think that's where they're going.
At 10 o'clock, he said they're starting at 10 tomorrow, probably because the jury doesn't have to come in.
They're starting at 10 or the jury's coming at 10?
No, he said they're starting at 10 tomorrow. So I don't know if the jury's, if they're doing directed verdicts. So
that's only a half an hour from their normal reporting time. They've been coming in at 10:30.
10:30, yeah, but he said they were starting at 10. So
all I have I have these clips of Hank and the sidebar, but that's all Karen Reed stuff. What else you want to talk about? What else you got?
Well, there was something about the feds, and that was the report. We talked about that later.
Oh, the ARC. That's the sidebar ARCA stuff.
Yeah. Do we have anything on Alan Jackson brilliantly arguing, taking that motion, which apparently sanctions have been denied? I understand. At least somebody posted that on right now on our account that sanctions have been denied.
The stuff that I have here that's been put into the system is a couple of Hank things. One about his going on and on about no obligation. Then there's this one. Well, I'll let you explain this. This is 12 whole seconds long here.
Okay.
I don't know why it doesn't open up when I open it up.
Let me hear what the Commonwealth has to say. What's the extent of the information that you provided today or yesterday?
In the most recent discovery?
Yes.
It was voluminous.
There we go. Last night.
Okay, then. All right.
Did we have a trial on this case already? Wasn't there a trial already? And Oasis Cat said yes. Bev denied the motion for reimbursement of costs. I don't get that.
I think that's wrong. That's totally wrong because that's like letting the prosecution off the hook for all of their obstreperous behavior.
Yeah.
That money would not have been needed had they been upfront about the things that the expert then had to go and investigate.
Yeah.
So that's wrong. But hey, congratulations, Commonwealth. There's another taxpayer-funded savings for you. Good job.
Right. 12,000 savings. Why you continue to pay for this trial to go on, right? Yeah. So I mean, that really is. And then they had the thing about the feds, and we're not sure what that is. Probably what's the ARCC report?
Yeah, here's how that played out, though, because I think you thought this was interesting. So let's just tee it up so you can see, and we can then speculate about the 14-minute sidebar that took place.
Ooh,
Right?
I love speculation.
All right. So the motion regarding, just want to get Commonwealth's motion for reciprocal discovery pertaining to employees of ARCA, and then if you go one step further than that, are we going one step further than that with the second motion today, or do council want to come to sidebar and tell me any information you have, or how do you want to do this?
Whatever the court's most comfortable with. An open court or sidebar.
I'd prefer to find out what's going on over in federal court at sidebar first.
Yes, Your Honor.
Okay, and so, like I said, so that we stared at the profile of Karen Reed for 14 minutes. So her goal was to find out what was happening on the federal level to impact the state case when it comes to, the ARCA reports. It's ARR, I think CA, or it's ARCCA. Anyway, it's ARCA, but when Judge Bev says it, it's ACA. So it sounds like the R is dropped off. And so those are the federal reports, as we're well aware of, that went into the investigation of the collision, if there was one, to determine whether there was one. So what do you think's happening? What's your speculation there?
I don't know. I don't know if they said we're talking about the ARCA reports, or maybe, remember, there's that federal investigation that's been going on, right?
Into Proctor.
Proctor. I'm wondering whether it had to do with that, and especially since right now all things are frozen, like with the FBI, right? There's all sorts of things happening. So I'm wondering whether it has to do with the Proctor. Remember, he was supposed to go back. Wasn't he supposed to go back tomorrow?
Like day 2 of his
hearing,
court martial, I call it.
Right.
Yeah.
So
I'm
wondering whether it has to do with that, or it has to do with the reports at all.
And then she mentioned, are we going to get into the second motion, which was never again addressed because they talked about it at bench. I don't know what the second motion was, but again, it's an ACA motion.
Yeah. So
ACA related.
Yeah, well, although she has some tight timelines with them that we discussed at lunch, and they have a trial date of April 1st, I guess, right?
April Fool's Day.
April Fool's Day.
Yeah, and the dates, we confirmed earlier. They've moved the date for the fully throated motion to dismiss. That has been moved to I keep misreading my notes here, but I think it's the 21st. Right? Yeah, 21st. That's a Friday. That's when Alan Jackson begged for the weekend, and the judge said, "No, thank you."
No, thank you.
So and March 4th will definitely be up there for that, because that's going to be full throated. So got to be up there for that.
So we should look. I don't know. Should look into it. What happened with this? This now goes to the case we've been covering all day, which is
ASAP.
Yeah. Here's a Karen Reed order. Right. By the way, just looking at it right now. After hearing and pleadings, the court credits the affidavit of special credits, though this is actually interesting before we go to ASAP. Credits the special affidavit of Special Prosecutor Hank Brennan, paragraph 6. Quote, Attorney Jackson expressed concern that the materials may longer exist on the NVR, given the time that had passed since the event. I agreed with him and told him that I had no knowledge whether the material still existed or were overwritten given the passage of time. In light of that averment by ADA Brennan, and in light of Attorney Jackson's acknowledgement during the hearing that he and ADA Brennan discussed his concerns regarding the likelihood of the video still existing, the motion to recover cost is denied. Further, though Attorney Jackson argued for sanctions for the alleged violation of Mass Rule 14, there is nothing in the written pleading that raises this argument, and therefore the issue is not currently before the court. Order defendant's motion to recover expenses denied.
Yeah, so you have to wonder too. I mean, 12,000 is 12,000, but in the big scheme of things, it's a soda. in terms of the defense costs in this case, and now that there's a second trial, especially. I wonder if, to some degree, AJ was using it as a platform to get out there all of the alleged abuses and misconduct that he says has been perpetrated on the defense by the prosecution.
And he did so. And he did so brilliantly.
He sure did. And so there's always a motive. There's always so if it was a loss, probably well worth it, right?
Right, exactly. And also, since it wasn't before the court, the issue of the violation, it allows him to bring the motion now again, because she says, well, that what you just argued wasn't before the court, right? And we were saying that he worked his way into it. So
yeah,
I mean, it's really not.
I think it's going to be all part of the motion to dismiss.
Yeah,
all of that.
All that part of motion to dismiss. Now let's go back to ASAP because
hold on. B. Castro is asking, and this relates to that. Would a directing verdict motion happen before the defense presents their case? Yes. That's the time at which, and what happens in court, and it won't be in this case because we think the way they're going to do it is they're going to meet and have it handled before the jury gets into place. But if the jury's in the box and you finish your last witness, Mr. Prosecutor, the defense would say, Your Honor, we have a matter of law in motion. And then they would excuse the jury. Then they would, bring the motion for directed verdict and whatever else they may come up with. They want to do that because I guess they're going to be there late tomorrow.
Yeah, well, I'm trying to see if the judge said anything about, because we kind of we're assuming that that's going to start at 10 o'clock, and maybe that's why he wants to start court at 10, and maybe the jury is still coming in 10:30. He figures the motion, and that would give a hint that he's going to deny it if he's having the jury come in right after that. Right?
Yeah, you would think. And is a half an hour enough? I wouldn't think so, really, because it's going to be pretty beefy motion by JT, and then Lewin. It could be full-throated, and then Lewin is always full of something, and so that could take a while for his response to the motion. So half an hour, I think, is being optimistic if that's the judge's thinking.
Oh, let me thank you, Touche. What did $5? What did you think of the? Thank you so much. What did you think of the arguments? I thought she was taking it under advisement and didn't rule today. Well, go ahead. She took it under advisement.
Yep. The funny thing about that, and again, she ruled from the bench in that bench trial, but this is different. All these motions, it's almost like the court either wants to take a breath and genuinely thinks I need a moment to think about this, or they just don't have the guts to do it in front of the parties. And I've seen judges that I could go either way with them. Some of them, their personality is just not to do it. Others, their personality is like, I'm doing it in your face. I don't care. I'm the judge. I think she's more the opposite, where she just would rather not throw it out there. So what does she do?
Well, but I think
she wait an hour?
I don't think she wants. Yeah, right, exactly. If this, we're on the air. I mean, quite frankly, she knew what she was going to do.
Of course. So she didn't have the guts to say
it. She wanted to put in writing that it wasn't raised, and therefore, I'm going to this. But to credit, here's what if you're the defense, here's what bothers you. She credited the affidavit of Brennan. Okay. She credited the affidavit of Brennan. You and I were saying, he should, after all this, he should remove himself from the case because he got lied to, we think. But instead, she says, well, I credited his affidavit. So that's going to be worrisome for the defense.
Yeah, I think, she's in a weird spot with Brennan because he did step into this mess and he inherited the whole thing. And he, to his credit, has said, this is my case now. I know things happened before I got here. That's now on me. I think she may give him a break as a result of that. And that's just a gut feeling that maybe she feels like this guy has stepped into a pile of shit, and however he has to deal with it, he has to deal with it. But this is a pretty small victory for them, really. 12,000. Come on.
Well, but when you're a defense, and when we've all been to trying cases, when you keep adding in the 12,000s here and there, and you have experts, and you have to have hearings on them, and you have to have trials on them. Your client doesn't have $400,000 or $500,000 for experts unless there's some of my clients who did have them, right? But she's not in that league. It's this is a lot, and the attorneys have to keep flying back and forth from California.
Well, she probably pay as much for the argument to get the 12 back as the 12. You know what I mean?
This is true.
It probably costs $5-6 grand easy to gather everything needed, the preparation of the motion, the attendance, all of that.
Right. Kay doesn't know why she's so bent over on the Karen Reed case. You think she just hates the lawyers? No, I don't think she hates the lawyers. I just think that maybe she thinks she's guilty. I don't know. What do you think?
Yeah, I don't know. That's not her job, but it shouldn't enter into any of her decisions. It shouldn't.
Yeah, well, I don't, I just, here comes drama. On the other hand, here comes drama. Like Judge Arnold, he's in your face. Stop it, Mr. Lewin.
He
Stop
is,
it.
but he's like, he's like the parent or the teacher that says, one more time, I'm telling you, one more time, but then it never, whatever that thing is, that never comes. It's just always stop it. Maybe because he figures, the days are numbered that he's gonna have to deal with this douche, and when that's over, it's over. So, but
Yeah.
there's not a lot of weight anymore behind his threats.
Yeah, I assume that I can't find it quickly, but I assume the directed verdict motion is on for 10 o'clock their time, which would be 1 o'clock our time tomorrow, right?
Yeah, I think
I'm
that's
assuming
a good guess.
Yeah, I'll be just barely getting back by then. I have an 11 o'clock appointment, so I'll be barely getting back to listen to it as I do my other work and get sucked into the no squabble zone.
That's right. I think tomorrow's going to be lots of squabble.
Actually, that's a great name for a show. There we go. We're flashing it. The no squabble zone, right? We're in the no squabble zone.
Okay.
Yeah, and I Jenny likes in terms of ASAP Rocky today, like the partner that was the partner of Joe Tacopina. He did a very nice job. I thought he did a lovely job. I mean, I would have handled just a little differently, but I understand where they were going, and he got what he needed. He got what he needed. Jenny says, by the way, that's 6 p.m. Irish time. We forget that. Oh my gosh. We all be covering the Melly case out of Broward County. Probably that's going in September, I think. Somewhere in there, we're going to have to take a little vacation. I know Michael has to go to Portugal, so we'll have to work that out. But we have a lot of guest hosts that will come into when we do coverage at this.
Yeah, when is that case again? When did they push that?
I think September. I think they moved it to September.
Okay, that's not a bad time to be down there.
And that's no, because I know you want to be in Florida. I know we have so many cases we have to cover now. Hey, you may have to go. Our correspondent on the road.
Yes.
You may have to go to Georgia, and then from Georgia hit
we'll have to check out the Doug case and see if that's on the radar of those that I'm not schlepping.
Apparently it is. I think Miss Dizzy sent us a link, and apparently it's been a bunch of our long crime is on it. All right.
Oh, okay. All right.
So
and what about Miss Sylvia? She might be on. She might be on it.
Yeah, I'd love to meet her though. She's
she's
fabulous.
a trip. Yeah,
she sounds just fabulous. So
she's a little camera shy.
She's camera shy.
A little bit.
My goodness.
A little bit.
Yeah. August is Doug. So okay, so you have 228 of you here. I think we'll keep running replays so that the channel stays up and you all can talk, and then we'll be back tomorrow. We try to come back at lunchtime if we can when they break for lunch. Now it'd be interesting tomorrow though. We don't know what's going to happen. Are they going to just do directed verdict?
I think your gut feeling is probably pretty telling that the judge would not have this bam, bam, bam schedule if there was a chance. I mean, it's not like he's going to learn anything new in this directed verdict motion. He's kind of been there the whole time.
Right.
So if he thought it could be heard in a half an hour and the jury in place, it's got to be because he ain't leaning toward granting it. And if that's true, then it'll just grind along with whatever the defense case happens to be. Maybe Joe's got a couple of witnesses in addition to Wally taken out of order, or maybe not. Maybe he's got nobody.
Yeah. So, it'll be interesting. But if I were Joe, I'm making all my arguments tomorrow with that camera present.
Oh yeah.
And
then what could happen is they could call it for the jury, right? If the defense rests and there is no rebuttal case. I can't imagine. Can you imagine a prosecution rebuttal case? What can you imagine anything that would help them? I just can't. So I'm assuming no rebuttal case, and then maybe the judge kicks the jury loose and they do work on jury instructions or something for the rest of the Friday.
Right. Because remember they said 2 weeks for the trial, and we are in our what are we?
This is day. Is today 8 or 9?
Yeah, day 9. Is it 9? Isn't it
so
9?
This is two weeks tomorrow.
Yeah, 2 weeks. Yeah, 2 weeks tomorrow. Should Rocky testify? No.
Oh my God.
No reason to. Absolutely no reason to. 12V and Levin are on the list for tomorrow, Jenny says.
What's it say? What was that?
12V and Levin are on the list for tomorrow. They're calling the state's calling 12V and Levin. Well, that'd be interesting if they do. Let's see. Let's see. Let's see. But I thought he's doing directed verdict arguments tomorrow at some point. So unless the defense is calling. See, the problem is that Michael and I, we have to count on you to tell us this, because when we're doing our regular
We
log
jumped
stuff,
off.
sometimes
Yeah.
we jumped off and we had to get some work done today, so we didn't hear. And then we jumped off with Doug, so we didn't hear really that interplay as to who was being called. But we'll have it for you by tomorrow, and of course tomorrow night we're gonna have a show. So no defense, no defense. Is that Jenny saying there was? Did he announce there was no defense or not? I mean, you're telling us. They've already called the defense. Remember, the state rested today,
Wally
so they
would
did
be it.
rest.
Okay.
The state rested today, so they got to be doing directed verdict motions tomorrow morning. And so I mean, unless Joe is going to call, except for Wally, unless Joe's going to call some witnesses, then the case ends pretty much tomorrow.
Yep, one way or the other. And again, they'd prep for closings.
Jenny says the defense is calling them, or so they say.
Defense is calling whom again?
12V and Lewin, and the other two people at the thing. So that'd be interesting. That'd be really interesting. That could be a real interesting time if Lewin was there and didn't want to be questioned by the state. Remember a couple weeks ago. So I can't wait to see what happens tomorrow. Usually Fridays are pretty dull, right? Not in this case. Not tomorrow. Marie defense is calling 12V and Lou Lewin. Okay.
All right.
All right.
That'll be fun.
Well,
so we don't want to
fun.
commit Missy to running anything on here once we sign off. So
Then
I don't know. I don't know if it's going to happen or not.
No, I don't know if it's going to happen or not either.
Let's call it. Let's call it.
Right. Okay, so we're going to call it. Let you go home. Let you rest for the night, especially all people overseas. And then we will see. We are going to be streaming tomorrow. Oh, well, wait. I see something. What is that? She's sleepy. Missy is sleepy. Oh, wait a second. Let's just, before we call, Lewin had a hissy fit. Wanting to know on the record who they were called. He had a hissy fit. We missed it. Thank you all.
I know.
Well, thank you all, Justice TV, everyone. Just, share. Missy will post a link for our live tomorrow. We will be streaming it. Thank you, Missy and Dizzy, who've kept
and Dizzy
us
go to
going.
bed.
And Dizzy go to bed. Yes, we love you all too. And we will see you tomorrow, probably around lunchtime. Michael may be on before I get back, but
yeah, we'll be in the area. But until then, I'm Michael Bryant. Try to do the right thing.
I'm Linda Kenny Bodden. Together we are Justice Serve TV. And please subscribe, like, share, and you'll get notified.